ಸೀನಿಯಾರಿಟಿ ಅಂತ ಹಾಕ್ತಾರ, ಬರೋದೇ ಇಲ್ಲ ಅವು. ಅಲ್ಲಿ ಸರ್ ಒಂದು ತಾರೋ ಇದೆ ಸರ್, ಕೊಡ್ಲ ಮೆಮೋ ಹಾಕ್ತಾರೆ ಪೆಂಡಿಂಗ್ ಅಲ್ಲಿ. ಏನಪ್ಪ ಇಲ್ಲಿ 14 ಮೂವ್ ಮಾಡಿ ಬರ್ತೀನಿ ಅಲ್ಲಿಗೆ. ಹಾ ಓಕೆ. ಕಾಫಿ ಸರ್ವ್ ಮಾಡ್ಬೇಕಂತೆ ಅವನ.
ಒಂದು ಕಡಿಮೆ ಕೇಳಿದರೆ ಅದೊಂದು ಸ್ವಲ್ಪ ಕಡಿಮೆ ಆಗ್ಬೋದು.
ನಮ್ ಲಾಯರ್ಗಳು ಹಂಗೆ ಮಾಡ್ತಾರೆ ಹೇಳಪ್ಪ. ನಿಮ್ ಕಡೆಯಿಂದ ಹೇಳ್ತಿದಾರೆ ಸುಮ್ಮನೆ, ಇಲ್ಲಿ ಹೇಳ್ತಿರ್ತಾರೆ ಅಲ್ಕೋ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಕೊಂತಾರೆ.
ಸರ್ ನಿಮ್ದು ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಎಲ್ಲ ಕೇಳ್ತಾ ಇದೆ ನೀವು ಮಾತಾಡೋದು.
ಹೇಳ್ಕೊಡ್ತೀವಿ ಸರ್. ಟೆಸ್ಟ್ ಮಾಡೋದಲ್ಲ ಮೇಡಮ್.
Regarding office note maintainability is there. Office is not listing.
They'll all come on Monday. Give it. Office along with council submission Monday ಹೇಳಿದ್ದೀನಿ. ಎಲ್ಲ give all the memos. No 230. Yes. Give all the memos. File contempt. Yes. No problem. Yes. Interim order is already there.
So Lordship.
Advance matter for what, sir? Police protection.
The Lordship kindly one.
ಅಲ್ಲಿ ಕೇಳ್ತಾ ಇಲ್ವಾ? ಇರೋದು ಎರಡೇ. Yes.
Even after advancing the matter, after taking the record of the police protection application, the trial court adjourned the matter to 19.
No problem. Monday ಕೊಡಿ ಸರ್. ಫ್ರೆಶ್ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್. ಇಂಜಂಕ್ಷನ್ ಇದೆ ಅಲ್ವಾ? ಇಂಜಂಕ್ಷನ್ ಇದೆ ತಾನೆ?
There is an injunction, in spite of that, changing the nature, the interim order will become infructuous.
You complain to that court, sir. No. Monday ಕೊಡಿ.
So Lordship.
1 minute. Wherever vacating stay applications ಎಲ್ಲ ಕೊಡಿ. Give all the vacating stay applications.
With your Lordship kindly, one tax matter last week also moved, but it not posted. Tomorrow, my lord.
Vacating stay, please give.
It's a tax
Vacating
matter.
stay, please give the applicant. Don't make any mention about vacating stay, please give.
My lordship, it's a tax matter, my lordship.
Give it, sir. ಎಲ್ಲ ಮೆಮೋಸ್ ಕೊಡಿ.
My lord.
One submission, my lord.
ಕೊಡಿ ಸರ್.
Put up, sir.
Vacating stay.
Now give all the memos.
Vacating stay.
It will come, sir. Give it. Kodi. Tomorrow it will come. Give it.
May seek my lord's indulgence.
My matter is listed on Tuesday before.
Give it. Tomorrow. Being spoken to. ಅಯ್ಯೇ ಹಾಕಿದ್ದೀರಾ? ಅಯ್ಯೇ ಹಾಕಿದ್ದೀರಾ? ಹಾ ಸರ್.
My lords, ಇದು my lords, this is.
ಕೊಡಿ ಎಲ್ಲ. ಯಾಕೆ? Why are you waiting? 2:30 I am not taking anything. Give it.
Lordship, it's a tax matter, my lordship.
ಟ್ಯಾಕ್ಸ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. ಕೊಡಿ ಸರ್. ಇಟ್ ವಿಲ್ ಕಮ್ ಸರ್. ಮೇಡಮ್ ನಾಳೆ ಸ್ಟೇ ಇಲ್ಲ, ನಾಳೆ ಹಾಕಿ. ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್ ಅದು ಪೆಂಡಿಂಗ್ ಮಾಡಿ.
My lords,
I'll hear you. Wait. Yes. Give all the memos, sir. ಏನಾದ್ರು ಕಾರ ಕೊಡಿ memos. Give all the memos. No problem. Why I told give all the memos. Can't give it. Yes.
My lords, may I be indulged?
Also, I made a mentioning. Today the matter is posted for orders in the trial court. Today 2:30 the matter will be.
Trial court.
Today they have posted for orders on IA number 4 also.
What were you doing till now?
Yesterday also I moved a memo.
No. What were you doing till yesterday? When was the order passed? When was the order passed?
Why? Because defendant number 6 has come to include this order also be adjudicated in this.
Correct, sir. When was that done?
On 7th.
7th of which month?
This month.
2:30 third.
my lords,
Give, sir. Give. If you want to give the memos. I'll call the cases otherwise. Don't waste time like
lords,
this. Give it.
lordship,
Yes.
one
Give it, sir. No date, nothing.
My lords, I'm appearing from
Give it,
Mumbai.
give it. VC, wait, sir. Please wait. Yes. Where? It will come on 20th only. Give it. We'll see. Give it. Yes. No problem. Yes, sir. Why are you waiting? Still give the memo.
my lords, disposed of
Wait. Give the memo. Give it, sir. Anything. ಕೊಡಿ. ಮೆಮೊ ಕೊಡಿ ಅಂದ್ರೆ ಗೊತ್ತಾಗಲ್ವಾ? ಕೊಡಿ.
let's see the
ಕೊಡಿ. ನಾಳೆಗಾಗಲ್ಲ ಕೊಡಿ.
My lordship,
ನಾಳೆಗಾಗಲ್ಲ. ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ? ಎಕ್ಸಿಕ್ಯೂಟ್ ಆಗೋಗ್ಬಿಡುತ್ತಾ 16th? ಮಂಡೇ ಕೊಡಿ ಸರ್.
lords, this is that disposed of matter, my lords. Kanpur matter where my lords had directed.
What happened?
The money came to the bank's account, the court's account only on the 7th. They're telling inna time ಬೇಕು ನಮಗೆ, ಇಲ್ಲಿ audit head ಅಲ್ಲಿ audit head ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡ್ಬಿಟ್ಟು ಅಲ್ಲಿಂದ ಇದು ಮಾಡಬೇಕು. We procured the details of the accounts in Kanpur, but they're still, it is not still not transferred.
ನಾಳೆ ಕೊಡಿ.
Threat of demolition BDA matter kindly have tomorrow.
Threat of demolition of why, sir? ಏನ್ threat of demolition?
The BDA official will come to demolish our building.
Notice ಕೊಟ್ಟಿದ್ದಾರೆ.
Encroach ಆಗಿದೆ.
ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
Earlier notice ಕೊಟ್ಟಿದ್ರು pending matter.
ಯಾವಾಗ ಕೊಟ್ಟಿದ್ರು?
In the year 2024 December. Pending matter.
Interim order ಇಲ್ವಾ?
Interim order ಇಲ್ಲ. That's why tomorrow.
ಆಯ್ತು, ನಾಳೆ ಕೊಡಿ.
Pending.
Now tell me. Yesterday you moved a matter. What happened? Not listed?
Not listed, my lord.
Give it. Which is that? Tax matter? Tax or what?
My petitioner, my client has been suspended, my lord.
Suspend? Which club?
NIPM.
Oh, NIP. Oh, give it. 2:30. Fresh matter? 2:30. Yes. Give it, sir.
Listening tomorrow. Short question, other side is
You are also suspended?
No, my lord.
Then give it.
Tomorrow other side is also going to take 5 minutes of my lord.
No, sir. Fresh matter?
Pending matter. My lord had directed the trial court to
No,
test.
sir.
They will listen next.
There is an interim order already?
My lord, I'm for the respondent, my lord.
Oh, then give it. Yes.
Tomorrow.
Not tomorrow. On Wednesday 20th, give it.
Wednesday.
No problem, sir. Give it. Godi, sir. Memo. Memo. Give the memos. Yella memo kodi. Why are you? I am not taking at 2:30 unless heavens are falling. Give it. No, tomorrow also. Give it. GMC tax matter will come tomorrow. Give it. Kodi, sir. ಏನ್ ಡೆಲಿವರಿ ವಾರಂಟ್ ನಾಳೆಗೇನು ಡೆಲಿವರಿ ಆಗಲ್ಲ. ನಥಿಂಗ್ ಮಂಡೇ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಇದ್ರೆ ಮಂಡೇ ಬರುತ್ತೆ ಸೀನಿಯಾರಿಟಿ. ಎಸ್ ಲಾರ್ಡ್ಶಿಪ್.
Fresh tax matter, my lord.
Give it.
Getting listed under B group.
ಫ್ರೆಶ್ ಟ್ಯಾಕ್ಸ್ ಮ್ಯಾಟರ್ ಹೌ ಕ್ಯಾನ್ ಇಟ್ ಗೋ ಟು ಬಿ ಗ್ರೂಪ್ ಸರ್?
That's what.
ನೋ ಸರ್, ನೋಟಿಸ್ ಆಗಿದೆ ಅದ್ರಲ್ಲಿ ಅಷ್ಟೇ. ಕೊಡಿ. ಏನೇನು ಹೇಳ್ಬೇಡಿ. Give it. Yes. Please give all the memos. Please give all the memos, no submissions.
lordship, it's a tax matter, my lordship.
Will you give the memo or not? When? Yesterday it was posted. We'll take it on Monday, don't worry.
My lordship, it's a tax matter, my lordship. My bank account has
Give
been
it, sir.
attacked.
Give all the memos.
It was listed on last week, my lordship. It may be.
May give it.
My lord, tax matter, my lord.
I will not hear any mentioning. Please give all the memos.
My lord, this honorable court had directed for
Give the memos.
for provisional release, my lord. Even the division bench had granted a provisional release.
What's the problem now?
Arekanat matter, my lord. It's a perishable
ಕೊಡಿ ಅದು. ಅದು ಅರೆಕನೆಕ್ಟ್ ಮಾಡಿ. Take it for tax matter.
tax matter, my lord.
ನಾಳೆ ತಗೊಳ್ಳಿ.
Please, sir.
Why? Oh. Argue the matter. Monday. ಏನಾಗಲ್ಲ ಕೊಡಿ. ಆರ್ಗ್ಯುಮೆಂಟ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ 617 ಹಾಕಿದ್ರೆ ಡಿಸ್ಮಿಸ್ ಆಗ್ಬೇಕಾಗಿ. ಮತ್ತೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಏನಕ್ಕೆ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? No problem.
LAC matter, my lords. Respondents are interfering despite interim order by this honorable court.
What matter is that?
LAC matter, my lords.
Tuesday. Yes.
Please, I'm ready.
One submission.
Give it.
I filed vacating
Please
stay
give the memo.
GMCPC, my lords.
Vacating
The
stay
entire
ಇದ್ರೆ
development has been stopped, my lords.
Vacating stay ಇದ್ರೆ ಕೊಡಿ. Yes. ಯಾವ್ದು ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ? ಕೊಡಿ ಸರ್. No tomorrow. No tomorrow. No tomorrow. Give it. It will come. Give it. I can't take 500 matters on Monday, sir. I will take whatever is. I will. No problem, sir. I will take whatever is possible. Give it. Please. ಕೊಡ್ತೀರಾ ಇಲ್ವಾ ಮೆಮೋನ? ಕೊಡಿ. I told you I will take it. ನಿಮ್ಗಿಂತ ಮುಂಚೆ ಕೊಟ್ಟಿರೋರು 500 ಜನ ಇದ್ದಾರೆ. ಅದೇನ್ ಮಾಡ್ಲಿ? ಅದು ತಗೊಳ್ಳೋದು ಬೇಡವಾ? They have filed 10 memos. Should I not take that? Give it. ಬೇರೆ ಅಡ್ವೊಕೇಟ್ಸ್ ಕೊಟ್ಟಿರೋದು ಮೆಮೋನೆ. ಅವ್ರಿಗೂ ಅರ್ಜೆನ್ಸಿ ಅಂತಾನೆ ಕೊಟ್ಟಿರೋದು. ನಿಮ್ದೇನು ಪ್ರೆಸಿಡೆನ್ಸ್? ಮತ್ತೆ ಕೊಡಿ. Please give all the memos. If you want to give the memos. Call the cases. Yes. Please give all the memos. Whatever it is, give the memos. Give it, sir. We will list it on designated days according to my capacity.
Yes, ma'am. Yes. Just that I wanted to do.
Give it, sir.
Seeking an adjournment.
ಕೊಡಿ. Adjournment ಬೆಳಗ್ಗೆ. Don't waste time further.
List 2.
Nothing doing.
Tax matters.
All tax matters today that are listed are not my date given matters. It is previous bench. All will be listed on 21st or 28th.
Stay may be
or
extended.
4th. Wherever interim order is there, they will get extended.
4th.
ಯಾಕೆ ಸರ್? ಕೊಡಿ. ನಾಳೆ.
Can I mention the numbers?
KPCL versus NCPC order to be listed today, Manor.
That will still wait. Tax matters 21st, 28th, 4th. All 3 days it will come. These are not date given by me at all.
Stay may be extended.
That will be. All second list, please don't wait. Tax matters, nobody wait.
Tax fresh matters, my lords, have just given the
Memo ಕೊಟ್ಟಿದ್ರೆ ಆಯ್ತು. ಯಾಕೆ ಮೆನ್ಷನ್ ಮಾಡಿ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡ್ತಾರೆ? ಮೆಮೊ ಕೊಟ್ಟಿದ್ರಲ್ಲ. If you cooperate in the morning, it will be all right. Otherwise, whole day.
I understand.
Gets loss ಯಾರಿಗೆ? ನಿಮಗೆ ಆಗುತ್ತೆ.
policy memo.
ಹಾಕ್ಬಿಡಿ. The tax matter entire list will be repeated on 4th. Interim orders ಎಲ್ಲಿದೆ that will continue. All 4th, yes. No, madam. All on 4th. There are already 100 matters on each day. Yes. ಎಷ್ಟಿದೆ ಅದಕ್ಕೆ? 80 matters. Distribute now. Next time ಬರ್ತಾವೆ. Distribute amongst all. Madam. Yes.
This
Orders?
ಬಿಡಿಯೇ ಎಲ್ಲೇ ಬಿಡಿಯೇ ಲ್ಯಾಂಡ್ ಎಕ್ವಿಸಿಷನ್ ವಿಲ್ ಸಿ ಕೊಡಿ ಟುಡೇ ಇಟ್ಸ್ ಅ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ರೈಟ್ ಆಕ್ಷನ್ ಯಾವತ್ತಿದೆ ಆಯ್ತು ನಾಳೆ ತಗೊಳ್ಳಿ
Actually, this is NCPC matter. Order to be listed today.
But
any date may be.
ನಾಳೆ ಹಾಕೋಣ.
I'm the land acquisition matter.
Additional Solicitor General.
Railway construction, line construction.
ಅದು ಕೊಡಿ.
These 2 days.
ಅದು ಟ್ಯೂಸ್ಡೇ.
Public.
Yes.
Orders list.
ಯಾವ್ದು ಸರ್?
Loda committee.
ಅದ್ರಲ್ಲಿ ಯಾವ್ದು ರಿಸರ್ವ್ ಆಗಿದೆಯಲ್ಲ ಅದು?
One matter, my lord, your lordship had given a date ಅಲ್ಲಿ ಗೊತ್ತಿಲ್ಲ. Any date next.
ಹಾಗಾದ್ರೆ 23rd.
Any date.
Yes, good. Yes.
Seal number 1.
My lords, may I please mention a matter?
One minute, wait. Who is this?
My name is Dhruv Sanghvi. I'm appearing from the Netherlands, actually. I'm
Netherlands.
Right.
Why?
That's right.
Which matter?
It's Mobicom Technologies, my lords. In this matter, notice was issued. We've challenged the constitutional validity of the angel tax, which has been levied on our client, Mobicom.
Is it listed today, or you're
It's
moving
not
it for listing?
We want to get it listed. We've moved memos.
It's a pending matter, right?
It's a pending matter, Your Honors.
It will come 20.
My lords, if you please indulge me for 1 minute. I won't take more than 1 minute of your time.
Listen to me. Tomorrow it's not possible. 21st or 28th it will get listed. Give the number.
I am actually in India till the 26th. If it can be kept on the 21st, I will fly down to Bangalore to argue the case.
No, don't fly down for that. We'll keep it on 28th. Yes.
I'm not in the country, my lord. I'm again out of the country. So if my lords could please keep it on the 21st, I will fly down for this.
Give
Because
the number.
the simple point, Your Honor, my lord.
Constitutional validity and simple point.
No, the simple point I want to place before my lords for taking this matter on urgency basis is simply that it was a 1 crore rupee investment made in my company, and they've taken away 30 lakhs of it. I am in need of working capital.
Give the memo, sir. Give the number. Yes.
The number is writ petition number 27,368 of 2024. Notice was issued on the 3rd of December, my lord.
No problem. Yes.
I'd be very grateful if it could. If it
21st, yes.
Much obliged, my lord.
Yes.
Order seal number 1.
Infructuous, why? Ashtala. Learned counsel for the respondent has filed a memo seeking disposal of the petition as having become infructuous in the light of the fact that the proceedings out of which the present petition emanates itself is disposed. In that light, petition is disposed as having become infructuous. Next.
Seal number 2.
Appear for the petitioner. So take steps to the respondent number 2 and clear concern. Please.
My lord, seal number 2, I'm appearing for the respondent, for the petitioner, my lords. I think there's some confusion here.
Seal number 2?
Yes,
that's list number 2. List number 2, seal number 2. I'm so sorry.
No, don't get into list number 2, sir. I'm in 1 still.
That's in this matter. Contempt is pending. Lords, 19th, the date has been given.
My lords,
that is after 19th, any date may be given. Lords, what has happened? Interim order has been granted in this, lords, in this writ petition, not to disperse the compensation so far as fifth respondent is concerned. Lords, that fact has been suppressed. The very same council has filed the wakalat on 18/7/2024. Lords, so now the contempt petition has been filed, lords, against the state. Lords, already the assistant commissioner has, lords, dispersed the compensation amount, even though, lords, the interim order is
in which is an interim order here?
That fact has been suppressed. Intentionally, the amount has been released. Now, minutes are brought to the notice of the division bench in the contempt proceedings. 19th date has been given. That's kindly
I want to make some submissions after my learned friend.
Who has filed contempt?
Let's the
I have filed. I have
respondent.
That is why.
First respondent and other.
ಒಂದು ನಿಮಿಷ ಇದ್ರೆ. Yes.
My lords,
why did you file contempt?
My lords, there was a direction by this honorable court.
Page.
My lords, in my statement of objections, my lords were to look at page 21, annexure R7, my lords.
ಹಾಕಿದ್ದೀರಾ objection?
Yes, my lords, I have filed.
Yesterday ಹಾಕಿರೋ put up ಆಗಿರೋದು.
My lords, can I just?
ಎಲ್ಲ ಹಾಕಿದ್ದೀರಾ?
My lords, I'm very sorry, my lords. My lords, I'll just pass it. I'm very sorry, my lords. Please, come. R7, page 21, my lords. My lords, the operative portion, my lords, will find at page 25. My lords, there are 3 petitions. Sorry.
So representation was directed to be considered. All right.
Yes, my lords. My lords,
1 minute.
Sorry, my lords.
Within a period of 2 weeks from today, and upon receipt of information, direct for respondent number 4 to consider the petitioner's claim for disbursal of compensation in acquired land in 3 months.
Yes.
All right.
This was not done. I filed contempt.
What was not done?
My lords, the genuinity certificate by the Tahsildar was not given. Thereafter, my lords, compensation was not filed. I filed all the three petitioners filed contempt petition. My lords, contempt
Now,
petition
who
order
is-
sheet is produced, my
one
lord, at
moment,
page 27.
One moment. Who is the present petitioner?
My lords, the present petitioner, my lords, is my second cousin. I have a grant in my favor. After I get a grant in my
What
favor,
is the suit pending?
suit is for partition, filed by him.
When?
My lord,
23.
Prior to acquisition, post acquisition?
post acquisition. Post acquisition and my lord,
Post acquisition, final notification or compensation?
post final notification also, post this judgment, post me filing the contempt petition also. I filed the contempt.
ಈಗ partition ಹಾಕಿರೋದಾ?
My lords, my lords,
This is 18th November 2023 is the order.
Yes, my lords.
When did you file contempt?
My lords, I filed contempt, my lords, in 2024, my lords. My lords, I'll give the exact date, my lords.
2024. When was
9th February 2024, my
When was
lords.
the suit filed?
Suit, my lords, I think was filed in December 24, my lords.
23.
December 23, December 23,
2023.
2023,
After the judgment on 18th November 23.
after my. Now, my
Yes,
lords,
sir. ಯಾಕೆ ಮುಂಚೆನೆ ಹಾಕ್ಲಿಲ್ಲ? ಕಾಂಪನ್ಸೇಷನ್ ಗೊತ್ತಾದ್ಮೇಲೆ ಹಾಕಿದ್ದೀವಿ.
No, minutes. In fact, minutes 23 revenue records, the state commissioner has passed an order minutes to effect the revenue records in the name of the first respondent. He is none other than my brother. Minutes on behalf of the joint family, the land was granted. Minutes subsequently, minutes.
Where is the grant order?
Grant order, minutes the. Minute annexure R2. Their objections, minutes.
ಯಾಕೆ ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ವಾ?
They have also minutes 86 the land has been.
ನೀವು ಯಾಕೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ?
But it's now we have also minutes the contention is minutes we have also
I
produced.
have asked a simple question.
minutes.
Why you did not produce your own grant order?
Minutes we have also produced. That's annexure C.
Now joint family property ಅಂತ ಎಲ್ಲಿದೆ?
Yes, minute annexure C. We have
Name of the
produced
grant. 1 minute, sir. Name of the grantee, page 15. Where is Chikanna?
Minutes he is none other than.
None other bidi, sir.
Minutes
Now,
my father and this first respondent father, they are the brothers.
1 minute.
That's-
One moment.
Family tree has been produced minutes along with.
Now,
my
Venkat
petition.
Lakshmamma,
Minutes
Narayan
after
Swami,
we-
one ನಿಮಿಷ. Venkat Lakshmamma, Narayan Swami, Chikanna are petitioners. Grant order ನಿಮ್ಮ ಹೆಸರು ತೋರಿಸ್ಬಿಡಿ.
Minutes grant is ensured to the benefit of the first.
ಎಲ್ಲಿದೆ?
joint family members.
Where is that? Where
Minutes
is
it is. Minutes kindly 86 it's a land.
ಹೌದು,
has been
correct, sir.
granted
ಎಲ್ಲಿದೆ?
in the
Names.
name of the first respondent.
Which first respondent?
Let's say the Muniappa, that is the first respondent.
Muniappa.
Another than.
ಒಂದ್ ನಿಮಿಷ ಸರ್.
Please. Let's.
None other than ಬಿಡಿ, ಅದ್ ಬಿಟ್ಟು ಬೇರೆ ಹೇಳಿ.
Genealogical tree, Malek kindly.
ಒಂದೇ
Page
ನಿಮಿಷ.
25 minutes.
Grant order 1986.
Yes, minutes.
ಅದರಲ್ಲಿ
Ravi, yes.
ಒಂದ್ ನಿಮಿಷ.
He is the elder person in the entire family. Please.
ದೇವನಹಳ್ಳಿ ಪ್ರಾಬ್ಲಮ್
Yes, minutes.
ಅದಕ್ಕೆ ಇದೆಲ್ಲ. Yes. In favor of Venkamma, Papanna and Muniappa. 1977 grant ಆಗಿತ್ತಾ?
86.
Come to reference number 2.
But finally, not Sagoli.
Reference number 2. ಹೇಳಿದ್ದನ್ನು ಕೇಳೋದೇ ಇಲ್ವಲ್ಲ? I'll adjourn it by 8 weeks.
So that's one sir.
Yes.
1986 minutes, page 27.
Come to page 14. What is it in reference number 2?
Page 14 in my writ petition.
Objection.
No, sir. My statement of objection, sir.
Grant orderly reference number 2 notice. Who is this?
Yes.
Report is survey number 1 in so and so village in favor of Venkamma, Papanna, Muniappa.
Venktam and Papanna don't make consent to us. Only in so far as Muniappa is concerned.
Who is Muniappa?
Muniappa, he is none other than my uncle's son. Family tree, let's kindly.
ಅದು ಆ ಜಿಯೋ 1977 ಅವರು ಗ್ರಾಂಟ್ ಆಗಿತ್ತಾ? ನೀವು ಸ್ವಲ್ಪ ಸುಮ್ಮನೆ. 1977 Muniappa had been granted.
Muniappa and two others.
Two others are not concerned with this land.
My lords, they are concerned with this land.
All right. Now tell me, K. Muniappa, Venkamma, Papanna ಅವ್ರಿಗೆ ಗ್ರಾಂಟ್ ಆಗಿತ್ತು. ಹೌದಾ? ಆಮೇಲೆ this is re-granted in favor of these 3 people. Page 15.
My lords, yes, same people. I mean, it is divided, my lords will see.
4 acres, 4 acres,
4 acres, it is divided.
Now, this Muniappa here, H.M. Muniappa, son of Mallappa, all right.
My lords,
Is this granted for the purpose of the family?
No, my lords, it is not. And I say so,
Individual grant?
Individual grant. Because initially it was Goma land, I was cultivating it, I applied for grant, Sagoli is granted in favor of 3 people together. Initially 3 people. All the 3 people, genuinity is again doubted at the time of acquisition. The government claims no, it's government land. All 3 of us file a writ petition before this honorable court.
That is just Ravi Osmani.
Yes, that is the order. All 3 of us file a writ petition. Writ petition direction is given. Direction is not complied. Tahsildar, then my lords, we file contempt. In the contempt, Tahsildar comes and confirms that the grant is only in favor of these 3 persons. RTC, everything is showing only my name. Now, my lords, if my lords one is claiming co-parcenary, there should be a common prospectus. Now the grant is in my name, not in my father's name. He's not even my father's brother's brother, son's son. So my lords, there are 3 levels else, sir? There are 3 degrees of
submission. Kindly see genealogical tree minutes. I have produced.
Grant is not for the family, sir. It is Muniappa's grant.
No, minutes. Grant is for the benefit of the family. Muniappa is none other than the brother, elder brother.
Ee relationship gottagiddu compensation determine admele.
Let's revenue records have been transferred in the year 2023 and Assistant Commissioner minutes Annexure C. Minutes kindly recently the order has been passed. Minutes Annexure D.
Earlier revenue records ellide.
No, no revenue records. Annexure D minutes page 59 in my writ petition.
ಎಷ್ಟು crores ಬಂದಿದೆ compensation ಈಗ?
4 minutes almost 5 crores.
4 crores and change. And my lord, my sisters, there are sisters of this person. He has not made sisters party.
Minutes Annexure C 27/3/2023 minutes the order has been passed by the Assistant Commissioner to effect the revenue records in the name of this first respondent. Then minutes he has started receiving the compensation. Immediately suit came to be filed. Minutes we are all in giant family. Suit minutes the application has been filed minutes not to disperse the compensation. Then minutes immediately writ petition has been filed. In the writ petition the interim order has been granted.
Correct. Have you challenged that order?
Yes, minutes. That is the order we have questioned in this
no,
writ
sir.
petition.
Writ petition order challenge ಮಾಡಿದಿರಾ?
Let's writ petition
order challenge
earlier writ petition.
ಹೌದಾ ಇಲ್ವಾ ಅದೇ ಕೇಳಿ.
No, the order is only the direction that's issued to the
so
KIT not to consider the representation.
Correct. So what?
Insofar as this interim order is concerned, they have the knowledge of this interim order granted in the writ petition.
We will not place the order of the civil court on a higher pedestal than that of this court. All right.
Insofar as this interim order is concerned, whether they have brought to the notice of this division bench.
Which division bench, sir?
Contempt proceeding.
Which order, sir?
This interim order granted in the writ petition.
In this writ petition. Yes. That we will take care. No problem.
Interim order has been granted. 27 minutes 18/7/24 lawyer
7/3/2024 there is no reason in this order.
Interim order not to disperse the compensation amount.
I just want to also point out writ petitionally
then notice has been issued. Counsel has been engaged.
No problems.
Then suppress the fact and receive
what
the
suppress?
Compensation.
ತಗೊಂಡು ಆಗಿದೆಯಲ್ಲ compensation.
With so far as other family members they are all depending on this compensation. One person takes the 5 crores rupees minutes. Now we are all depending on suit is pending. Whether it is a joint family property or self-acquired property, that has to be decided by the civil court.
Suit decide ಮಾಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ let's suppress.
ಈಗ ತಗೊಂಡು ಆಗೋಗಿದೆಯಲ್ಲ ಏನು refund ಕೊಡಕ್ಕೆ ಹೇಳಲ್ಲ ಈಗ.
Till then let them deposit before the court.
They have already taken. You have taken it.
Well, under the contempt order I have taken.
That's the civil court. Suit is pending.
ಯಾವಾಗ? Was it pending earlier?
Pending.
Was it pending earlier? Was it pending earlier?
Yes, because.
ಯಾವಾಗ?
With the understanding.
These things I am seeing n number of cases. Whenever compensation is determined, family members crop up. ಎಲ್ಲಿಂದಾನೋ ನಾವು family member compensation. ಅಲ್ಲಿವರೆಗೂ nobody knows each other.
Let me Muniappa produced one single document to show that yes, there was a partition among the family members. This property is self-acquired property. Let him place
one document. 4 acres grant order ಇದೆ. ನಿಮಗೇನು grant ಆಗಿತ್ತಾ?
Grant is for the benefit of entire family members.
ತೋರಿಸ್ಬಿಡಿ ಸರ್ ಅದು.
When Muniappa says with
where is it?
Partition.
Where?
Partition agidre then we have no right at all. Yes, already there was a partition. This grant land is when the property is concerned exclusively in favor of Muniappa. That is the different aspect.
Muniappa is still alive?
Yes, alive. She is alive.
Then no problem. Anything else, sir?
This contention, but with regard to this, the
Yes.
adjudication
You
of this.
fight out in the suit. There is no warrant. There is no warrant to continue the interim order, sir.
The civil court, when the suit is pending,
Yeah, when is it pending? That is what I'm asking.
reason is, suppose in case 86.
Anyway, I'll pass a detailed order and vacate the interim order now.
When he is exclusive possession, then I have no right.
Exclusive possession ಮತ್ತೆ.
ಎಲ್ಲಿ ಕೂಡ partition ಆಗಿದೆ, ಇದು ನನ್ನ ಪ್ರಾಪರ್ಟಿ ಅಂತ, that is not his case.
ಅವ್ರ ಪಾರ್ಟಿಷನ್ ಯಾಕೆ ಸರ್? 4 ಎಕರೆ ಅವ್ರಿಗೆ ಗ್ರಾಂಟ್ ಆಗಿರೋದು.
Grant is for the he himself. Muniappa son himself has filed the suit that there is no, all the properties are joint family properties ಅಂತ. when
ಅದೇ suit ಯಾವಾಗ ಹಾಕಿದ್ರಿ? ಯಾವಾಗ?
2016 ಅಲ್ಲಿ suit has been filed.
Where is that suit?
That copy I will produce.
Where is it?
That copy, Muniappa son, that is respondent number 2. I have filed the suit.
Which is that suit, Ajay?
That is,
My lords, I am not aware of any
I
such
will
suit.
produce
My
the
lords,
copy of the
my lords,
plaint.
just
Kindly have this matter on Monday. I will produce the plain copy of this. Muniappa
Nothing.
son has filed the suit.
List tomorrow in list number 2, preliminary hearing. Yes. Tomorrow I'm going to vacate the interim order.
We will produce the interim
You
order.
may produce anything. Tomorrow I'll vacate the interim order if no document comes up.
Yes, I will produce the copies of the plaints.
Play. Pending idea. Suit pending idea.
Yes, suit
my lords,
pending is
just
before
one
the
minute. My
senior
lords,
civil
one
judge.
minute.
Suit is pending before the senior civil judge. Muniappa.
Suit for what?
Partition. The very same condition.
Filed by whom?
Filed by the son of Muniappa. We are the parties in that suit.
ನಾಳೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
Yes,
ಯಾಕೆ
we
ಇದು
will
ಪ್ರೊಡ್ಯೂಸ್
produce
ಮಾಡಿಲ್ಲ ಇಲ್ಲಿವರೆಗೆ?
Yesterday night they have sent through the copy minutes, the WhatsApp. Immediately the matter has been listed. At least they could have served the copy minutes 2 days
All right.
prior to that.
No problem. Yes, tomorrow.
Number 3.
Still then interim order maybe tomorrow minutes 6.
I appear for the first respondent, my lord.
Yes.
Illa, sir, I appear for the first response.
Which matter? Next matter ನೀವು appear ಆಗ್ತಿದ್ದೀರಾ?
List number 3, serial number 3, I appear for the first respondent.
No problem. Dispensation
Impleading
to be heard along with the main matter. Why is it listed now?
ಅಲ್ಲ ಒಂದು
Dispensation allow ಮಾಡಿ, post the matter.
ಇದು ಒಂದೇ ಒಂದು ಸ್ಮಾಲ್.
No, in this stage I can't because that contempt ಇದೆ ಅಂತ ಹೇಳಿದ್ ಮಾತ್ರ ಕೇಳಿದ್ದೆ ಅಷ್ಟೇ. Portion destroyed.
ಅಲ್ಲ ಅಂದ್ರಲ್ಲಿ ನಮ್ದು ಎಲ್ಲಾ ಅಪ್ಲಿಕೇಶನ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ because my brothers have not joined me ಅಂತ.
No problem.
That may not be a reason.
List the matter on 20th in preliminary hearing. Dispensation allowed. ಅದೊಂದು ಬರ್ದ್ಬಿಡಿ.
Interim order action.
Interim ಮಾಡಿದ್ಯಾ?
ಇದೆ.
List the matter on 10th September. Yes.
ಇದು interim order action.
ಯಾರಿಗೆ ನೋಟಿಸ್? 2 to 20 ಬೇಡವಾ?
ಇಲ್ಲ ಬೇಕಿಲ್ಲ. ದಾರ್ಖಾನತ್ ಅಲೋನ್ ಅಪೋಸ್
ಮೆಮೊ in terms of memo ಅದನ್ನ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡ್ಬಿಡಿ ಅಷ್ಟೇ. Yes.
4. Withdrawal motion.
In terms of memo.
5.
interim order action.
That will go.
Appear for President's petition, my lord. Petitionary positioning since 2000.
Non-compliance of office objections.
There's only the annexures
ತೊಂದ್ರೆ ಇಲ್ಲ.
horizontal ಅದು ಫಿಕ್ಸ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಅಷ್ಟೇ, ಬೇರೆ nothing.
Office objections overruled. List on Monday in preliminary hearing. Next.
Please, my lord.
6.
My lord, yesterday I filed a wakala.
10
days time ಅವರಿಗೆ ಹೇಳಿದೀನಿ.
Learned counsel for the respondent Jaikar Shetty seeks 2 weeks time to file statement of objections. List on 3rd September. Objections if any by then. Please.
To consider the interim prayer.
7.
Preliminary hearing ಅಲ್ಲೇ ಬರುತ್ತೆ.
2 years ಆಯ್ತು ರಿಜೆಕ್ಟ್ ಆಗಿ.
ಅದಕ್ಕೆ ಕೊಟ್ಟಿಲ್ಲ, ಇದರ ಕೊಟ್ಬಿಡ್ತಾರೆ.
7.
Why is this in orders? This was Naganand sir had appeared. Same thing.
Yes.
Vacating stay.
Yes, your lordship.
Yeah, I'll take it later along with the other vacating stay applications. You're ready?
Your lordship, it may be called out at 2:30 or 3 p.m.
All right, 2:30.
Senior will be available.
All right, 2:30. This was heard substantially the other day.
Yes, ma'am.
Yes, your lordship.
2:30.
8.
I am appearing for respondent 2 to 7. I am seeking time to file objections, my lord.
8.
Yes, my lord.
Counsel for the respondent seeks 2 weeks time to file statement of objections. Interim order. List the matter after 4 weeks. Objections if any by then. Interim order subsisting will continue till the next date of hearing.
Much obliged.
Yes.
9.
For the petitioners, last time we had submitted the dispensation notice.
Memo for dispensation. Adon notice JY.
Orders ಆಗಿಲ್ಲ.
2, 3, 4 memo.
10.
Interim order extended.
Let's, in the,
That will continue. No date, yes.
my, my lords, all the respondents had been to Tirupati and a family function.
Tirupati?
Please, my lord.
Why,
And a
sir?
family function, my lord. Therefore, it may be permitted to take out and summons again.
Tirupati?
ಇಲ್ಲ ಈಗ ಬಂದಿದ್ದಾರೆ my lord.
ವಾಪಸ್ ಬಂದ್ರ?
ಈಗ ವಾಪಸ್ ಬಂದಿದ್ದಾರೆ.
Family function ಮುಗೀತಾ?
ಮುಗಿದಿದೆ my lord.
Yes. Learned counsel for the petitioner seeks a week's time to comply with the earlier order of taking out hand summons. Yes, next.
Interim order may be extended.
Interim order subsisting will continue to the next date of hearing, 3rd September. Yes.
Much of it.
Next.
7.
My lord, I've
Respondent.
served it on the child put advocate, however, intentionally they're not appearing.
Intentionally?
Please, my
Interim
lord.
order ಇದೆಯಾ?
Illa, my lord, it's, we've challenged the manner of computation in an execution proceeding, my lord.
You are a decree holder.
Please, my lord.
ಬರ್ಲೇಬೇಕಲ್ಲ ಮತ್ತೆ.
Please.
Yes.
May I be permitted to parallelly take notice also, my lord, on the party because they've not.
Hand summons you will take?
Please, my lord.
The counsel for the petitioner is permitted to serve the respondents by way of hand summons as well. List the matter on 3rd September in preliminary hearing. Next.
12.
Yesterday, I filed it in the counter, my lord.
ಏನು?
Acknowledgement for having served the copy.
Interim order ಇದೆಯಾ?
ಇಲ್ಲ ಕೊಟ್ಟೆ.
What's the matter?
Suit for injunction was filed, my lord. During the course of cross-examination, plaintiff admitted the possession of the defendant.
Application in?
Application for withdrawal of the suit to file a comprehensive suit for declaration and possession. That was dismissed.
Let's see. Learned counsel for the petitioner submits needful has been done. Office to verify. List the matter on 29th.
21st ಕೆಳಗಿದೆ.
ಒಂದು adjournment ತಗೊಳ್ಳಿ.
Final hearing ಕೊಟ್ಟಿದ್ದಾರೆ. 21st.
Adjournment ಒಂದು ತಗೊಳ್ಳಿ ಕೊಡ್ತಾರೆ. Yes. Next.
13.
That 5 guttas has been given by the respondent. Partition
Merits
agide.
ಮೇಲೆ merits ಮೇಲಲ್ಲ ಇದು ಏನಿದೆ?
ಅಲ್ಲ is
Cost list ಏನಿದೆ ಅದನ್ನ ಹೇಳಿ.
settlement report ಆಗಿದೆ. ಆ ಸರ್ವೆ ಆಗಿದೆ 5 guttas ಕೊಟ್ಟಿದ್ದಾರೆ plaintiffs ಗೆ.
ಕ್ಲೋಸ್ ಮಾಡೋಣ ಇದನ್ನ?
ಅಲ್ಲ ಅದನ್ನ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಇದೆ next week ಅಲ್ಲಿ partition deed.
ಹಾ ಸರಿ.
ಅದಕ್ಕೆ 10 days time ಇದೆ.
List the matter after 4 weeks. Interim order subsisting will continue to the next date. Next. Settlement ಆದ್ರೆ move ಮಾಡಿ will close it.
I'm for the respondent, I seek a short passover.
No passover. Tell me what is it?
Said by senior
I also
counsel.
seek a short passover. This is a matter was partly heard. The limitation arbitration agittu adadmele suit has been filed.
List the matter at the request learned counsel appearing for the parties. List the matter on 10th September. Yes, next.
Interim order may
In
be
preliminary hearing, interim order subsisting will continue to the next date of hearing. Next.
15.
Milords, the acknowledgement for having served the writ petition is placed on record on 23rd June, Milords.
Previously an office of chief forensic 14 ಅಲ್ಲಿ.
And 23rd.
1 minute. 14 ಅಲ್ಲಿ needful be done by then, failing which the interim order would stand automatically vacated. Yes. Furnishing of copies to R2. Who appears for R2?
Postal acknowledgement for having served on R2 has been filed on 23rd June.
Counsel for the petitioner submits needful has been done. Office to verify. List after 2 weeks. Interim order subsisting will continue to the next date of hearing. List after 4 weeks. Yes, next.
16.
R2 ಯಾರು?
The respondent in this matter.
ಒಬ್ರೇನಾ respondent?
ಸುಮಾರು ಜನ ಇದ್ದಾರೆ. I am appearing for
R1.
R1 and others, my lord.
Milords, I appear on behalf of petitioner counsel, Milords. There is some inconvenience, Milords, health issues to the petitioner
Health
counsel,
issues?
Milords. To the petitioner counsel itself, Milords.
Oh.
Can it be taken after 2 weeks, Milords?
Execution is stayed, is it?
Please, Milords. Interim order.
Payment of rent has been stayed, my lord. In fact, it has not been, it's close to 10 lakhs and above, my lord. 10 lakhs, 10,000 rupees.
Oh, ಅದಕ್ಕೆ not
And
well.
it's, the suit is
No,
of the year
Milords, the petitioner counsel,
2009.
Milords.
And it was decreed in the year 2014. Subsequently, High Court passed a judgment in the year 2020. And we are in the year 2025.
ಎಲ್ಲಿದೆ order? High Court order.
That's next week tavakondu by
List the matter,
overslems.
list the matter on 20th in preliminary hearing. It is
My
made
lords,
clear if the counsel for the petitioner would not make his submissions, the interim order would stand
My
automatically
lords,
vacated.
my lords, the petitioner counsel is taking treatment for hemorrhoids, my lords. That's the reason he is not in a position to come, my lords.
You appear, madam. Yes.
My lords, I'm a proxy counsel, my lords. Can it be
Then,
taken?
then
first
we'll adjourn it, not extend the interim order. Yes, next.
My lords, at least on 28th, my lords.
No.
He's
yes.
taking treatment, my lords. That's
20, we'll take it on Previn Godre. Treatment ಅಂತ 28
Last person to object.
correct.
They should not make this reason.
29 29th in preliminary hearing, same
Please.
order. It will get automatically vacated if they don't submit. Yes.
please. Break.
Respondent 6 and 7, my lordship. I undertake to appear for 1 and 5, lordship.
6 and 7.
Yes, my lord. Contesting respondents.
Awaiting service one are 1, 3 and 5.
I undertake to file wakalat, lordship.
Learned counsel so and so undertakes to enter appearance for respondents 1, 3 and 5. One second time R4 yaru.
I'm taking for 1 to 5, lordship.
1 to 5 or 1 to 5. Yes. Register to print the name of so and so as 1 to 5.
My lords, the
29.
execution petition is coming up tomorrow, my lords. They are seeking
can't
for
help.
issuance of a delivery warrant, my lords.
List the matter on 20th in preliminary hearing.
My lords, may I make.
Lordship, what has happened, lordship, is that the respondents 1 to 5 have sold their share in the suit schedule property, lordship, to the petitioners. No objection from us.
Nimden
I have not sold the property, my lord.
ಎಲ್ಲ ಸೇಲ್ ಮಾಡಿದ್ದೀರಾ?
Out of 7 shares, my lord, 5 shares are already sold.
List the matter on 10th September in
May kindly
1 minute,
bear with
madam.
me. My lords, tomorrow.
Will you please allow me to pass some order?
Very good.
List the matter on 10th September. Further proceedings before the concerned court shall remain stayed till the next date. ಆಡಕ್ಕೆ ಬಿಡಲ್ಲ. Yes. Yes.
Any earlier date, my lord?
ಏನ್ ಪರವಾಗಿಲ್ಲ. ಎಲ್ಲ ಸೇಲ್ ಮಾಡಾದ್ಮೇಲೆ.
ಇಲ್ಲ, ಸೇಲ್ ಎಲ್ಲ ಆಗಿಲ್ಲ.
ಪರವಾಗಿಲ್ಲ, ತೊಂದ್ರೆ ಇಲ್ಲ, ನೋಡುವ.
Because my lord, 40 years from I am fighting for the possession, my lord.
We'll see. Yes. Next.
18.
No representation list after 4 weeks. Yes, next.
19.
I appear for the respondent.
Rectification of wakalat.
There is a mistake in the name of the respondent 1B, which is in the repetition. I have mentioned the correct name. Therefore, my lord, there appears to be an office objection raised on that.
What is your correct name?
Kavita.
Kavita.
Respondent number 1B is shown as Shanti. Even in the amended plaint, it is as Kavita.
Party name.
Party name. Adrinda.
Oh, then rectify it. Office objection, advocate for respondent. What is it, sir? Have you seen the cause list?
There is
What is the office objection? Que the wakalat filed by you.
In the wakalat, my lord.
What is the problem?
I have mentioned the name of respondent 1B as Kavita. They have in the writ petition is mentioned Shanti.
Yen sir problem?
ಅಲ್ಲ ಅವ್ರ ನೇಮ್ ಕವಿತಾ ಅಂತಾನೆ ಅವ್ರು ತಪ್ಪು ಬರೆದಿದ್ದಾರೆ. ನಾನು ಕರೆಕ್ಟ್ ಹೆಸರು.
Anyway, list the matter on first time.
First time. Notice is not issued.
List the matter on 20th in preliminary hearing. Office
Sir.
objections
This-
we
in this
complied
case,
with
it is
by
posted
then.
for argument.
When?
Posted for argument.
20th. Yes, next.
IMA.
20.
Monday, Wednesday. Yes.
Served the copy. I served the copy to other side. 28th.
Memo having served.
Appear for respondent
You're
number
appearing?
1. For respondent number 1.
1, 3 and 4.
Appearing for respondent.
ಇದಾರೆ ಇನ್ಯಾರಿಗೆ?
3 and 4 is we have served copy.
Who is R2?
He will sail with respondent number 1, but he doesn't want to appear before.
All
the
right,
court.
leave it. What's the matter? Interim order ಇದೆಯಾ?
No.
No, order on 26 rule 10A. 26 rule 10A.
Placed on 29th. Yes, next.
Your Lordship, may kindly have it on 28th.
Interim order ಇಲ್ಲ.
Alla, 20, because last weekend I'm not in town.
28th ಇಲ್ಲ. Either 3rd or 28th.
3rd, my lord.
Yes, 3rd.
3rd. Much obliged.
Next.
21.
Please, my lord. This is the plaintiff's petition, my application for amendment to incorporate declaration that the sale deed
Suit
executed.
for.
Suit is for partition. by the sister against the brothers.
In
And one of the
ಯಾರಿಗಾಗಲ್ಲ.
brother has sold the
What
property.
else can happen? Partition ಅದೇ ತಾನೆ. Yes. ಆಮೇಲೆ.
One submission, my lord. This writ petition may not survive for the reason that the writ petition may not survive for the reason that he has filed another application, that is I number 5, to amend this application.
To amend this application.
Yes.
What happened to that application?
That was dismissed.
This
And
is
this-
also dismissed.
Yes,
ಇಲ್ಲ ಇಲ್ಲ
yes.
ಅದರಲ್ಲಿ ಡಿಫೆಂಡ್ ನಂಬರ್ 5 ಅನ್ನೋ ಬದಲಿ ಡಿಫೆಂಡ್ ನಂಬರ್ 1 ಅಂತ ಹಾಕೊಂಡು ಅದು ಒಂದೇ ನಾವು ಕರೆಕ್ಟ್
ಪರವಾಗಿಲ್ಲ. ಏನ್ amendment ಕೇಳಿದ್ರಿ?
ಸೇಲ್ ಡೀಡ್
ಯಾವ
executed
sale
by executed by defend number 5 in favor of 50 has been 57 and he got impleaded in this suit madam.
When?
In 2019.
19.
Application was filed in
Written
2000
statement ಯಾವಾಗ ಹಾಕಿದ್ರು?
18 ಅಲ್ಲಿ ಹಾಕಿದ್ರು. 18 ಅಲ್ಲಿ ಹಾಕಿದೀವಿ, and we have brought to the notice of the court about this sale which took place in 2011.
Sale date 2011.
Prior to the filing of the suit itself.
Correct.
But
But
they did not, they
when
did
did
not
you
make me a
written
part.
statement ಹಾಕಿದ್ಯಾ ಯಾವಾಗ?
2019 madam.
18 ಅಲ್ಲಿ ಹಾಕಿದ್ವಿ.
ಇಲ್ಲ 2019.
Where is the written statement?
Page number 76.
70?
6 madam.
16 to 2018.
ಅದು ಆರ್ಡರ್. ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ ಯಾವತ್ತು? 16/12/2019.
16/12.
Anything else, sir? ಅಷ್ಟೇನಾ? We'll dismiss it.
16.
ಹೆಂಗು ಇನ್ನೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
ಅಲ್ಲ ಅದರಲ್ಲಿ ನಾವು ಓನ್ಲಿ
ಪರವಾಗಿಲ್ಲ. ಅದಕ್ಕೆ I will not refer to that at all. Not a problem. Yes.
ಅಲ್ಲ that becomes infructuous consequential order.
We have. Yes. The petitioner is before this court calling in question an order dated 2/7/2025 rejecting the application of the petitioner plaintiff filed under Order 6 Rule 17 seeking amendment of the plaint to the effect of bringing a sale deed that had taken place in the year 2011 on record or challenging the same by way of the said amendment. The concerned court in terms of the order as aforesaid rejects the application on the following reasons. Page 74 to 76. The learned counsel appearing for the respondent submits the written statement was filed on 16/12/2019 itself, and the factum of the sale deed having taken place long before the institution of the suit itself was pleaded in the written statement. Notwithstanding the same, the application did not come, the application seeking amendment was not filed. When the matter was set at the stage of evidence or arguments as the case would be, the application comes to be filed. The said application is rejected by the aforesaid order. I do not find any perversity in the order to excise the jurisdiction of this court under Article 227 of the Constitution of India to obliterate the same. The learned counsel appearing for the respondent further submit that another application is filed for the same reason, and that also has come to be dismissed. For all the aforesaid reasons, finding no merit in the petition stands disposed.
Great.
Dismissed. Next.
22.
Post immediately after service of notice upon respondent 1 to 3.
23.
Dispensation all madam. 2 and 3.
Intermediate till then minutes.
ಇದೀರಾ?
No.
Next matter. Sorry.
Maintain status contempt.
ಅಲ್ಲ ರೆಸ್ಪಾಂಡ್ ನೀವಾ?
No,
ಇಲ್ಲ.
next matter. Next, sorry.
List the matter after 2 weeks. Interim order subsisting ಇದೆಲ್ಲ ಜೇವೈ.
Yeah.
1 2 3.
22 interim.
23.
ಇಲ್ವಾ? 22 whatever. Note post immediately after service of notice upon R1 IA 1 of 25 2 25 allowed. Yes, next.
23.
My lord, 23, I appear for first respondent.
Notice in respect of
My lord, they are sailing along.
R2 to R7.
Yes, they are sailing along with the petitioner. And the first respondent, suit for partition, my lord. First respondent is partly cross-examined by dependent number 7. And at that stage, written statement came to be filed after 7.5 years.
I have not stayed the proceedings. I only stayed that order which permitted additional written statement to be filed.
Yes.
Yeah,
That's all.
therefore, my lord.
Proceedings are not stayed at all.
My lord, may I request that there is a connected writ petition,
Kodi,
WP
tag this petition along with the
23194. May I request it next week, my lord, because The person,
20, we'll take it on 10th September.
my lord,
Yes.
little earlier for
No, no, I have
this,
not stayed the proceedings at all.
for
Yes.
this reason.
It
my
is
lord.
made clear that the proceedings before the concerned court are not stayed, as what is stayed is only permitting additional written statement to be filed after, at the fag end of the trial. Yes,
Yes.
next.
Obliged.
24.
Then-
Plaintiff before this honorable court.
Affidavit, defendant number 3 to 4. Serve ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿ, notice ಆಗಿದೆ. Suit for partition.
ಪರವಾಗಿಲ್ಲ. Yes. Petitioner, learned counsel of the petitioner submits needful has been done. In that light, list the matter on 29th. Yes, next.
25.
For the respondent number 2 in this case, my lords, I filed my wakalat today, my lords, in the registry.
Enter ಮಾಡಿದ್ಯಾ?
ಇಲ್ಲ.
Counsel for the respondent, learned counsel so and so, and it submits that she has entered appearance for respondents 2 and 3.
Respondent number 2, my lords.
Respondent number 2, registry to print the name of so and so as appearing for the second respondent. List on 29th. Yes.
Lord, before the trial court matter is there tomorrow.
What is the matter?
For plaintiff's further evidence. Let the proceedings be stayed till then.
Why is- What's the order and challenge?
My lord, my 12 rule 6 application has been dismissed.
Correct ಆಗಿದೆ.
My
Very-
lord,
Where is the judgment on admission now?
My lord, plaint,
Partition suit ಅಲ್ಲಿ.
partition suit.
Anything else, sir? List the matter on 10th September. Objections, if any, by then. Next. 12 rule 6 partition ಇಲ್ಲ. Compromise ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ?
ಇಲ್ಲ.
Then
I'm the purchaser.
nothing. Yes, yes, next.
26.
My lords may directed me to serve the copy of the writ petition to the opponent counsel, which I have served it. I'm also with this, my lords has heard this matter.
Section 10,
Section 10.
list after 4 weeks.
ಇದು
Interim order
judgment
subsisting will continue till the next.
interim order ಇಲ್ಲ.
ಇಲ್ವಾ? ಕೇಳಿಲ್ವಾ?
ಕೇಳಿದೆ ತಾವು ಸರ್ವ್ ಮಾಡ್ಕೊಂಡು ಬಂದಿದ್ದೀವಿ.
ಅದು ಸರ್ವ್ ಮಾಡಿ ಹಂಗಾರೆ. List on
ಅಲ್ಲ ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ ಸರ್.
learned counsel such submits that he has served on the counsel appearing for the respondent awaiting his appearance. List the matter on 20th in preliminary hearing. In the event the counsel would, in the event the respondent would not be represented, the an interim order as sought for consideration, the interim order would be considered to be granted. Next.
ಸರ್ ನಂದು ಜಜ್ಮೆಂಟ್ ಆಗ್ಬಿಡ್ತದೆ ಇವತ್ತು ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್.
ಎಲ್ಲಿದೆ?
ಲೆಟ್ ದೆಮ್ ಕೋರ್ಟ್ ಮೇ ನಾಟ್ ಪಾಸ್ ಎ ಜಜ್ಮೆಂಟ್ ಅಷ್ಟೇ ನಾನು ಕೇಳ್ತೇನೆ.
ಹಾಗಾದ್ರೆ ಒಂದು ಕೆಲಸ ಮಾಡಿ. The learned counsel for this now submits that the matter is posted for his judgment tomorrow.
ಅಲ್ಲ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಇವತ್ತಿಗೆ ಫರ್ದರ್ ಆರ್ಗ್ಯುಮೆಂಟಿಗೆ.
Further argument.
ಹೌದು ಸರ್. ಜಜ್ಮೆಂಟ್ ಪಾಸ್ ಮಾಡೋದು.
All right. The court, concerned court shall not deliver its judgment without the leave of this court.
Great.
Yes, next.
27.
For the petition in this case, Your Honor, I have served the copy to the respondent, my lord.
ನೀವಿದ್ದೀರಾ? Counsel submits, needful has been done, office to verify.
It was already filed, my lord. Acknowledgement filed ಮಾಡಿದ್ವಿ ಸರ್ವಾಗಿ.
ಅದೇ, needful has been done, office to verify. List the matter. Interim order ಇದೆಯಾ?
Interim ಕೊಡ್ಲಿಲ್ಲ ಸ್ವಾಮಿ.
29th, yes. Next.
For 28.
Petitioner, lots so suit pending before commercial court for recovery of 14,92,000.
What is non-compliance? Office objection ಏನು?
My lords, it's earlier one office objections were cleared, my lords. Again, after scrutiny, my lords, they have raised some office objections. That I'll clear, my lords.
ಏನು 6 objection ಬಾಕಿ ಇದೆ. ನೋಡೋದೇ ಇಲ್ಲ ಅಲ್ಲಿ ಹಾಕಿದ್ಮೇಲೆ. ಮೆಮೊ ಮಾತ್ರ ಮೂವ್ ಮಾಡೋದಷ್ಟೇ.
Will comply.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಆದ್ರೆ ಯಾವ ಮ್ಯಾಟ್ರು ಇವಳಿಲ್ಲ, ಎಲ್ಲ ಬರುತ್ತೆ. ಮೆಮೊ ಮಾಡ್ತೀರಾ ಆ ಕಡೆ ಹೋಗೋದೇ ಇಲ್ಲ.
ಇದರಲ್ಲಿ 28 ಗೆ further.
ನಾಟ್ ಇವನ್ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಇಲ್ಲ, 6 ಅಬ್ಜೆಕ್ಷನ್. ಅಫಿಡವಿಟ್ ಇಲ್ಲ, ಸಿಗ್ನೇಚರ್ ಇಲ್ಲ. ವಾಟ್ ಈಸ್ ಆಲ್ ದಿಸ್? A week's time is granted to comply with the office objections. In the event they stand complied, list the matter on 20th in preliminary hearing.
20th.
Yes, next.
29.
I have served the copy on Madam Sridevi.
Appearing for the respondent, I have
There.
filed my wakalat on 4th August.
Learned counsel. ನಿಮ್ಮ ಹೆಸರೇನಾ?
J.M. Patil.
J.M. Patil submits that the said counsel has entered appearance for the respondent, Federal Bank.
Please.
List the matter on
Some urgency, my lord.
what urgencies?
Matter is posted for arguments.
Argue ಮಾಡಿ.
Right.
Yes. ಇಲ್ಲ. List on 20th preliminary hearing. Yes, next.
30,
For the petition in this case, my
As a
lord.
respondent number 1 and 2, my lord. My lord, I'm yet to be served a copy of the petition, my lord.
Council, my lord, I was directed to serve the copy to the council, my lord, I have served. I will file.
My lord, I am the NOC Vakalatama in the trial court, my lord.
I will
They have
serve,
served it
I
to
will
the previous council.
Learned counsel so and so, learned counsel, the petitioner is directed to serve on the counsel for the respondent.
1 and 2, my lord.
What's under challenge?
Lord, order 18, rule 17, my lord, so as to recall the DW 1 and DW 2, my lord, so one opportunity, my lord, I have sought for.
Let him come. Yes, list on 20th. Note
18th, my lord, argument, my lord.
Argument ಮಾಡಿ ಭಯಾನ್ argument ಮಾಡಕ್ಕೆ.
ಅಲ್ಲ ಏನಂದ್ರೆ
We'll see. Yes, yes. Next.
Oblige.
till then, my lord.
31,
This case appear for petition. Trial court copy serve ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ. The urgency is order 21 rule 54 allow ಮಾಡಿದ attachment of the property. Earlier execution petition dismissed.
20th is preliminary hearing.
Interim ಮಾಡ್.
No, sir. ಅವತ್ತು. Next.
32,
I appear for respondent number 4, my lord. The matter may be taken up on the next week, my lord. Senior has health issues, my lord.
No representation behalf of the petitioner. List on 10th September. Next.
33,
What maintainability?
Lord, it's a transfer petition
From where?
from one bench to another bench at the trial
Where?
court. Yes, my lord.
Why?
My lord, it is connected.
That
my-
is rejected.
Not rejected, my lord. They are saying that it may not be maintainable. They are in doubt and it is a connected matter with the main petition.
Number-
WP
number
number
ಕೊಡಿ.
16549.
Number.
16549 of 2025, serial number 84 today, my lord.
ಇವತ್ತು ಇದೆಯಾ?
Yes, my lord.
We'll take it along with that. Yes.
And now, after having heard this
Pass
petition,
over,
the main
yes.
petition,
Pass over.
34,
Lord, I have served the copies, my lord. He has acknowledged, my lord, the receipt of notice, but he has not appeared. My lord, the problem is, my lord, PW 1 and 2, my lord, I have not cross-examined.
At all?
No, my lord.
Suit is of the year 2005.
Now, we still, my lord, in the stage of defendant's evidence. And I have to lead my evidence. I am defendant number 3. My lord, I understand that, my lord, there is some lapse and because of the advocate, my lord, I have changed him now. I have engaged another advocate. My lord, your lordship may impose cost because suit is for.
Let the respondent come. Yes.
No, my lord, I have served him copy.
No problem, sir. List the matter on 29th in preliminary hearing.
Such time, my lord.
No, sir. Not in this case.
No, what happens?
2005 suit al stay ಕೊಟ್ಕೊಂಡಿಗೆ no,
No,
sir.
my lord, it was not, my lord, filed in this court.
Let
It
him-
was
let
filed
him-
in some other.
Let
court, my
him
lord.
come, sir. Yes.
My lord, I have served him copy. I have told him.
Let him
my lord.
come, sir. Yes.
My lord, your lordship may say the issue notice because your lordship permitted me to serve a copy on the advocate acting for the respondent. I have done it, my lord. Still
Now
he
you
didn't-
want me to give you hand summons? Please, sir.
Counsel,
Counsel for the petitioner is at liberty to serve the respondent by way of hand summons. List on 29th. In the event there would be no representation of the respondent, the consideration of interim prayer, the interim prayer would be considered to be granted. Yes, next.
3rd September.
29.
35,
29ಕ್ಕೆ ತಗೊಳ್ಳಿಲ್ಲ. ಬೇರೆ ರಜಾನೇ ಇದೆ 25, 26, 27 ಲೈನ್
ಅಲ್ಲ, ಊರಲ್ಲಿ. I will not be in station.
You will not be in station. ಹಂಗಾರೆ 3ನೇ ತಾರೀಕು ಹಾಕ್ಲಾ? 3rd, yes.
I've taken steps today, my lords.
Serve ಮಾಡಿಲ್ವಾ ಇನ್ನು?
I may be permitted to serve a copy.
I'll vacate the interim order then.
Binding counsel KPSTL before this court, my lords.
The petitioner shall serve on the counsel, serve on any counsel representing the respondent KPTCL in the next 2 days. List the matter on 20th in preliminary hearing.
Interim order may kindly be extended.
ಆಯ್ತು, serve ಮಾಡಿ first. Yes,
36,
interim order continues.
That copy has been served on minute 4th itself. I have served the copy and minute process also I have paid minute.
10th interim order continues. Next.
In this, may I request your lordship?
10th September.
Your lordships have granted interim order staying all further proceedings. ಅಲ್ಲಿ ಬರೀ ಆರ್ಡರ್ ಮಾತ್ರ ಸ್ಟೇ ಮಾಡಿದ್ರೆ at least ನನ್ನ objections ಎಲ್ಲ.
ಅಲ್ಲಿ ತಗೊಳ್ಳಿ. It is clarified that further proceedings before the concerned court are not stayed except the order R1 year.
File vakalat for R1.
Learned counsel so and so submits that his entered appearance for the first respondent, registry to print the name of so and so. 2 to 25 dispense agidya.
Or defendant, sir.
3rd September, interim order continues. Next.
Please.
38.
Copy served on 11th, my lord, I received acknowledgement. I will file today acknowledgement. The copy served on 11th.
Counsel for the petitioner seeks a week's time to do the needful.
Date, 20th.
List on 20th illa. List on 20th. Yes. Next.
39.
Petitioner, my lord. The respondent files a
Is this
suit.
serial number?
My lord, the respondent files a suit alleging setback violations, which comes under 248, and the trial court grants an injunction. My respectful submission is that order was without jurisdiction.
BBMP notice ಕೊಟ್ಟಿರೋದು ಎಲ್ಲಿದೆ?
But yes,
BBMP
has
proceedings
given- yes,
ಎಲ್ಲಿದೆ?
BBMP has given us notice. And the proceedings are all, in fact, he has sent 2 more complaints to BBMP. They've done a spot
Why
inspection.
don't you file all that?
My lord,
What's the problem in filing everything here?
here, I'm sorry, I just given it, my lord.
Annexure ಮಾಡಕ್ಕೆ ಏನ್ ಪ್ರಾಬ್ಲಮ್?
Compilation, it was urgent. is that.
ಅದಕ್ಕೆ ಹೆಂಗ್ ಬೇಕಾದ್ರೆ
Annexure
ಮಾಡೋದಾ?
D, Annexure D is the notice, page 29.
ಹಾ.
In October of 24,
ಇದ್ರಲ್ಲಿ ಈ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ.
ಕೊಟ್ಟಿದ್ದೀವಲ್ಲ?
ಈ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳಿ ಏನೇನಿದೆ?
ಇದ್ರಲ್ಲಿ ಏನಿದೆ ಅಂತ ಈ ಡಾಕ್ಯುಮೆಂಟ್ಸ್
1 minute.
Petition ಜೊತೆಗೆ ಇದೆ.
ಇದರಲ್ಲಿ
Merely he says there is setback violation on 28/7/25.
I'm asking a simple question. BBMP proceedings ಎಲ್ಲಿದೆ?
No, these are all proceedings. They came and inspected. They have not given us any report.
BBMP.
BBMP. They were also present when they had proceedings, when they came and inspected the.
Now, this is the complaint at page 74.
Yes, my lord.
Unauthorized construction of multi-story building without sanctioned plan. Where is the plan?
My lord.
Where is your plan? Vinayaka House Building Society.
They allotted me the site.
But where is the sanctioned plan?
Your lordship may see it at, in the compilation which I have given to your lordship, my lord.
ಅದನ್ನೇ ಕೇಳ್ತಾರೆ. Jurisdiction we will see.
69.
But do you have a plan?
Yes, my lord, we have a plan. And no 6 floors are being constructed there. It's only the stilt floor is constructed.
That we'll see. Where is the proceeding of BBMP notice ಅಲ್ಲಿ ಏನಾಗಿದೆ?
ಇಲ್ಲ, ಏನಿಲ್ಲ, that's the only notice which they gave us. Then
Which page?
My lord, page 29 of the writ petition, my lord. Page 20, that's all the notice I got from BBMP. Then they came and inspected. After that, I have not heard from BBMP.
Oh, it inspected on 28/7/20.
ಹೌದು. After that, they have not come and.
Suit ಯಾವಾಗ ಹಾಕಿದ್ದು?
Suit has been filed on 2nd August 2025.
Why, sir? Why are you in a hurry?
I am not in hurry.
Then we will stay this. Where is the, where is jurisdiction of civil court to entertain all this?
Civil court is under, my suit is not barred either under 9, section 9 of the CPC, nor under any provision. And your lordship has to appreciate, my learned friend has filed only operative portion of the interim order.
I'm not.
I am filing the entire interim order fast.
No problem.
That shows it is a considered order.
So what?
If it is a considered order, your lordship, he has got a remedy under 39(4). Statutory remedy under 39(4). You should exhaust it.
My lord, I'm not challenging whether
Wait,
the
sir.
order is right or wrong.
Don't get so touchy, sir. Wait. Yes.
39(4), he has to exhaust it, your lordship, for variation. That he has not done, but without exhausting that, he cannot invoke the writ jurisdiction. That is my submission, your lordship.
Oh. ಅಷ್ಟೇನಾ?
39(4), he has to exhaust it, your lordship. And your lordship will kindly see the decision of this court is there. Without exhausting a 39(4). Yeah, CRP was filed. Then it is the court held, it is not maintained.
You give it, sir.
Yes, I am giving. Yellow. Go to the decision. Give a site, I am sorry, I'll get it. 1994, one Karnataka Law Ordinance 142, your lordship. That says, without exhausting a remedy under section 39(4), CRP cannot be filed.
CRP cannot be filed.
Yes, my submission,
Our CRP.
I understand your lordship power under 226 is very wide.
227 is 6 alga.
Therefore, your lordship will kindly see, under 227, the order passed by the trial court, whether it is on the face of it is illegal or patent error. Your lordship will kindly say, I have passed on the order, consider
Give
order,
him 248 kodi.
order passed by the trial court, it has considered everything, then it has passed an order. Therefore, he has to exhaust order 39 rule 4, your lordship.
Correct.
248.
248.
No, bar and jurisdiction is a
Yeah, it says that the commissioner has got the.
Correct, sir. Civil
Which means that
civil court cannot
it
entertain.
excludes the, because there are a couple of judgments also, my lord.
I am aware of that. Where is that provision?
There's no specific provision
There
as far
is.
as 248 is concerned is when there is any violation, this chief commissioner will have the jurisdiction to inquire into it and.
Yes, Heli. Ashana, sir.
That will not take away my power of if it is affects my right and ear, I am entitled to file a civil suit. Civil court has got a jurisdiction. It is not barred either under section 9 of Civil Court Act, Civil Procedure Code, or any provision of the Corporation Act. Therefore, your lordship, when a considered order is passed by the trial court, that cannot be interfered with, because you can exhaust 39(4).
Other code judgments.
Yes. My lord, your lordship may see paragraph 6. The provision in the bylaw framed by the municipality requiring a clear space so-and-so does not create a right in the neighboring owner to institute a suit for injunction. It is for the appropriate authority under the municipal act to determine whether the terms and conditions of license have been contravened. No temporary injunction can be granted in favor. This is His Lordship Justice Hiramat's judgment, paragraphs 6 and 9. Paragraph 6 and 9. 6 deals with easemental rights. My learned friend was saying light and air. There should be a pleading that I've been enjoying it for 20 years. There's nothing left except one single line. And BBMP jurisdiction at para 9. Para 9 at page 3, 1, 2. Three, 1, 2, 3.
Yes, Nagbhushan sir, Ashtana.
Yes, sir.
I'll pass the order.
My lord.
I'll pass the order.
Your Lordship, I only consider submission again at the cost of repeated. Your Lordship may peruse the interim order passed by the trial. That's the only, Your Lordship. When it is a considered order, it should go before trial court, exhaust 39(4), not come before this court.
Yes. Heard as a petitioner, the defendant is at the doors of this court calling in question an order dated 5/8/2025 passed by the concerned court in OS 5599 of 2025, by which the concerned court grants injunction against the present petitioner in favor of the plaintiff. The order of injunction reads as follows. It is this order that has driven the plaintiff to defendant to this court in the subject petition. The learned counsel appearing for the learned senior counsel appearing for the petitioner would vehemently contend that the suit itself was not entertainable before the concerned court, as the issue would clearly fall within the jurisdiction of the zonal commissioner under section 248 of the BBMP Act. So and so. It is not that the plaintiff has not exhausted that remedy. The plaintiff has registered complaints before the BBMP, and the BBMP has inspected the property of the petitioner. And notwithstanding the same, the suit is filed seeking mandatory injunction. He would contend that he would seek to place reliance upon two judgments of the learned single judges of this court to buttress his submission that it is only the municipal authorities, or now the BBMP, that has to act upon the said complaint and not a civil suit for injunction. The learned counsel CM Nagbhushan, representing the respondent, would contend that there is a reasoned order granted, the reasoned order passed while granting injunction by the concerned court. The learned counsel would submit that the petitioner has to exhaust the remedy under 39(4) by filing an application seeking vacation of the interim order, and not approach this court directly by filing a petition under writ petition under Article 227 of the Constitution of India. He would submit that that this court cannot entertain the petition straight away, as the order does not, as the proceedings is not barred under the Code of Civil Procedure. He would seek dismissal of the petition. I have given my anxious considerations on. The afore narrated facts are not in dispute. The plaint is instituted, not in dispute. The petitioner, the plaintiff, the neighbor of the present defendant, registers a complaint before the BBMP alleging that the petitioner is undertaking unauthorized construction without a sanctioned plan. The BBMP issues a notice to the petitioner to inspect the property on 28/7/2025. The report of the inspection is yet to come out. In the interregnum, yet to come out. Notwithstanding the complaint and the report, the petitioner complains. Plaintiff institutes the suit on 2/8/2025, seeking the following prayer. The prayer of the petition, following prayer, that is at page 19 of the petition. The prayer of the petitioner squarely falls within the power of the BBMP to stop construction or demolish the already made construction. In the light of falls within the BBMP. Section 248 of the Act reads as follows. Section 248 vests power with the commissioner, zonal commissioner, to act upon the complaint and pass necessary orders, either demolishing or stopping construction as the case would be, leaving open to the owner of the property all remedies available in law. The jurisdiction of the civil court is undoubtedly unavailable to the plaintiff to knock at its door unless the plea of easementary rights being taken away is taken in the plaint. That is not the issue, that is not the plea that is taken, nor the prayer that is sought. Prayer quoted herein above squarely falls within the jurisdiction of the commissioner, zonal commissioner, in terms of section 248, which remedy the plaintiff has already initiated by registering a complaint. The law in this regard is no longer res integra, as the two learned single judges of this court in so and so have held as follows. The learned counsel for the petitioner plaintiff contends that without exhausting the remedy under 39(4), the present petition could not have been preferred. The submission is noted only to be rejected, as it is the question of jurisdiction. If the concerned court has no jurisdiction to entertain the petition, in the light of the law being laid down by this court, by two learned single judges of this court, and the statute itself, there was no question of granting an interim order of injunction against the petitioners. In that light, the order so and so, which suffers from want of jurisdiction, is a nullity in law. Therefore, the petition deserves to succeed. So and so stands quashed.
Pray your lordship to direct the BBMP to pass an order on the notice issued by them within a short time.
ಅವ್ರ ಪೆಟಿಷನ್ ನಿಮ್ ಪ್ರೇಯರ್
Why not your lordship?
ನೀವು ಸಪರೇಟ್ ಹಾಕಿ ಎಲ್ ಬಿ ಕೋರ್ಟ್ ಹೋಗಿ ಒಂದು ಮ್ಯಾಂಡಮಸ್ ಕೇಳಿ ಕೊಡ್ತಾರೆ.
ಅಲ್ಲ mandamus ಅಲ್ಲ, I can come before your lordship
No,
again.
sir,
for a
ನೀವು ಈ
fresh-
ಕಡೆ
ಅಲ್ಲ, fresh writ petition.
ನೀವು ಈ ಕಡೆ ಬಂದ್ರೆ
ಅಲ್ಲ,
ಪರವಾಗಿಲ್ಲ,
that is
ಹಂಗಂತ ಈಗ ಬಂದ್ಬಿಡ್ಬೇಡಿ ಈ ಕಡೆ.
That is not necessary when your lordship exercising power under 227. ಅಲ್ಲ, why there should be multiplicity of proceedings again?
ಮಲ್ಟಿಪ್ಲಿಸಿಟಿ ಎಲ್ಲ, ಯು ಕ್ಯಾಂಟ್ ಪರ್ಫಾರ್ಮ್ ಯುವರ್ ಮ್ಯಾರೇಜ್ ಇನ್ ಹಿಶಾಮಿಯಾನ.
No, your lordship, because that prayer arises out of his prayer.
I have only set aside the injunction
No,
order because
you-
that is the only thing under challenge.
No, my lord, that is because your lordship has held that commission has got a power that I.
Definitely, sir, you already
No,
take, ಅಲ್ಲ ಅಲ್ಲಿ
the power of the-
29ಕ್ಕೆ
I am not
ಇನ್ಸ್ಪೆಕ್ಟ್ ಮಾಡ್ತಾರೆ,
My lord, I am
ಇನ್ನೂ ಆ
not-
ರಿಪೋರ್ಟ್ ಬಂದಿಲ್ಲ, ಆಗ್ಲೇ ಸೂಟ್.
Sir, I am not disputing the power. What I am praying your
If this
lordship
is permitted, the civil courts will be again flooded, LB court will become khali.
At least direct the commissioner to dispose of the, as early as possible. That
Mandam-
one line will save all the trouble for
Mandamus,
both the parties.
Next court mandamus.
ಅಲ್ಲ, for both the parties.
Next court ಅಲ್ಲಿ ಒಂದು mandamus ಹಾಕ್ತಾರೆ.
I leave it to all.
Yes.
Hearing on IA 40.
I am not going to grant time at all in these vacating stay matters. Don't seek time.
No.
Yes. Hmm. Attachment warrant.
Yes.
What's wrong with it? It's a matter of evidence.
Yes, my lord.
ಮತ್ತೆ?
We've produced memo of calculation where it states that we've paid the entire
I will
amount.
direct the court to consider everything and pass orders.
Yes, my lord.
ಅಷ್ಟೇ, 3 ವರ್ಷದಿಂದ ಇದಕ್ಕೆ ಸ್ಟೇ ಇದೆ.
Unconditional order.
ಮತ್ತೆ? Yes. Sorry, I thought you're coming for asking time.
No.
The petitioner is before this court calling in question an order dated 31/1/2023 passed by the concerned court in execution petition 414 of 2022. Heard so and so. The petitioner your chit funds, Allah?
Yes, my lord.
The petitioners are said to be judgment debtors. They avail the benefit of certain chits from Mannapuram Chit Karnataka Private Limited, the respondent, the decree holder. On the default, it transpires that a suit in OS
No, my lord, arbitration award.
on the default, it transpires that the dispute was arbitrated between the arbitrated and an amount of rupees 4 ಎಷ್ಟದ award
2,84,737.
and an amount of rupees 2 lakh. Where do I get? ಎಲ್ಲೋ ನೋಡಿದ್ನಲ್ಲ,
I'll pass the award, my lord.
ಕೊಡಿ. ಅವಾರ್ಡ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ವಾ ಮೇಡಮ್?
We've produced memo.
ಪೇಜ್ ಹೇಳಿ ಮೇಡಮ್. ಪಾಸ್ ದಿ ಫಾಲೋಯಿಂಗ್
Oh, my lord.
ಅವಾರ್ಡ್ ಅಂತ ಹೇಳಿ ಒಂದು ನಿಮಿಷ ಇಲ್ಲಿ quote this award. So the petition is preferred on the petitioners, the judgment debtors in execution 414 of 2022 produce a memo of calculation. According to the counsel for the petitioner, the petitioners have already paid rupees 10 lakhs and there is nothing remaining to be paid in the execution. Notwithstanding the memo of calculation, the concerned court issues an attachment warrant which has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner would vehemently contend that there is nothing to be paid as the memo of calculation was filed before the court and the concerned court, without even looking into it, has issued a attachment warrant. The learned counsel appearing for the respondent would now submit that the concerned court be directed to consider the memo of calculation also and pass necessary orders in accordance with law. The learned counsel for the petitioner would submit that if such an order would be passed, it would suffice for the present. In the light of the said submission, the concerned court shall now consider the memo of calculation that is filed before it by the judgment debtors and then arrive at a conclusion whether the amount was completely paid or the award is still executable. In that light, I deem it appropriate to dispose the petition with the following order. The order dated so and so stands quashed. The matter is remitted, stands quashed since the proceedings are pending in execution 414 of 2022 before the concerned court. The concerned court shall now look into the memo of calculation and then pass necessary orders in accordance with law. Ordered accordingly. Attachment warrant illa.
41.
Appear for petition.
Yes, sir.
Defendant's writ petition, when an application filed under Article 26 rule 9 is being allowed.
Yes, sir.
Appointing court commissioner to measure the property.
Mm.
Lord and Lord, the prayer, Lord, they sought the property to measure, Lord.
Suit for?
Suit for a declaration and mandatory injunction.
Mm.
It's allegation that Lord, 5 feet into 200 feet is Lord is encroached. Lord, in a plaint, Lord, they've sought Lord A and B schedule property.
Mm.
But they file an IA to Lord measure their own property,
Mm.
of which the court has been granted. Lord, in a memo of Lord instruction, they have filed Lord wanted to Lord measure the property of the defendant. Lord,
Yes, madam.
kindly see Lord.
Yes, madam.
My lord, this is an agricultural property, my lord. It has to be, the property has to be measured.
Why?
Because there was, without the
Who
assistance
is
of
the
the
plaintiff?
technical. Plaint,
You are the plaintiff.
yes, my lord.
You don't know
Plaintiff
what
are the
measurement
plaintiff.
property
My
is?
lord,
Anything else?
I have given the,
Anything else, madam? Idak more varsha stay. Yes.
my lord. My
Petitioner.
lord, one
Yes.
submission, my lord.
Yes, madam.
His contention, he has taken a
2009 suit
contention.
early 2023, you file an application in 26/9 at the stage of arguments. It should not have been entertained at all.
My lord.
Nim property
His
nimge gottilla andre, what is the use?
No, my lord, he is a subsequent purchaser. It is
Maybe,
an
madam,
ancestral property,
you are the
my lord.
plaintiff, you have filed an application to measure your own property.
My lord, he has, in this writ petition, he has sought for measurement of his property also, my lord. He has no objection for measuring his property also. So entire dispute will be resolved if both the properties are measured, my lord.
I have not filed any application to seeking a measure.
What application? He has filed an application?
No, he has not filed.
Then what?
But he has filed a memo of instructions only, he has sought.
Well,
Like the
have
property
you
of
sought?
the,
Memo
yes,
of instruction ಅವ್ರು ಕೊಟ್ಟಿರೋದು ಅವ್ರು ಇದರಲ್ಲಿ ನನ್ನ ಪ್ರಾಪರ್ಟಿ
he has also filed.
in IA they have not filed. In IA they have not sought.
Report is already filed before the court, is it?
No, it's
Measurement
not
ಆಗಿದೆ.
measurement.
Hmm. Yes, anything else, madam? Ashana?
My lord. He himself has sought for the measurement
Tell
of
us,
his property also.
I don't find that at
I
all.
don't,
I don't find
my
that.
lord, the entire dispute will not be resolved, my lord. If the
it
property is not
it-
measured and if the technical.
It's surprising that you want to measure your own property in your own case, saying that you don't know the measurements.
My lord, I have produced the document of 72 also, my lord.
Declaration weak ಆಗ್ತಾ ಹೋದಂಗೆ ಇವೆಲ್ಲ ಶುರು ಆಗುತ್ತೆ.
Only the, with respect to the B schedule property, fine to 200
Thank-
feet has been
No,
encroached, my
madam.
lord.
Yes. And it is stayed for the last 3 years here.
Yes, my lord, I'm
Suit is
seeking
of
for the-
2009.
Yes, my lord. That is the reason I wanted.
No.
Entire dispute will be resolved, my
Nothing,
lord.
nothing. That's why I posted all these. The buck should stop here. Yes. The petitioner, the defendant number 1D in OS 2092 of 2009 is before the court calling in question an order of the concerned court dated 16/2/2023 by in OS 16/2/2023, whereby the concerned court allows an application filed under Order 26 Rule 9 by the plaintiff seeking measurement of the plaintiff's property is the heard sounds. A suit is instituted by the respondent plaintiff in OS so and so seeking declaration and mandatory injunction against the petitioner. This suit progresses in terms of law. At the time when the matter was posted for its judgment, the plaintiff comes up with an application in I-11 for I-11 seeking appointment of a court commissioner under Order 26 Rule 9 to measure the suit schedule property. The concerned court allows the application despite the objections filed by the present petitioner, as also the fact that the matter was posted for its judgment and the application so filed results in restoring the matter for a clarification in terms of the IA. The learned counsel for the this is what has driven the petitioner defendant to this court in the subject petition. The learned counsel for the petitioner would reiterate the contents of the objection filed before the concerned court, seeking on the application so filed by the plaintiff. The objections, notwithstanding the objections, the court has allowed the application and appointed a commissioner to measure the plaintiff's own property, own suit schedule property. The learned counsel would submit that when the matter was reserved for its judgment, the application comes to be filed. In that, the counsel would seek quashment of the proceeding of the order so passed. Counsel for the respondent would vehemently refute the submission in contending that the petitioner is a subsequent purchaser and therefore it was necessary for an appointment of the commissioner to resolve the dispute. Without the report of the commissioner, the dispute would not get resolved and the suit would languish. In that light, the learned counsel seeks dismissal of the petition. I have given my anxious consideration. It is an admitted fact, the suit is of the year 2009, in OS 2092 of 2009. 14 years passed by. The matter was, the trial progressed and the matter was reserved for its judgment. When the matter was reserved for its judgment, the application in IA-11 comes to be filed by the plaintiff, which is allowed, comes to be filed by the plaintiff. The reason for seeking the appointment of the commissioner as found in the affidavit of the plaintiff is as follows, page 31. The defendant then objects to the same on the score that the matter was reserved for its judgment and only to drag the proceedings, the application is preferred. The objection would read as follows, page 34-35. The concerned court, notwithstanding the objections and the fact that the matter was at the stage of matter was reserved for its order, on relying on judgments that would not be applicable to the facts of the case, allows the application to appointing a court commissioner to survey the suit schedule properties and report the same. As observed here in above, the suit was for declaration and mandatory injunction. The plaintiff, the application filed by the plaintiff and the matter was reserved for judgment ought not to have been entertained by the concerned court, the entertainment of which is on the face of it illegal. The order, that is order passed by the concerned court, does not reflect even semblance of a reason as to why the application is to be allowed and the measurement of the property is necessary. Ostensibly, it is preferred at the stage at which it is preferred only as a ruse to drag the proceedings. In that light, the order is rendered unsustainable and the unsustainability of which would lead to its obliteration. Petition is allowed so and so quashed. Since the matter is of the year 2009, I deem it appropriate to infuse finality into this suit. The concerned court shall endeavor to conclude the proceedings within an outer limit of 2 months from the date of receipt of the copy of the order, as the matter was already reserved for its judgment. Yes, next.
42.
Before respondent.
8 ವರ್ಷ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಸರ್?
I came on record in the year 2018. 2014 matter. ಅಂದ್ರೆ ನನ್ನ ರೆಕಾರ್ಡ್ ತಂದಿದ್ದು 2018.
ಕರೆಕ್ಟ್ ಸರ್. ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದು 22 ಅಲ್ಲಿ.
ಅಪ್ಲಿಕೇಶನ್
4 ದಿನ ಅಲ್ಲ, 4 ವರ್ಷ ಡಿಲೇ.
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ 23 ಅಲ್ಲಿ.
ಪೀರಿಯಡ್ ಇತ್ತು.
ಕೋವಿಡ್
ಪಬ್ಲಿಕ್
18 ಅಲ್ಲಿ ನೀವು ಬಂದಾಗ ಕೋವಿಡ್ ಇನ್ನೂ ಬಂದಿರಲಿಲ್ಲ ಸರ್.
ಬಂದಾಗಿರ್ಲಿಲ್ಲ, ಆದ್ರೆ ರೆಕಾರ್ಡ್ಸ್ ತರಬೇಕಿತ್ತು. I am produced several documents on 17/4/25 before this court, my lord. On these sources, I am seeking amendment of my return statement.
No, sir.
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ, ಜೊತೆಗೆ ಡೇಟ್ ವೈಸ್ ಕೂಡ ಇದೆ ಸ್ವಾಮಿ, ಸಿನಾಪ್ಸಿಸ್ ಮಾಡಿದ್ದೀನಿ ಯಾವತ್ತು ನಾನು ಪಬ್ಲಿಕ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇಂದ ರೆಕಾರ್ಡ್ಸ್ ತಂದಿದ್ದೀನಿ ಅಂತ ಹೇಳಿ. ವೆರಿ ಸೇಮ್ ಸಿಮಿಲರ್ 6 Rule 17 application, it was allowed by the senior division in OS number 3/2014. OS number 3/2014.
ಯಾವ್ದದು?
ಅದು ಕಾಂಪ್ರಿಹೆನ್ಸಿವ್ ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಇನ್ಕ್ಲೂಡಿಂಗ್ ದಿಸ್ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಸ್ವಾಮಿ.
Yes, sir.
My lords, the suit is of the year 2014, my lords.
ಆಯ್ತು.
Application ಅಲ್ಲಿ there is no mention about due diligence, my lords, and the
Correct.
amendments that are sought for, my lords, in this petition, my lords, are of no use, my lords, in adjudicating this case.
Suit for?
Permanent injunction, my lords. My lords, the amendments that are sought for in this petition, my lords, are useful for him in the declaration suit.
Another suit is pending, is it?
Another suit is pending, my lords.
It is filed by this petitioner for seeking for my lord partition, including the 17 scheduled property ಗಳು ಕೂಡ, ಜೊತೆಗೆ ಇದು ಕೂಡ
ಅಲ್ಲಿ ಕೇಳ್ಕೊಳ್ಳಿ.
Yes, my lord, ಅಲ್ಲಿ ಕೇಳಿದ್ದೀನಿ, ಅದು ಹಲೋ ಆಗಿದೆ. Very same contention I am taken in my return statement as a defense. So they having every right to file rejoinder ಮತ್ತೆ ಅದ್ರ ಮೇಲೆ ಎವಿಡೆನ್ಸ್ ಕೂಡ ಮಾಡಬಹುದು. My lord, ನನ್ನ co-personal ಪ್ರಾಪರ್ಟಿ ಇಲ್ಲಿ ಅವರು ಇಂಜಂಕ್ಷನ್ ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. ಹಾಗಾಗಿ ನಂದು ಡಿಫೆನ್ಸ್ ಇಲ್ಲೇನು ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಅಲ್ಲಿ ತಗೊಂಡಿದ್ದೀನಿ ಅದನ್ನೆಲ್ಲ ಕೂಡ ಇಲ್ಲಿ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಸ್ವಾಮಿ.
Tagging of the case, which is that suit?
My lords, OS
Documents number ಕೊಟ್ಟಿದ್ದೀನಿ
3 of 2014, my lord.
3 of
2014.
that is declaration, huh?
That is suit for declaration that is filed by him, my lord.
Page
Moreover,
number
my lords,
104.
my lords, the petitioner, my lords, he had filed a suit for permanent injunction in the year 1999
Additional
with
document.
respect to the same survey number which was rejected.
Now, Somana,
Please,
listen. This, you said it is to drag the proceedings.
Please, my lord.
2 ವರ್ಷದಿಂದ stay ಇದೆ ಇಲ್ಲಿ.
My lord, I
ಅದೇನು?
filed my vacating
ಅಲ್ಲ
application.
ಅದೇನು?
My lord, the matter.
ಮತ್ತೆ ಈಗ 2 ವರ್ಷ ಡ್ರ್ಯಾಗ್ ಆಗಿದೆಯಾ ಸುಮ್ನೆ? ಇಷ್ಟೊಂದು ಸೂಟೇ ಮುಗ್ದೋಗಿರೋದು.
Application cannot
ಅಲ್ಲ
be-
ಸೂಟೇ
my lord,
ಮುಗ್ದೋಗಿರೋದು.
not a mention about due diligence in this application, my lord. It is covered by the judgment of Honorable Supreme
No,
Court.
I have myself held, sir, due diligence ಇರ್ಬೇಕು ಅಂತ, that's a different
ಅಲ್ಲಿ
thing.
mention ಮಾಡಿಲ್ಲ, ಏನ್ due diligence ಇದೆ, ಯಾಕೆ?
Where is the application?
Application page number.
My lord, in this application also, my lord, he says that the amendments that are
120,
sought for
Annex
are helpful
D.
for him in the suit which is filed there 2014, declaration suit. only.
Where is that, sir? Where is
Page
the
number
application?
120.
120, my lord.
Annex D.
120.
125 is the affidavit, my lord.
ಈ scheduled
Lord,
property
para
ಕೂಡ
4,
not
my
to
lord.
cut and remove the standing trees, so not to alienate the scheduled properties ಅಂತ ಹೇಳಿ ಕಾಂಪ್ರಿಹೆನ್ಸಿವ್ ಸೂಟ್ OS 3/2014 ಅಲ್ಲಿ ಹಾಡು ಕೂಡ ಇದೆ ಸ್ವಾಮಿ. They are not challenged. ಅದಾದ್ಮೇಲೆ ಅಲ್ಲಿ ವಕಾಲತ್ತಾಗಿ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಾದ್ಮೇಲೆ ಈ ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ ಅವರು.
My lord, page 126 of his affidavit, my lord. Para 4, my lord, that I submit that after filing my return statement in this suit, I have made inquiry. Para 3, my lord. I submit that earlier there was no declarative relief in my original suit number 3 of 2014. Recently, I added the declarative relief in the said suit. My original suit was amended by me as per the court order recently as such. As such, in order to bring fresh and additional defense and facts, and it is subsequent to my return statement as such now filing this amendment application.
Which is this suit 3 of 2014?
That's a suit
It is
for
for
declaration
partition
filed by him.
This
my
is
lord.
366 of 2000, injunction.
Injunction.
ಇಂಜಂಕ್ಷನ್ಸ್ ಅದು ನಮ್ದು ಕಾಂಪ್ರಿಹೆನ್ಸಿವ್
ಅದ್ರಲ್ಲಿ ಇದೆಯಲ್ಲ?
ಇದೆ ಸ್ವಾಮಿ.
ಇದೇನ್ ಬೇಡ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಯಾಕಂದ್ರೆ ನನ್ನ ಡಿಫೆನ್ಸ್
ನಿಮ್ ಪ್ರಕಾರನೇ ಇದೇನ್
ಇದು
ಬೇಕಾಗಿಲ್ಲ.
ನಂದು ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ನಂದು.
ಅಲ್ಲ ಆಯ್ತು, ಅದ್ರಲ್ಲಿ ಇದೆಯಲ್ಲ, ತೊಂದ್ರೆ ಇಲ್ಲ.
ತೊಂದರೆ ಇದೆ ಸ್ವಾಮಿ, ಸ್ಟೇ ಕೂಡ ಇದೆ. ಹಾಗಾಗಿ
ಯಾವ್ದ್ರಲ್ಲಿ ಸ್ಟೇ ಇದೆ?
OS 3/2014 ಅಲ್ಲಿ ನಾಟ್ ಟು ಕಟ್ ಅಂಡ್ ರಿಮೂವ್ ದಿ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಟ್ರೀಸ್ ಆನ್ ದಿ
ಸರಿ, ಮತ್ತೆ it's in your favor.
ಅಂತ ಇದೆ.
In your favor, then
ಡಿಫೆನ್ಸ್
why do-
ಮತ್ತೆ ಇಲ್ಲಿ ಮತ್ತೆ ಅಲ್ಲಿ ಪ್ಲೀ ಅಂತ ಹೇಳಿದ್ವಿ, ಅದು ಡಿಫ್ರೆಂಟ್ ಆಗ್ಬಾರ್ದು ಅಂತ ಸ್ವಾಮಿ. ಇದು ಕೂಡ ಈ 3 ನಲ್ಲೂ ಕೂಡ ರೀಸೆಂಟ್ ಆಗಿ 6 Rule 17 ಅಲ್ಲಿ ಹಲೋ ಆದ್ಮೇಲೆ ಮತ್ತೆ ನಾವ್ ಇಲ್ಲಿ ಬಂದು ಕೇಳಿರೋದು.
ಅದ್ರಲ್ಲಿ 3 ಅಲ್ಲಿ ಅಲೋ ಆಯ್ತಾ?
ಹೌದು ಸ್ವಾಮಿ, ಹಲೋ ಆದ್ಮೇಲೆ
ಯಾವಾಗ?
ಮತ್ತೆ ಇಲ್ಲ ಹಾಕಿದ್ರು. ವೆರಿ 2023 ನಲ್ಲಿ
ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್
ಹೌದು ಸ್ವಾಮಿ, ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್
ಅಲ್ಲ,
ಅಲ್ಲ,
ಪ್ಲೇಂಟ್ ಅಮೆಂಡ್ಮೆಂಟ್.
ಸ್ವಾಮಿ ಅದು ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ. ನಾನು ಪ್ಲೇಂಟ್ ಕಾಪಿ 120 ನಲ್ಲಿ ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ರೀಸೆಂಟ್ ಆಗಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ, ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಅದ್ರಲ್ಲೆಲ್ಲ ಕೇಳಿದಿರಲ್ಲ, ಈಗ ಅಮೆಂಡ್ ಆಗಿದೆಯಲ್ಲ ಪ್ಲೇಂಟ್
ಆಗಿದೆ ಸ್ವಾಮಿ.
ಇದರಲ್ಲಿ ಯಾಕೆ ಸುಮ್ನೆ
ಅಲ್ಲ ಆಗಲ್ಲ
will go on.
ಡಿಫೆನ್ಸ್ ಡಿಫರೆನ್ಸ್ ಆಗುತ್ತೆ, ಪ್ಲೀ ಇಲ್ಲ ಅಂತ ಬೇರೆ ಬೇರೆ ವರ್ಷನ್.
That's a comprehensive suit for declaration and injunction.
ಫೈಲ್ ಮಾಡಬಹುದು,
Sir,
ಎವಿಡೆನ್ಸ್ ಲೀಡ್ ಮಾಡಬಹುದು.
you are the plaintiff in that 3 of 2014,
ಹೌದು.
correct?
Awesome.
Declaration and injunction is a comprehensive suit.
Yes, ma'am.
Why you are a defendant in this injunction suit?
Awesome.
He will prove whatever he wants. Ali declaratory suit ಅಲ್ಲಿ ಮಾಡ್ಕೊಳ್ಳಿ. This will not come in the way at all. Yes.
ಇಂಟೆನ್ಷನಲ್ ಪ್ರಾಪರ್ಟಿಗಳಿಗೆ ಸಂಬಂಧಪಟ್ಟಂಗೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇರಲಿಲ್ಲ ಸ್ವಾಮಿ, ಅದರಲ್ಲೂ ಕೂಡ ಸೆಕ್ಯೂರ್ ಮಾಡಿ ಆಡ್ ಮಾಡಿದ್ವಿ.
ಎಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ anterior to the institution of the suit itself.
ಅಲ್ಲ ಹಾಗಾಗಿ ಅಲ್ಲ, ಅದು ಕೂಡ ರೀಸೆಂಟ್ ಆಗಿ 22 ಆದ್ಮೇಲೆ
ನೀವು
ಡಾಕ್ಯುಮೆಂಟ್ಸ್
ಪ್ರೊಕ್ಯೂರ್ ಮಾಡಿದಾಗ ಅಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ ಆಗದು.
ನಮ್ಮ ಹತ್ರ
You
ಇರಲಿಲ್ಲ.
should show due diligence at the
And
time of,
family,
at the time of filing the written statement.
ಅಲ್ಲ ಅವತ್ತೇ ಇರಲಿಲ್ಲ ಸ್ವಾಮಿ.
Written statement ಯಾವತ್ತು
ಕೂಡ
ಹಾಕಿದ್ವಿ?
ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿದ್ವಿ.
ಅಲ್ಲಿ ಮಾಡಿದಿರಲ್ಲ.
ಇನ್ ಇಯರ್ 2018 ಸ್ವಾಮಿ. ನಾವು ರೆಕಾರ್ಡ್ ಇವ್ರು ತಂದಿದ್ದು, ನಾವು ರೆಕಾರ್ಡ್ ತರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರ ಸಮಸ್ಯೆನೇ ಇರ್ಲಿಲ್ಲ. ನಮ್ನ ರೆಕಾರ್ಡ್ ಅವರೇ ತಂದಿದ್ದು, ನಮ್ಮ ಅವಶ್ಯಕತೆ ಇರ್ಲಿಲ್ಲ ಅವತ್ತು.
Your purchasers?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಕೋಪಾಡ್ಸ್ತಾರ. ನಮ್ಮ 2018 ನಲ್ಲಿ ರೆಕಾರ್ಡ್ ತರ್ತಾರೆ, 2014 ನಲ್ಲಿ ಅವ್ರು ಸೂಟ್ ಫೈಲ್ ಮಾಡಿರೋರು ಬೇರೆ ಮೇಲೆ. ಆ ಊರ್ನಲ್ಲಿ ಆಲ್ಮೋಸ್ಟ್ 20% ಜನಗಳ ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ.
2004. Will direct both the suits to be taken up, tried together.
ಆಗ್ಬೋದು.
It solves the problem.
The application cannot be allowed, my lord, but in my lords, in this suit, my lords, is defendant number 7, my lords. He had filed a suit
24
for
items
injunction
scheduled
in the year
property
1999 pertaining to same survey number, which was dismissed against him.
No, let
Now,
the,
my lords, have made him party in this suit, my lords, because my lords, he is instigating other neighbors, my lords, to interfere in my possession of the property.
Yes.
That is the only reason, my lords, we are
The-
party in this
the
suit, my lords.
petitioner,
ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲಿ 24
declaratory suit ಎಲ್ಲ,
ಇನ್ನೂ
declaratory suit ಅಲ್ಲಿ ಎಲ್ಲ
ಹೆಸರಲ್ಲಿ RTC mutations ಗಳು ಇವೆ
the
ಸ್ವಾಮಿ.
petitioner defendant 7B, C, D are at the doors of this court calling in question an order dated 20th July 2023 passed in OS 366 of 2014 rejecting an application filed by the petitioner under Order 6 Rule 17 seeking amendment of the written statement. The heard so and so. The petitioner, the respondent plaintiff institutes the subject suit in OS 366 of 2014 against respondents 10 to 22, seeking injunction in respect of the suit schedule property. The defendants 4, 7 and 8 filed their written statement on 9/10/2015. The seventh respondent dies during the proceedings and the legal representatives are brought on record. An amendment is filed. The legal representatives who come on record file their written statement, legal representative who come on record, the present petitioners file the written statement on 20th July 2019. The examination and cross-examination of the parties get concluded. On 19/6/2023, 4 years after filing of the written statement and 9 years after institution of the suit, the application comes to be filed seeking to amend the written statement. The amendment sought for in the written statement was to bring in certain records which the defendant had already bought in a comprehensive suit of declaration and mandatory injunction in OS 3 of 2014, in which the respondent is the defendant. The concerned court rejects the application on the score that it is in violation of it does not satisfy the rigor of proviso to Rule 17, which needs due diligence to be exercised by the parties while filing the written statement or the plaint, as the case would be. The rejection of which has driven the petitioner to this court in the subject petition. The learned counsel for the petitioner would reiterate the grounds urged in the application and seek that the application be allowed as it is that the plaint is already amended in OS 3 of 2014 instituted by the present petitioner. The learned counsel appearing for the respondent would take this court through the affidavit filed by the petitioner seeking amendment. Seeking amendment to contend that it would not be of any use for him to amend the written statement filed in the subject suit as the affidavit itself indicates that it would be useful in suit OS 3 of 2014. He would seek dismissal of the petition. I have given my source. The aforenarrated facts are not in dispute. The timeline of filing the application seeking seeking amendment is 9 years after the institution of the suit and 4 years after the written statement being filed by the very petitioners. The affidavit in support of the application under Order 6 Rule 17, insofar as it is germane, reads as follows, page 126. It is an admitted fact that the present petitioner has instituted a suit in OS 3 of 2014 seeking declaration and permanent injunction. The plaintiff in the subject suit is the defendant in the said suit. In the said suit, all these factors have already been brought on record by way of an amendment to the plaint, which has been allowed. Noticing the said facts, the concerned court has rejected the application for want of due diligence. I do not find any warrant to interfere with the order so passed by the concerned court in exercise of my jurisdiction under Article 227 of the Constitution of India. More so, in the light of the affidavit of the petitioner himself, that it is useful in OS 3 of 2014. In that light, no fault can be found with the order so passed by the concerned court. Petition lacking in merit stands rejected. Next.
43.
Petitioner in this case. Petitioner, my lord, filed application under Art 22 Rule 4. The trial court was rejected my application. On the ground that, my lord,
second wife children.
Second wife children. They are also entitled for share in the properties, my lord.
First, ಅದು ಪ್ರೂವ್ ಆಗಿದೆಯಾ ನೀವು ಸೆಕೆಂಡ್ ವೈಫ್ ಚಿಲ್ಡ್ರನ್ ಅಂತ?
Second wife, my lord.
ಯಾರು ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ?
ಅಲ್ಲ ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿಲ್ಲ ಅಂದ್ರೆ ಈ
ಅಲ್ಲ ಯಾರು ಎಲ್ಲಿ ಸೆಕೆಂಡ್ ವೈಫ್ ಚಿಲ್ಡ್ರನ್ ಅಂತ ಪ್ರೂವ್ ಆಗಿರೋದು ಎಲ್ಲಿ?
Father himself was contended before the trial court, stating that the non-joinder and misjoinder of the suit parties to the suit itself is not maintainable. At page
where is that? ಎಲ್ಲಿದೆ?
Page 63, para 63, page number 52.
ಈಗ now the application is rejected ಅಲ್ವಾ? Correctly rejected. Yes.
I think kindly, my lord, Supreme Court, my lord.
Supreme Court ಕೊಡಿ ಸರ್. Suit for partition.
Partition.
Partition ನೀವು ಹೆಂಗೆ ಸರ್ ಬರ್ತೀರಾ?
ಅಲ್ಲ even, my lord, the non-joinder of parties, my lord, the Supreme Court
Non-joinder
says,
of
my lord,
proper and necessary parties. ಸುಮ್ಮನೆ non-joinder
once
ಅಲ್ಲ.
the non-joinder of and misjoinder of parties is
that is the law, sir.
ಅಲ್ಲ
But proper and necessary ಇರಬೇಕು. Non-joinder ಅಂದ್ಬಿಟ್ರೆ ಎಲ್ಲದಕ್ಕೂ ಆಗಲ್ಲ.
Even the children born out of void and voidable marriages, my lord, they are entitled
Where
for
is
shares.
it? Where is it shown, sir? ನೀವು ಎಲ್ಲಿ which
So
is?
he himself is admitted. First defendant himself is admitted.
Where
At page number
where is that?
63, my lord. Para 63, page number 52, my lord.
Para 63, page 52.
Page 52. The first defendant has contended in his written statement that.
Page 52.
Page 52.
The first defendant
Contended in his written statement that the suit is bad for non-joinder of necessary parties. This suit is having other 3 children, namely Sneha, Teja and Sweetie, and further contended that since purchases of the suit property item number 1 to 3 have not been made as a party, subsequent to filing of written statement, the plaintiff has impleaded the purchaser as a defendant number 4 to 10.
Which is this suit decree ಆಗಿರೋದು?
Suit properties are the self-acquired properties of the father, my lord.
ಅಲ್ಲ what is this OS 189 of 2006?
189 is that's only the preliminary decree, my lord. Now, my lord, during the
FDP ಇಲ್ಲ ನೀವು ಬರ್ಬೇಕು ಅಂತ.
FDP, when the first defendant was died, we filed application for bringing the LRs of first defendant, my lord.
Now the decree in whose suit is dismissed with respect of item 347.
And the appeal is also pending before this honorable court, my lord. Appeal is pending still.
So
RSA number 505 of 2015. And one more appeal is filed by the purchaser, 303 of 2015.
Yes, sir.
That your lordship may kindly see that Annexure D, Malad. Annexure D, they have filed the application for order 1 rule 10, Malad. That was rejected, Malad. And he has not challenging that order, Malad.
22 for subsequent application is challenged.
Subsequent application is challenged, Malad. That in a similar application filed in regular appeal, Malad. So that suit was filed in the year of Malad
No, what is, there are two proceedings pending before this court?
Yes, brother.
Please.
Pending.
RSA.
RSA is pending, that. No interim order has been granted, that. And moreover, that commissioner has also completed his work and submitted the report, that. At the time of that, that made an this application. Earlier order rejected by the same court, that. Your lordship may kindly see annexure D, that. Page 80.
No, ಅದರಲ್ಲಿ ಅವ್ರದ್ದೇ, the first defendant himself has said so in 2006 suit.
They have taken contention. My father has taken contention, that. That non-joinder, that is how, why they are kept quiet, that in the suit, that. At the flag end of the FDP proceedings, that they have come up this application. For a kindly moment, that your lordship may kindly see annexure D, that. Detailed order has been passed by the trial court on order 1 rule 10, that. That para 6, that.
What was pending, they are minors.
Para 6, that, page 86, that. It is seriously opposed by the petitioner in FDP proceedings. According to them, already they have denied the relationship proposed legal heirs with respond number 1. This is what, may I got it, that? 86,
there, yes.
This is YV Gopinath. Hence, they are not necessary parties to the present final decree proceedings. Further, according to petitioner, her mother, Sri Hamshavani, is legally wedded up with the respond number 1. Though there was several proceedings between the parties, nowhere the proposed respond number 12 has been declared as a wife of YV Gopinath. Further, according to petitioner, Srimati Asha herself, G. Rekha, respond number 3, Deepak, are children of YV Gopinath, and his wife, Srimati Hamshavani. Hamshavani, respond number 1 is in the present proceedings. The respond number 11 is also opposing IA number 11 by filing their objection. As contended by the first petitioner, it is also opposed by the respond number 2 and 3. That proposed legal heirs of the
ಇದು FDP ಅಲ್ಲೇ ಹಾಕಿದ್ದ?
FDP ಹಾಕಿದ್ದಾರೆ. That was rejected by the trial court, that was not challenged by the present petitioners, and subsequently they filed the application,
Same petitioners ಅವಾಗ ಹಾಕಿದ್ದು?
Same petitioner, that they filed an application, that at page 83.
Yes, sir.
That was not questioning that, Similar that similar contention, the provisions is changed, that. All the contents are same, that.
Yes, sir.
Contentions are same, my lord, because, my lord, they are minors at the time of filing.
Minors, sir.
No, by the time,
24, 22, 20 minors.
Suit was filed, my lord. When the suit was filed. After that, my lord, subsequently when the suit was decreed and the FDP proceedings was filed by the the petitioner, my lord, the first defendant was died.
Everything will be subject to the appeals, sir. Pending.
My lord, they have partitioned the properties, my lord, in the FDP proceedings. Their right will be curtailed, my lord. That's why, my lord, I am a necessary party in the FDP proceedings. Otherwise, my lord, it may be stayed till the RSA second appeal is decided, my lord.
That what their contention, issue number 3, the non-joiner of lesser party, that issue was already against them, that.
He himself
That's
is
all right,
admitted,
sir.
first defendant is admitted that
We are on
children
question
born
of
through second
rights
wife.
of the parties. ಅವರು ಮುಂಚೆ ಮಾಡಿಲ್ಲ, ಆಮೇಲೆ
Regular appeal is pending, that.
Even, my lord, the share
regular
is not.
ಒಂದ್ ನಿಮಿಷ ರೆಗ್ಯುಲರ್ ಅಪೀಲ್ ಯಾವ್ದ್ರ ಮೇಲೆ?
RSA, against the RA and OS, that.
That's what
My
he
father,
challenged
my
before
father has also filed the regular appeal, that he is died, that. We are come on record in the second appeal, that. And that one of the purchaser has filed the RSA, that. That was pending. No interim order has been granted by this court, that. And during the pendency of this appeal, that they filed the application for order.
Who are
1
the
rule.
appellants in RSA?
RSA dalli that one of the purchaser, that. Yashodamma.
ಹಾ.
She has filed the.
ಇವ್ರೇನ್ ಹಾಕಿಲ್ವಾ?
My father was filed.
Allah,
My
why
father was
Gopinath has filed the
Your
appeal?
father, which father?
Ivrén appeal hakilla iವರು. My father has filed the appeal, that.
Yes, sir. Subject to
My lord,
the,
earlier
you have not
properties-
filed any appeal against the decree.
My father was filed. That's what, my
Oh,
lord, contention.
ಅದರಲ್ಲಿ
ಅದರಲ್ಲೂನು
ಅಲ್ಲ,
LR
ಆ appeal
application-
ಏನಾಯ್ತು?
LR application is also filed in the appeal also, my lord.
That is allowed?
Still
Still
is
they
pending.
pending,
Still it is
that
pending.
I seriously objected for that application, that Thereafter, it was keep pending mal that. That was not allowed by this court mal that. And thereafter, they filed the application in APDP, this application mal that. During the pendency of that application. That was rejected.
LR application ಯಾವ್ದ್ರಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ?
RSA.
RSA ದಲ್ಲಿ.
ಎರಡು ಅಪ್ಲಿಕೇಶನ್, ಎರಡು ಸೂಟ್ ಇದ್ರಲ್ಲೂ ಅಪೀಲ್ ಅನ್ನು
505 ಅಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ.
505.
505 of
2015.
18
18.
ಆಮೇಲೆ ಇನ್ನೊಂದು ಯಾವ್ದು?
ಇನ್ನೊಂದು 303 ಇದೆ. That purchaser has filed the.
ಅದರಲ್ಲೂ ಹಾಕಿದಾರ ಇವರು?
ಹೌದು.
ಎರಡರಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ. Purchaser ಅಲ್ಲಿ they have not filed any application. Only father appeal ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ. And moreover, order 110 ಇವ್ರು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ. That was rejected mal that.
All right. We'll await these proceedings subject to LR application in RSA 105 of 2018.
Please, ma.
All right.
505 ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ಅವ್ರು ನಮ್ಮ.
ಅಲ್ಲ ಯಾವ್ದ್ರಲ್ಲಿ ಹಾಕಿ 505 ಅಲ್ಲಿ.
505.
ಹೌದು.
505 ಅಲ್ಲಿ you expedite that application. We will make this dependent on that. ಅಲ್ಲಿ LR application allow ಆದ್ರೆ we will allow this. Yes. The petitioners will keep this pending.
Okay.
The petitioners are said to be
that already that commissioner work was completed.
ಎಲ್ಲ ಪರವಾಗಿಲ್ಲ. So ಅಲ್ಲಿ LR application allow ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ we will dismiss this.
ಯಾರು?
The petitioners ಅದಕ್ಕೆ ಮೂವ್ ಮಾಡಿ ಅದು. The petitioners
ಯಾರು?
claim to be the legal representatives of one Y.V. Gopinath. They file Y.V. Gopinath.
May make one submission. ಏನ್ ಇವರು ಒಂದು ಪ್ರಾಪರ್ಟಿ my father has sold the purchaser item number 1 and 2 mal that. That sale deed ಗೆ that ಶ್ರೀಮತಿ ಸುಶೀಲಾ has signed it mal that. How can it?
ಅದು ಅಲ್ಲಿ ಎಲ್ಲಾರ application ಕೇಳಿ if that is allowed then we will see.
Please.
Yes. A suit in OS 189 of 2006 comes to be instituted by the first respondent, one Srimati G. Asha, daughter of Y.V. Gopinath. The suit is decreed by granting her 1/4 share of the property. To execute the said decree, pursuant to the preliminary decree so drawn, final decree proceedings are instituted in FDP 6 of 2015. The proceedings progressed. The present petitioners file application and order 1 Rule 10 to bring them as parties to the proceedings on the score that they are the legally wedded, they are the children of the legally wedded wife of Y.V. Gopinath. Objections were filed and the concerned court rejects the application and order 1 Rule 10. Changing the provision of law, another application verbatim similar is preferred by these petitioners and order 22 Rule 24 of the CPC. The Rule 4 of the CPC. The concerned court again by the impugned order rejects the application, rejection of which has driven these petitioners to this court in the subject petition. The learned counsel for the parties would submit the original suit ended. Original suit was challenged before the first appellate court and is now pending in RSA before a coordinate bench of this court. In the said suit, in the said RSA 505 of 2015,
18 mal that. 18. 505 of 2018.
505 of 2018. The petitioners have preferred an application seeking to come on record as the legal representatives of the legally wedded wife of Y.V. Gopinath. This is objected to by the present respondents. In the light of the issue revolving around whether the petitioners would become legal representatives of V.Y. Gopinath and become entitled to certain share in the property, it is necessary for this court to hold its hands, awaiting an order on the application seeking to implead the application filed by the petitioners to implead themselves as legal representatives of V.Y. Gopinath in RSA 505 of 2018. The parties to the list shall move the matter once there is an order passed in the RSA on the application in RSA 505 of 2018. Till such time, the present order would continue.
44.
Written statement
ಏನು already changes.
Interim order is there, that I will not continue the FTP proceedings, that already.
ಅಲ್ಲ ಅದಕ್ಕೆ ಅಲ್ಲಿ ಮೂವ್ ಮಾಡಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮೂವ್ ಮಾಡಿ ಆರ್ಡರ್ ಬಂದು ವಿಲ್ ಟೇಕ್ ಇಟ್ ಅಪ್. ಎಸ್
Seniority ಅಂತಾರೆ.
ಎಸ್ ಸರ್.
Prepare for the petitioner, my lord. An application under the order 6 rule 17.
ಇನ್ ಎಫ್ ಡಿ ಪಿ
Not FDP, my lord.
ಇನ್ಯಾವ್ದ್ರಲ್ಲಿ
OS.
OS, it is a
OS
suit
ಅಲ್ಲೇ
for
ಹಾಕು.
partition.
Please.
My lord, with the leave of the court, I just point out the order dated 14/11/2024.
1 minute.
Number 33.
My lord, the respondent number 3 herein is the plaintiff.
All right.
And respondent number 4 is defendant number 2. The respondent number, they have taken dispensation of notice against these two parties by virtue of the order dated 14/11/2024. The complication in the matter is the respondent number 1 and 2 herein have filed an application under 6 rule 17 seeking amendment of their statement that came to be allowed, which has been challenged. The respondent number 2, that is defendant number 2, respondent number 4, defendant number 2, filed the return statement before the trial court. What has been sought by the respondent number 1 and 2 herein, being the defendant number 1 and 3 before the trial court, that the certain properties were.
ಅದು ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಹೇಳ್ತಾ ಇದ್ದೀರಾ ನೀವು?
I am not coming in the way. Our defendant number 2 has already pleaded about the very fact in the return statement.
ತಾವು ಹೇಳ್ಬೋದು.
ಅಲ್ಲ ನಾನು ನೀವು ಆರ್ಡರ್ ಬಗ್ಗೆ ಏನು ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲ ಮಾಡ್ಬೋದು. ಆಮೇಲೆ plaintiff ಇದಕ್ಕೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ ಫಾರ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಫ್ ದಿ plaint.
ಅದೇನಾಯ್ತು?
Yes, it is for inclusion of the very properties which are sought to be included pending.
Is that allowed?
That is pending.
Please, your lordship, may kindly just have this.
Suit for partition?
Yes.
Suit for partition.
Propositors Kodigehalli Timmappa had 2 sons and a daughter. This KT Narayanappa, second son, top-nalli, second son, filed OS number 38 of 1976. Attavu genealogy ನೋಡ್ಬಿಟ್ರೆ.
Yes.
Second son filed OS number 38 of 1976 against KT Venkatappa. Suit is decreed. Final decree proceedings are pending.
1971.
76 suit. 2002 ದಲ್ಲಿ decree ಆಯ್ತು. There is a RFA filed, but there is no stay. At the same time, FDP ಇನ್ನು ಪೂರ ಮುಗ್ದಿಲ್ಲ, FDP pending. Now, this KT Venkatappa's issues, kindly go to daughter Yallamma. KT Venkatappa has ಅಲ್ಲಿ half share each ಕೊಟ್ಟಿದ್ದಾರೆ. ಇಲ್ಲಿ ಯಲ್ಲಮ್ಮನ daughter ರತ್ನಮ್ಮ, ಲಲಿತಮ್ಮ, ಸರಸ್ವತಮ್ಮ. Defendant number 13 is the present petitioner ಇಲ್ಲಿ. This defendant number 13, kindly go to top, daughter ಅಂತಿದೆಯಲ್ಲ genealogyಯಲ್ಲಿ.
Third daughter.
ಹೌದು. Daughter of third daughter ಇನ ಮಗಳು ಇವಳು. One of the daughter of the ಕೊಡಗಿಹಳ್ಳಿ ತಿಮ್ಮಪ್ಪನ ಡಾಟರ್ ಚೆನ್ನಮ್ಮನ ಮಗಳು.
ಅಲ್ಲ ಈಗ ರಿಟರ್ನ್
ಮೊಮ್ಮಗಳು.
ಸೂಟ್ ಆರ್ಗ್ಯೂ ಮಾಡೋದ್ ಬೇಡ. ರಿಟರ್ನ್
ಇಲ್ಲ,
ಏನ್
suit ಅಲ್ಲ.
ವಾಟ್ ಇಸ್ ದಿ
Just-
ಇಶ್ಯೂ?
Just for the, unless this is noticed, it will not be possible to. ಈ KT ವೆಂಕಟಪ್ಪನ ಏರ್ಸ್ ಪೈಕಿ KV ತಿಮ್ಮಪ್ಪ ಅಂತ ಹೇಳಿ ನಾನೊಂದು ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಿ. KV ತಿಮ್ಮಪ್ಪ ಅಂತ ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಿ ತಾವು ಜಿನಿಯಾಲಜಿಯಲ್ಲಿ. ಒನ್ ಆಫ್ ದಿ ಸನ್ಸ್.
ಆಲ್ ರೈಟ್.
ಅವರ ಆ KV ತಿಮ್ಮಪ್ಪನ ಮಗಳು ಅನಸೂಯ is the plaintiff.
Correct.
ಈಗಿನ ಸೂಟ್ ನಲ್ಲಿ.
ಹೌದು.
She is the plaintiff. So she is claiming a share in the half share allotted to KT ವೆಂಕಟಪ್ಪ.
In the 1976 suit.
76 ಸೂಟ್ ನಲ್ಲಿ ಅವ್ರಿಗೆ ಹಾಫ್ ಶೇರ್ ಕೊಟ್ಟಿದ್ರಲ್ಲಿ she says she has a share. No dispute, she has a share in respect of the properties that is allotted to KT Venkatappa. Now what is done is an application, they filed WS supporting the suit. Defendants 2 and 3 are the plaintiff mother and sister. Mother and sister, they have filed WS supporting the plaintiff. All those things fine. Now an application is filed to include the properties of third daughter Channamma. Channamma's son KN Ramaya. ಮೇಲ್ಗಡೆ ಟಾಪ್ ನಲ್ಲಿ KN ರಾಮಯ್ಯ. ಈ KN ರಾಮಯ್ಯನ ಪ್ರಾಪರ್ಟಿಯನ್ನ ಈ ಸೂಟ್ ನಲ್ಲಿ ಹಾಕಬೇಕು. ಯಾಕೆ ಅಂದ್ರೆ ಅಕಾರ್ಡಿಂಗ್ ಟು ದೆಮ್ KT Venkatappa has earned those properties in Benami in the name of KN Ramaya ಅಂತ ಹೇಳಿ. That is the amendment application. We pointed out this suit has nothing to do with the KN Ramaya's property. This amendment cannot be allowed. Ultimately, the
where is the prayer in the plaint and suit schedule property in the plaint?
Please.
Plaint.
Plaint, your lordships, get it. Page 41.
41.
Prayer.
46.
Prayer is at page 110. May kindly be seen, my lord. I will read that prayer, my lord.
ಅನಸೂಯ ಎಲ್ಲಿ ಬರ್ತಾರೆ ಅಂದ್ರೆ ಇಲ್ಲಿ?
ಅನಸೂಯ ತಿಮ್ಮಯ್ಯ ಅಂತ ಹೇಳಿ KT ವೆಂಕಟಪ್ಪನ ಮಗ ತಿಮ್ಮಯ್ಯ. ನಾನೊಂದು ಎಲ್ಲೋ
KT ವೆಂಕಟಪ್ಪ.
KT ವೆಂಕಟಪ್ಪ has several daughters and sons. Right hand side ಗೆ last but third KV ತಿಮ್ಮಪ್ಪ. KV ತಿಮ್ಮಪ್ಪನಿಗೆ ಮಗಳು ವೈಫ್ ರತ್ನಮ್ಮ, ಲಾಸ್ಟ್ ಡಾಟರ್ ಅನಸೂಯ ಪ್ಲೇಂಟಿಫ್.
ನಾವು ಈಗ 1976 ಸೂಟ್ ಅಲ್ಲಿ
ಹೌದು
ದಿಸ್ KV ತಿಮ್ಮಪ್ಪ ವಾಸ್ ಎ ಪಾರ್ಟಿ.
KV ತಿಮ್ಮಪ್ಪ ಇನಿಷಿಯಲಿ ವಾಸ್ ನಾಟ್ ಎ ಪಾರ್ಟಿ, ಬಟ್ ಇವರು ಸತ್ತ ನಂತರ ಪಾರ್ಟಿ ಆಗಿದ್ದಾರೆ.
ಆಯ್ತು, ಅವ್ರಿಗೆ ಶೇರ್ ಹೋಗಿದೆ ಅದ್ರಲ್ಲಿ.
ಅವ್ರಿಗೆ ಶೇರ್ ಹೋಗಿದೆ. ಅದಕ್ಕೆ ಇಲ್ಲಿ ತಾವು ಇವ್ರ ಪ್ರೇಯರ್ ಅನ್ನು ತಾವು ಕೈಂಡ್ಲಿ ಸಿ ದಿ ಪ್ರೇಯರ್ 110.
There was a vertical division between KT Venkatappa and KT Narayanappa in the earlier
prayer.
Each was
partitioning and dividing the suit schedule properties allotable to the branch of KT Venkatappa as per the final appellate adjudication in FDP number so and so, by putting the plaintiff in her separate share and possession of her 30% share in 1/4 of the suit schedule properties allotable to the branch of KV Timmappa. So KV Timmappaniಗೆ KT ವೆಂಕಟಪ್ಪನಿಂದ ಬರಬಹುದಾದ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ ತನಗೆ 1/4 ಶೇರ್ ಬರುತ್ತೆ ಅಂತ ಅವ್ರು ಕೇಳಿದ್ದಾರೆ.
ಇದಕ್ಕೆ ತೊಂದರೆ ಇಲ್ಲ.
ಅದಕ್ಕೆ ತೊಂದರೆ ಇಲ್ಲ. ದಟ್ಸ್ ಅವ್ರವ್ರೊಳಗೆ ಡಿಸ್ಪ್ಯೂಟ್ ಇದ್ರೆ ನೋಡ್ಕೊಳ್ಬೇಕು. ಅದರ್ವೈಸ್ ಯಾರದ್ದು ಏನು ತೊಂದರೆ ಇಲ್ಲ.
ಅಮೆಂಡ್ಮೆಂಟ್ ಅಲ್ಲಿ
ಈಗ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ kindly go to page 113. 138, I'm sorry, 138, annexure E. One 142 ದಲ್ಲಿ 6B ತಾವು ನೋಡ್ಬೇಕು. 142 ದಲ್ಲಿ ಪ್ಯಾರಾ 6B. It is stated that properties annexed to the schedule hereunder, which presently stands in the name of Saraswatamma, defendant number 13, are derivable from K.N. Ramaya and her paternal grandfather Narayanappa. Narayanappa was married to Channamma, the only sister of K.T. Venkatappa. And post-marriage, K.T. Venkatappa looked after the economic welfare of his sister and her husband. ಅಲ್ಲಿ ಅದನ್ನೆಲ್ಲ ಅವರು ಅರ್ನ್ ಮಾಡಿದ್ದಾರೆ. ಬೇನಾಮಿ ಪ್ರಾಪರ್ಟಿ, ಇಟ್ ಶುಡ್ ಕಮ್ ಬ್ಯಾಕ್. ಇಫ್ ಇವ್ರು ಹೇಳೋ ರೀತಿ ಇದು ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿಗೆ ಸಂಬಂಧಪಟ್ಟ ಪ್ರಾಪರ್ಟಿ ಆಗಿದ್ದಿದ್ರೆ ಆ OS ನಂಬರಿಗೆ ಹೋಗ್ಬೇಕು.
ಬೇನಾಮಿ ಪ್ರಾಪರ್ಟಿ.
ಹೌದು.
ಎಸ್ ಸರ್.
Please, Malad, suit for partition. Ansuya has filed the suit. The defendant number 2, that is Geeta Lakshmi, had filed the return statement.
With the counterclaim.
Geeta Lakshmi, in the return statement filed by her, also taken a contention. The properties now were to be included by way of amendment to the return statement of defendant number 1 and 3 are the properties of the joint family. It has been inbuilt in the return statement. It is already inbuilt.
That return statement is not produced, separation.
Already produced.
That
So
return statement is not
That paragraph in the written
that
statement.
return statement has not been produced by them before this honorable court.
ನೀವು ಕೊಡಿ.
ಅದ್ರೊಳಗೆ ಇದೆಯಪ್ಪ. ಎಷ್ಟನೇ ಪೇಜ್ ಅದ ಸರ್? ನೋಡಿ ನಮ್ಮಲ್ಲಿ ತಗ
ಪೇಜ್ ಪ್ಯಾರಾಗ್ರಾಫ್.
ಎಸ್ ಮೇಡಮ್.
Page 77.
Page number 77, my lord.
77.
77.
Paragraph 77 is WS.
My lord. Page, relevant page number 79. These properties were already included in the form of counterclaim in the return statement filed by defendant number 2. So these properties are already the subject matter of the suit before the trial court.
Which suit?
Yes.
Which suit?
In the present suit.
You are the plaintiff.
I'm not the plaintiff.
You are the plaintiff. Who is?
They are brother and sister, mother and sister of the plaintiff.
Notice has been dispensed to me.
Plaintiff is
ನಾನು
dispensed
defendant
ಮಾಡ್ಸ್ಕೊಂಬಿಟ್ರು.
number 13.
Notice
Defendant
been
number
dispensed to me,
13.
Lord, I have to file my wakalat. I've just gotten notice of
TV
this
ಯಾರಿಗೆ?
matter.
Defendant number 8.
13
Defendant number 13.
8.
is the
He is
petitioner.
defendant number 8.
All right, yes.
They sought for
So this
dispensation.
written statement is filed by whom?
Defendant number 2, who is arrayed as respondent number 4. Intelligently, they have taken dispensation to this respondent as well as to the plaintiff.
No, this defendant number 4 is Shanti.
Defendant number 2.
Respondent number 4.
Respondent number 4 is Geeta Lakshmi.
Geeta Lakshmi. This
I
is,
appeal for the
this is Geeta Lakshmi's written statement.
Yes, written statement. So therefore, the proposed amendment sought to be included by way of amendment by defendant number 1 and 3 is the very statement which is already on record. They also sought for counterclaim. They were not aware of the properties, the other properties which were left out in the suit filed by the plaintiff. the plaintiff on the similar line has filed an application to amend the plaint also.
What happened to that?
It is pending.
Pending.
It is pending.
If I could make a submission, my lords. The notice has.
Mugasle, madam. Why are you in a hurry? Yes.
The application which has been filed by the plaintiff for amendment of the plaint for inclusion of the 17 properties now sought to be included by way of counterclaim by defendant number 1 and 3 made a similar application which is pending. Your Lordship, kindly, any order that may be passed by this honorable court would adversely affect the pending application made by the plaintiff and also the written statement which
Filed
has
by
been
me.
filed by the defendant number 2.
Yes.
Your Lordship, kindly say, the trial court passes an order, the relevant portion of the order which has been passed by the trial court, page number 33 at the paper 34. The relevant page 35, para number 9.
So these properties are already in the counterclaim?
Already on
No,
record.
they are not already on record. I
Already on
have the
record.
option of filing for striking down of the pleadings. There is no
And-
question of.
And they have made an application for the rejection of the plaint that came to be rejected.
Rejection of the plaint before plaintiff filed the application for amendment.
Even otherwise, the finding which has been recorded,
Muslim.
the finding which has been recorded with the trial court at page number 35, ink page number 35, para number 9. As could be seen from the records, the suit is filed by partition and separate possession, wherein the plaintiff included 69 immovable properties in the suit, alleging that the said properties are joint family properties. The defendant number 1 and 3 filed counterclaim, and now they want to add 17 properties, claiming that in which they are entitled to for partition. It is further seen from the record that the defendant number 13 totally denied the case of the plaintiff. However, upon going through the record, it is opinion that the said defendant number 1 and 3 are intending to add some more property, some more facts, along with the existing facts to seek for partition in respect in all properties. It is significant to note that the properties which the defendant number 1 and 3 want to add with their defense are the properties which are already included in the counterclaim of the defendant number 2. Therefore, the amendment with the defendant number 1 and 3 intend to make is not a new facts to the case. This is the finding which has been recorded and allowed. If the application which has been filed by us is dismissed, it will have an impact with regard to the defense already opened
My
by
written
defendant number 2.
My written statement and.
And also it will affect the application which has been filed by the plaintiff for amendment of the plaintiff. This is the situation.
Tell me.
Number 13, written statement.
And one more fact.
Even I may be given a chance to file vakalat and
Ah,
heard.
really?
I'll take necessary instructions.
One more submit, I will add one more.
After
submission.
having spent so much time, no? Yes.
And one more submission, my lord. The,
You are sailing with the petitioner.
I'm not with the petitioner, I'm the plaintiff.
Then, okay, yes, wait.
Your Lordship, kindly see at page number 171 of the, now we have produced the paper compilation containing the written statement.
170, E ಕೊಟ್ಟಿರೋದ್ರಲ್ಲಿ.
Yes, E ಕೊಟ್ಟಿದ್ದು.
170?
171. They makes an application before this court, before the trial court, that is IN number 8. Amendment. Answering the claim of defendant number 2 with regard to counterclaim properties. This application also came to be allowed on the very same day while allowing IN number 7. This has not been stated in the writ petition filed by them. They have also not stated about the application filed by the plaintiff for amendment. If any order which going to be passed in the present writ petition would adversely affect the interest of defendant number 2 as well as the plaintiff application pending consideration.
ಹಾಗಾದ್ರೆ ಏನು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡೋದು ಬೇಡವಾ?
ಅಲ್ಲ, ಏನು
Any
ಮಾಡ್ಬೇಡಿ
order,
ಅಂತ
any
ಏನು
order,
ಹೇಳಲ್ಲ.
no order should be passed ಅಂತ.
What I request is, they should also be heard. Defendant number 2 and plaintiff should also be heard before passing any order.
Anything else?
I appear for defendant number 2, my lord, I'll file my vakalat today. Name may be shown.
as regards the WS filed by defendant number 2, including these properties, I will file my application for striking down the pleadings. All those
That is
things
before the court.
that is before, that will be dealt with. Now, someone wants an amendment saying such and such a property belonging to so and so should be treated as Benami property in
My lord,
which
my
I will get
counterclaim, my counterclaim, my lord, matches, my
No,
lord,
one,
the
one,
amendment.
1 minute, Sumant.
I'm sorry.
Now, in the counter claim,
Hmm.
these properties are included.
ಆ ಕೌಂಟರ್ ಕ್ಲೇಮಿಗೆ ನಾನು ಸ್ಟ್ರೈಕಿಂಗ್ ಡೌನ್ ಕೇಳ್ತಾ ಇರೋದು.
ಅದು ಕೇಳಿದ್ ಇನ್ನು ಕೇಳಿಲ್ಲ, ಕೇಳಿದ್ರೆ ಅದು ಆನ್ಸರ್ ಮಾಡ್ಲಿ.
ಅಲ್ಲಲ್ಲ, ಇದನ್ನ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಲೋ ಮಾಡಿದ್ಮೇಲೆ ಅಲ್ಲಿ ಆನ್ಸರ್ ಮಾಡೋ ಪ್ರಶ್ನೆನೇ ಉಳಿಯೋದಿಲ್ಲ. ಕೋರ್ಟ್ ವಿಲ್ ಸೇ ಬಿಕಾಸ್ ಐ ಹ್ಯಾವ್ ಆಲ್ರೆಡಿ ಟೇಕನ್ ದಿಸ್ ವ್ಯೂ.
We will reserve liberty to do that if you want.
And can one,
ಅಲ್ಲಲ್ಲ, it is a liberty.
ಈಗ counter claim ಅಲ್ಲಿ those properties are already there. Then those properties are sought to be included now by way of an application.
ಕೌಂಟರ್ ಕ್ಲೇಮ್ ನಲ್ಲಿ ಇದ್ರೆ ಕೌಂಟರ್ ಕ್ಲೇಮ್ ಇನ್ನ ಆ ಪ್ರಾಪರ್ಟಿಗೆ ಇಟ್ ವಿಲ್ ಬಿ ಡೆಲ್ಟ್ ವಿತ್ ಇನ್ ದಿ ಮ್ಯಾನರ್ ನೋನ್ ದಟ್ ಇಸ್ ಅಂಡರ್ ಆರ್ಡರ್ 22 ಸ್ಟ್ರೈಕಿಂಗ್ ಡೌನ್ ದಿ ಪ್ಲೀಡಿಂಗ್ಸ್.
Fine.
I ask myself, my lord, can striking down, my lord, be done after filing a written statement on that counterclaim? Already done.
The court decide. I am not
The
going to
paper book,
decide
my
on
lord,
all
is-
that.
Yes, my lord, I'm
Those
sorry.
facts I am not going to decide.
sorry,
We
my
only
lord, I'm
answer
sorry.
the application whether it was
Sorry.
correct, allowing
Yes,
of it was correct or not.
Yes, my lord.
My respectful submission is a counterclaim is filed by someone pleading certain facts cannot be taken as a right, cause of action, etc. for these persons to include the property.
That we will answer. I am not on that. I only asked that counterclaim ali properties ಇದೆ because court observes that counterclaim ali properties ಇದೆ.
ಕೌಂಟರ್ ಕ್ಲೇಮ್ ನಲ್ಲಿ
They have
ಪ್ರಾಪರ್ಟಿ
written-
ಸೇರಿಸಿದ್ದಾರೆ, ಅದ್ರ ಬಗ್ಗೆ ನಾವು we will take the necessary steps. ಈಗ ಯಾಕೆ ಅದನ್ನ ನೆಸರಿ ಸ್ಟೆಪ್ಸ್ ತಗೊಂಡಿಲ್ಲ ಅಂದ್ರೆ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಆಲ್ರೆಡಿ ಪಾಸ್ಡ್ ದಿಸ್ ಆರ್ಡರ್. ವಿತ್ ದಿಸ್ ಆರ್ಡರ್ there is no question of striking down of the pleadings etc. that would arise because of the court having taken the view.
We'll see. Yes. ಅಷ್ಟೇ ಅಲ್ವಾ? Heard reserved. Yes.
And another aspect that is this thing, your lordship may kindly see third daughter ಇದರಲ್ಲಿ ಚೆನ್ನಮ್ಮ son Ramaya. Ramaya has 3 daughters. ಈ 3 ಜನ there was a suit OS number 104 of 84 for partitioning the property of K.N. Ramaya. That suit is decreed allotting 1/3 share each. 3 daughters, each one is granted 1/3 share. Out of that 1/3 share, one of the sister has bequeathed the property in favor of defendant number 13, the present petitioner before the court. So I am the owner of 2/3 this thing. The other daughter Lalitamma has 1/3 share. That is decided long back. With these facts, whether this amendment application on the ground there is a written statement by someone.
CRP ಹಾಕ್ಲಿಲ್ವಾ? CRP rejection of plaint ಹಾಕ್ಲಿಲ್ವಾ?
Rejection of plaint ಅಲ್ಲ
ಹಾಕಿದ್ರ facts
ಈ ಪ್ರಾಪರ್ಟಿ ಇರೋದಕ್ಕಿಂತ ಮೊದಲೇ
ಮುಂಚೆನೆ ಹಾಕಿದ್ರಿ.
ಪ್ಲೇಂಟಿಫ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಕೇಳೋದಕ್ಕಿಂತ ಮೊದಲೇ ಆರ್ಡರ್ 7 ರೂಲ್ 11 ಹಾಕಿದ್ವಿ.
What happened to that?
ಅದಕ್ಕೆ ಇವ್ರದ್ದು individually one of the sons want a share, grandson wants a share. She can always maintain. A suit was this
Order.
thing and that CRP was rejected.
Order ಇದೆಯಾ ಅದು? Page.
264.
ಒಂದು ನಿಮಿಷ ಕೊಡಿ ಮೇಡಮ್. 264.
Yes, 264, my lord. dated 17/1/2023.
Kindly go to para 10, page 278. Specifically saying it is confined to Venkatappa's share. Therefore, there is nothing wrong. Para 10.
Yes. Right.
Number 6. The one another aspect.
No, Allu, nim submission was that
Yes.
application under 711 should have been allowed and the counterclaim should have been rejected.
ಅಂದ್ರೆ ಅದೇ FDP ಅಲ್ಲಿ ಕೇಳಬಹುದು ಅವರು, ಇಲ್ಲಿ ಬರೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ ಅಂತೇಳಿ ದಟ್ ವಾಸ್ ಅವರ್ ಕಂಟೆನ್ಷನ್.
All right, yes. ಅಷ್ಟೇ.
One another
ಮತ್ತೆ
proceedings which has been instituted, which is out page number 245.
ಏನದು?
It is the defendant number 8 has filed a MFF against the grant of an order of injunction
So far as the written statement shall
in respect of written statement scheduled properties of defendant number 2. The said matter came up for consideration before this court on 29/4/2025. Court has directed, consider the case of the defendant number 2 for grant of an order of injunction. The relevant portion of the order is at page number 246.
I number 6 is the application filed by defendant number 2.
IA number 6 was the application filed by
Pending is
defendant
there.
number 2.
Para number 3.
The matter
Para
is-
number 3.
Matter is pending still.
Yes,
ಅದರಲ್ಲಿ
in respect of written statement scheduled properties.
kindly go to page 247. I don't know why my learned friend is making a submission contrary to the facts. I will only put it to that.
Yes.
Para 4, 247.
Yes.
Therefore, the impugned order dated 23/9/22 in so far as the order granting temporary injunction, written statement scheduled properties is concerned,
Is set
is set aside.
As the
With
order-
regard to plaint scheduled property, MFA is pending.
Interim order set aside ಮಾಡ್ಬಿಟ್ರೆ.
Yes.
Allah, that was not the application.
All right.
Court will have finds anything and everything application is.
Court has
filed
said
partition
reconsider
for-
it, remanded
partition
and
for.
reconsider it.
ಆಮೇಲೆ ರೀಕನ್ಸಿಡರ್ ಆಗಿದೆಯಾ?
Yes.
ಟ್ರಯಲ್ ನಡೀತಾ ಇದೆ, ನಾಳೆ
ಪೂರ್ತಿ
date
ಓದಿ.
ಇದೆ.
ಅವರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ನಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ನಾಳೆ
ಅದು ಮತ್ತೊಂದು ಹೊಸ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ ಈಗ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿಗೂ ಕೊಡಬೇಕು ಅಂತ.
ಇಲ್ಲ. ಅಲ್ಲಿ ಪೂರ್ತಿ ಓದಿ ಅದನ್ನ. 240.
Same is remanded for trial court direction to consider arguments in IS 6 filed by defendant number 2 to pass fresh
Yes.
order.
Fresh order.
It is remanded back.
It's a remand.
ಅದನ್ನ ಹೊಸದಾಗಿ ಮಾಡ್ಕೊಳ್ಳಿ, ಈಗಂತೂ ಆರ್ಡರ್ ಇಲ್ಲ.
ಅಲ್ಲ, ಈಗ ಆಗ್ತಾ ಇದೆಯಲ್ಲ, ಅದಕ್ಕೆ ಇದಕ್ಕೆ ಏನ್ ಸಂಬಂಧ?
ಅಲ್ಲಲ್ಲ, ಆ ಇಂಜಂಕ್ಷನ್ ಆರ್ಡರ್ ಇದೆ ಅಂತ ಹೇಳಿ ತೋರಿಸಿದ್ರು, ಇಂಜಂಕ್ಷನ್ ಆರ್ಡರ್ ಇಲ್ಲ ಅಂತ ನಾನು ಹೇಳಿದೆ.
ರಿಮಾಂಡ್ ಆರ್ಡರ್ ಅಂತ ಹೇಳಿದೆ ನಾನು.
ಇಲ್ಲ, ರಿಮಾಂಡ್ ಆರ್ಡರ್ ಅಂತ ಹೇಳಿರಲಿಲ್ಲ.
No problem.
ರಿಮಾಂಡ್ ಆರ್ಡರ್ ಅನ್ನೋ
If
ಶಬ್ದ
that is so, I
ಬಂದಿದೆ,
stand
ನಾನು
correct. I stand correct.
it should have been
I
done
made a-
earlier.
Heard. Reliance Senior Counsel, Jaykumar is partly appearing for the petitioner. Senior Counsel T. Sheshgiri Rao representing the respondent and Shamant.
Soumya.
So, reserved, yes.
Mobilization.
Great. Next.
45.
Respondent.
Settlement ಆಗಿದೆಯಾ?
Settlement ಅಲ್ಲಿ, my client is ready to give up rent which comes around 5 lakhs, my lord. Additionally, they want 20 lakhs rupees.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದರಲ್ಲಿ ನಾನು 20 lakhs ಕೇಳ್ತಾ ಇಲ್ಲ.
ಈಗ ಬಂದಿರೋ interim order continue.
ಒಂದೇ ಒಂದು ರಿಕ್ವೆಸ್ಟ್, ಇಂಟೀರಿಯರ್ ಮಾಡಿ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
Continue, don't worry about that. Yes.
ಅಲ್ಲಿ ನಾ ಕೇಳ್ತಾ ಇರೋದು ಏನಂದ್ರೆ, ಓನರ್ ಆಫ್ ದಿ ಪ್ರಾಪರ್ಟಿ, ಓನರು ಟೆನೆಂಟ್.
ಈಗ ನೀವು ಬಂದಿರೋದು 26/9 ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ.
26/9.
ಹೌದು.
ಮತ್ತೆ ಅದ್ರೇನೋ ಸೆಟಲ್ಮೆಂಟ್ ಆಗುತ್ತೆ ಅಂತ ಹೇಳಿ.
ಸೆಟ್ಲ್ಮೆಂಟ್ ಗೆ
ಆಗ್ಲಿಲ್ಲ
ಮಾತಾಡ್ತಾ
ಅಂತಂದ್ರೆ ವಿಲ್ ಪಾಸ್ ಆರ್ಡರ್ಸ್ ಆನ್ ಮೆರಿಟ್ಸ್ ನಾವು ತೊಂದ್ರೆ ಇಲ್ಲ.
ಇಲ್ಲ
Suit for-
ಯಾಕೆಂದ್ರೆ parties
for
also-
ejectment.
ejectment.
ಅದ್ರಲ್ಲಿ ಕೋರ್ಟ್ ಕಮಿಷನರ್ ಯಾಕೆ?
ಅಲ್ಲ ಕೋರ್ಟ್ ಕಮಿಷನರ್ ಯಾತಕ್ಕೆ ಅಂತ
Application
ಹೇಳಿದ್ರೆ
may kindly be seen
I have
now.
filed one suit, injunction suit file ಮಾಡ್ತೀನಿ.
Annexure D.
ಅದು 550/2020. ಸೊ ಅದ್ರಲ್ಲಿ ನನ್ನ ಅಡ್ರೆಸ್ ಬಂದು ಫಸ್ಟ್ ಫ್ಲೋರ್ ಅಲ್ಲಿ ನಾವಿದೀವಿ ಅಂತ ನಾ ಹೇಳ್ತೀನಿ.
ಎನಿಥಿಂಗ್ ಎಲ್ಸ್ ಮೇಡಮ್?
ಅಲ್ಲ ಸುಮ್ಮನೆ ಅದ್ರಲ್ಲಿ ನಾನು ಸ್ವಲ್ಪ ಕ್ಲಾರಿಫಿಕೇಶನ್.
ಎಸ್ ಮೇಡಮ್.
ಸೊ ಅದಾದ್ಮೇಲೆ 792 ಇದರಲ್ಲಿ 515 ನಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು ಹಸ್ಬೆಂಡ್ ಒನ್ ಗಣೇಶ್ ಅವ್ರ ಮೇಲೆಲ್ಲೇ ನಾನು ಇಂಜೆಕ್ಷನ್ ಸೂಟ್ ಹಾಕ್ತೀನಿ. ಸೊ ಅದಾದ್ಮೇಲೆ 792 ಎಜೆಕ್ಟ್ಮೆಂಟ್ ಸೂಟ್ ಹಾಕ್ತಾರೆ, ಅದು ಗಣೇಶ್ ವೈಫ್. ಸೊ ಈಗ ಏನಾಯ್ತು, ಹಸ್ಬೆಂಡ್ ಅಂಡ್ ವೈಫ್ ಇಬ್ರದ್ರಲ್ಲೂ ಒಂದೊಂದು ಕೇಸ್ ಇದೆ. ಪ್ಲೇಂಟಿಫ್ ಇದ್ರಲ್ಲಿ ನಾನು 792 ಐ ಆಮ್ ದಿ.
ನೀವು ಯಾರು?
I am the owner of the property.
Between the husband and wife he is caught.
ಅಲ್ಲ ಹಂಗಲ್ಲ ಸ್ವಾಮಿ, ಇದ್ರಲ್ಲಿ ಒಂದ್ ಸೈಟ್
ತೊಂದ್ರೆ ಇಲ್ಲ. You are on 26(9) application in an ejectment suit. What will the court commissioner do? Yes, anything else?
ಸ್ವಾಮಿ ಅದ್ರಲ್ಲಿ ನಾನು ಏನ್ ಹೇಳ್ತಿದ್ದೀನಿ ಅಂದ್ರೆ ಇವರು ರೆಂಟ್ ನನಗ್ ಕೊಡ್ತಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. ನಾನ್ ತಗೊಂಡಿರೋದು
So commissioner will decide who is paying rent to whom.
ಅಲ್ಲ ಸುಮ್ಮನೆ ಅದ್ರಲ್ಲಿ ಎಲೆಕ್ಟ್ರಿಕ್ ಬಿಲ್ ಇದೆ, ಮೀಟರ್ ಇದೆ. ಆ ಕರೆಂಟ್ ಮೀಟರ್ ನ ಎಲ್ಲಿದೆ, ಯಾವ್ದು ಒಂದ್ ಪ್ರಿಮಿಸಸ್ ಇಲ್ಲಿತ್ತು ಆ ಪ್ರಿಮಿಸಸ್ ಅಲ್ಲಿ ಇಲ್ಲ, ಆ ಅಡ್ರೆಸ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅದು ಮೀಟರ್, ಇನ್ನೊಂದು ಲೊಕೇಶನ್ ಅಲ್ಲಿ ಹಾಕೊಂಡಿದ್ದಾರೆ. ಸೊ ನಾನು ಅದಕ್ಕೋಸ್ಕರನೇ ಈಗ ನನಗೆ ರೆಂಟ್ ಕೊಡಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನಾನು ಒಂದು ಲೀಗಲ್ ನೋಟಿಸ್
They are not
ಕೊಡ್ತೀನಿ.
cross-examined me, they are not led evidence, and when the matter is posted for argument, they have filed an application.
Anything else madam?
ಇದ್ರಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಲ್ಲ ಅವರು. 26 ರೂಲ್ 9 ಅಪ್ಲಿಕೇಶನ್
ಡಿಸ್ಮಿಸ್ ಮಾಡಿದಾರಲ್ಲ.
ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅದು ಏನಕ್ಕೆ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ ಅವ್ರ ಅದ್ರೊಳಗಡೆ ನಾ ಕೇಳ್ತಾ ಇರೋದು ಇಷ್ಟೇ ಪ್ರೇಯರ್ ಸ್ವಾಮಿ. ಅದು 3 ಪ್ರೇಯರ್ ಕೇಳಿದೀನಿ. ಕೈಂಡ್ಲಿ ಪರ್ಸ್ಯೂ ದಟ್ ಅಪ್ಲಿಕೇಶನ್.
Yes madam.
ಇನ್ ಪೇಜ್ ನಂಬರ್
27.
annexure D.
27.
27 ಬೇಡ, 35 ಇಂದ 42 ವರೆಗೆ ನೋಡಿ. Anything else madam?
27 madam. ಅದರಲ್ಲಿ to direct the commissioner to inspect the property bearing number 122 first floor situated at 9th main 16th cross Maruti Nagar Sonnenahalli Ullala post.
You are the wife of Ganesh, huh? Alla Manjunath. Ganesh is
our
landlord.
landlord husband. ಅವರು ನನಗೆ ಅವರ ಸೈಟ್ ಅಲ್ಲಿ ಮನೆ ಕಟ್ಟಿರೋದ್ರಲ್ಲಿ ನಾನ್ ಟೆನೆಂಟ್ ಆಗಿರ್ತೀನಿ ಸ್ವಾಮಿ. ಅವರೇ ಅಗ್ರಿಮೆಂಟ್ ಹಾಕೊಡ್ತಾರೆ.
ಇಂಜಂಕ್ಷನ್ ಸೂಟ್ ಪೆಂಡಿಂಗ್ ಇದೆಯಲ್ಲ,
ಇಂಜಂಕ್ಷನ್ ಸೂಟ್ ಪೆಂಡಿಂಗ್ ಇದೆ, ಎಜೆಕ್ಟ್ಮೆಂಟ್ ಸೂಟ್
ಅದ್ರಲ್ಲಿ ಮಾಡ್ಕೊಳ್ಳಿ ಅಲ್ಲ. ಎಸ್,
ಅದಕ್ಕೆ ಕೈಂಡ್ಲಿ ಅಲೋ ದಟ್ ಅಪ್ಲಿಕೇಶನ್. ನನಗೆ ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಆಯ್ತು ಅಂದ್ರೆ ನನ್ಗೆ ಅಲ್ಲಿ ಏನ್ ನಡೀತಿದೆ ಇಲ್ಲಾಂದ್ರೆ ಮೀಟರ್ ಅಲ್ಲಿ ಇರೋದನ್ನು ತಪ್ಪಿದೆ ಸ್ವಾಮಿ. KEB ಅವರು ಅದನ್ನ
ಇಂಜಂಕ್ಷನ್ ಸೂಟ್ ಎಲ್ಲ ಮಾಡ್ಕೊಳ್ಳಿ. ಎಸ್, ದಿ ಪೆಟಿಷನರ್
ಸ್ವಾಮಿ ಅದ್ರಲ್ಲಿ
ನೋ
ಇನ್ನೊಂದು
ಮೇಡಮ್.
ಲಕ್ಷ್ಮಿ
ಮತ್ತೆ ಇದು
ಮನೆ
1.5 ವರ್ಷದ ಪೆಂಡಿಂಗ್ ಇದೆ ಸ್ಟೇ. ಎಸ್, ದಿ ಪೆಟಿಷನರ್ is before this court calling in question an order dated
ಇನ್ನೊಂದೇ ಒಂದು ಸಬ್ಮಿಷನ್. ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್ ಏನಿದ್ದಾರೆ ಪಾರ್ಟೀಸ್
we will reserve liberty to urge all the contentions before the in the injunction suit, not in this ejectment. Court commissioner I will never permit appointment. ಏನ್ ಒಂದು ರೀಸನ್ ಕೊಟ್ಟಿಲ್ಲ ಯಾಕೆ ಬೇಕು ಅಂತ. ಕೋರ್ಟ್ has passed a reasoned order. Where is the question of staying it now?
ಅಲ್ಲ ಇನ್ ಕೈಂಡ್ಲಿ ಪರ್ಸ್ಯೂ ದಟ್
no madam.
ಜಡ್ಜ್ಮೆಂಟ್ ಕಾಪಿ ನಲ್ಲೇ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲೇ ಇದೆ
ಸೆಪರೇಟ್ ಆರ್ಡರ್ ಅಲ್ಲಿ
ಗೊತ್ತಾಯ್ತು. The application on the following reasons page 37 ಅಲ್ಲಿ ಇದೆ.
41 kindly in page number 41. As stated above, the present suit is filed for injunction. The burden is on the plaintiff to prove that landlord and tenant relationship in between the defendant and plaintiff. The defendant has denied the relationship of landlord and tenant. Under such circumstances, the burden is on the plaintiff to prove the relationship.
Yes, anything else madam?
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರಿಗೆ ಕಣ್ಣೇ ಹೋಗಿದೆ ಸ್ವಾಮಿ. Party is also present before this honorable court also.
That does not mean 26(9) will be allowed. Injunction suit ಇದೆ ಅಲ್ವಾ, ಅದ್ರಲ್ಲಿ ಮಾಡ್ಕೊಳ್ಳಿ.
ಇದೂನು ಪೆಂಡಿಂಗ್ ಇದೆ, ಅದು ಪೆಂಡಿಂಗ್ ಇದೆ ಸ್ವಾಮಿ.
Yes sir.
The reason is given in the may kindly see page 40 my lord. It is
You want to evict the person, is it?
Yes my lord.
26(9) ಅಲ್ಲಿ ಏನಾಗುತ್ತೆ ಮೇಡಮ್?
ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ರೆ ಡೈರೆಕ್ಷನ್ ಆದ್ರೂ ಕೊಡಿ ಸ್ವಾಮಿ. KEB ನ ಅವ್ರು ನೋಡಿ ಮೀಟರ್ ಎಲ್ಲಿದೆ ಅನ್ನೋದು ಗೊತ್ತಾದ್ರೂ ಸಾಕು
Electricity bill also my lord.
ಇನ್ನೇನಿಲ್ಲ.
The document has been marked. Electricity bill produce ಮಾಡಿದ್ದೀನಿ ನಾನು.
ಅದು ನಾವ್ ಇನ್ನ ಕ್ರಾಸ್
You are the tenant, correct?
Yes madam.
the petitioner, tenant in, or petitioner a tenant is the defendant in OS 792 of 2020 in a suit instituted by the respondent landlord seeking ejectment. The issue in the list does not pertain to the merit of the matter. The petitioner, the tenant, files an application under Order 26 Rule 9 seeking appointment of a commissioner to verify certain things about the property in which the petitioner is a tenant. The concerned court by a reasoned order rejects the application, rejection of which has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner would vehemently contend that appointment of a commissioner is imperative in the case at hand in the light of several disputed questions of fact between the petitioner and the respondent qua the landlord and tenant relationship. In that light, the application was filed. The concerned court ought to have allowed the application. The learned counsel for the respondent takes this court through the application to seeking to contend that the petitioner has already instituted a suit for injunction against the very plaintiff, and the said suit is pending. In the teeth of the said pendency of the suit, the application for appointment of a commissioner to fetch evidence with regard to landlord and tenant relationship could not have been filed and entertained. The concerned court has appropriately rejected the same is the submission to counsel for the petition respondent. I have given my so and so. The concerned court, the afore narrated facts are not in dispute. The concerned court answers the application by the following order, page 35 to 42. The suit is for ejectment. The relationship between the landlord and tenant is not in dispute. The the petitioner instituting another suit for injunction against the respondent is also a matter of record. In the light of the said proceedings pending, it is ununderstandable as to what the court commissioner would do with regard to a relationship between the landlord and tenant The proceedings, argument stage. The application comes to be filed at the stage of arguments in the ejectment suit, hyphen the subject suit. In that light, there was no warrant for the in that light, the concerned court has appropriately rejected the same by the aforequoted reasoned order. I do not find any perversity in the said order to interfere in the proceeding under Article 227 of the Constitution of India. The petitioner is at liberty to urge all the contentions before the concerned court in the ejection suit in OS.
Ejectment suit 790.
Adu,
550.
injunction.
550 of 2020.
550 of 2020. Yes, order record. Finding no merit in the petition, petition stands rejected. Next.
46.
Sir, I'm 46. I am for the response.
The fourth defendant is the petitioner. Suit filed by the respondent 1 to 4 against for partition and separate possession. They may file the application. They filed the application for amendment by adding the subject property.
Partition suit.
But Malad, the husband of the first plaintiff and father of the plaintiff, other plaintiffs have relinquished their rights over this property as per Annex.
Where is the relinquishment?
Annex L. Malad. That is registered deed Malad dated 24/11/2001. That is not challenged.
No problem. Their daughters, is it?
No, not.
Who is the plaintiff?
No, the plaintiff, the Nagarajappa is one of the party to that relinquished deed.
Relinquishment bidi, sir. Who is the plaintiff now?
His wife and children are the parties to the.
Children andre yaru?
Nagarajappa is one of the party to the relinquished deed. His wife and children are filed the suit for partition.
Daughter Gayatri so and so. Court will consider that also.
Yes. It is a matter of trial.
It
is a matter of trial.
Yes, sir. It's a matter of trial.
The registered deeds, that is not questioned in this partition.
There is no warrant to stay this year.
That is registered deed, in 2001, that is executed. Nobody disputed that one,
Court will consider, sir, with the change in law, court will consider.
Well, when they are relinquished their rights for this
ಅವ್ರು ರಿಟರ್ನ್
property.
ಸ್ಟೇಟ್ಮೆಂಟ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ.
ಯಾರು?
ಅಲ್ಲ ಅವ್ರು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಫೈಲ್ ಮಾಡಿದ್ರೆ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇಲ್ಲಿ ಕಂಟೆನ್ಷನ್ ತಗೊಂಡಿದ್ದಾರೆ.
ತಗೊಂಡಿದ್ದಾರೆ.
ಅಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
Application.
Well, application, objection, I have taken a specific
objection,
contention, that is the, but as there is, the
ಈಗ-
property is not a family property.
ಈಗ application is allowed.
Please.
ಹೌದು.
Court will consider the relinquishment deed also and pass on necessary orders.
ಇನ್ನು ಇಶ್ಯೂಸ್
That is
ಫ್ರೇಮ್
not the
ಆಗಿಲ್ಲ.
subject matter of the suit, my lord, that's why, my lord.
No, this amendment ಮಾಡಿರೋದು, those properties are also included now,
That is
which they have
include-
relinquished, is what you say?
Please, my lord.
Correct, yes.
My lord, 2001 deed, my lord, that is not challenged anywhere, my lord.
Court will take note of that also while drawing up the partitions. It may, those properties may be rejected even.
But
I
unnecessarily,
will
my
not
lord,
pronounce on the relinquishment deed because it's a matter of evidence how it was taken.
well, if it is, my lord, that.
ಎಷ್ಟು ವರ್ಷ ಅವಾಗ ಅವ್ರಿಗೆ?
ಅಲ್ಲ
Well, our father, husband of the first plaintiff has
Oh,
relinquished.
He is no more?
He is no more. After his death, my lord, they filed the suit.
No problem.
In the 2022.
ಎಲ್ಲ
This
matter
is
of
2001
trial,
deed.
sir. That's a matter of trial. I will not pronounce upon that.
But even that is not disputed, my lord, nowhere, my lord, they have not challenged that.
ಇನ್ನು
also.
ಇಶ್ಯೂಸ್ ಫ್ರೇಮ್ ಆಗಿಲ್ಲ ಸರ್. ಇಶ್ಯೂಸ್ ಆರ್ ಟು ಬಿ ಫ್ರೇಮ್ಡ್. ಅವ್ರು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಫೈಲ್ ಮಾಡಿಲ್ಲ.
Anything else? ಎಲ್ಲ ಅಲ್ಲೇ ಅರ್ಜಿ ಮಾಡಿ.
When there is a registered deed is there, my lord.
ಆಯ್ತು, ಅದನ್ನು ಅರ್ಜಿ ಮಾಡಿ.
ಅಲ್ಲ, ಅದನ್ನ ಅರ್ಜಿ ಮಾಡಿದೀವಿ, that is
ಅಲ್ಲ
the
ನಾನ್
contention, my lord.
ಕಂಟೆನ್ಷನ್ ತಗೊಳ್ತೀನಿ, ಅದು ವ್ಯಾಲಿಡಿಟಿನ ಅದೆಲ್ಲ.
Now it is allowed.
Please.
Yes. After the issues are framed, then we'll see what. It's not an amendment that ought not to have been allowed antilla.
ಅಲ್ಲ, ಯಾಕಂದ್ರೆ when it is not a family property, my lord,
Matter
that
of
cannot
trials,
be.
the matter of trials, sir.
ಅಲ್ಲ, prima
ಇನ್ನು
facie
issues
shows-
frame ಆಗಿಲ್ಲ.
ಅಲ್ಲ, prima facie document shows, my lord, they are, he is also
ಆಯ್ತು,
party.
let the issue be framed that way, otherwise order 14 rule 5 ಹಾಕಿ, we'll see.
That liberty is between.
The petitioner is before this court seeking the following prayer. The suit is for partition. The application comes to be filed by the respondent, plaintiff,
1 to 4.
respondent plaintiff 1 to 4.
1 to 4.
Seeking amendment of the plaint. The amendment of the plaint is filed before the issues are framed. Immediately after the written statement was filed by the present petitioners.
Both written statement and application were filed on the same day.
Written statement was filed. The learned counsel for the respondent submits that the application seeking amendment of the plaint was preferred on the day the written statement was filed. Be that as it may, the amendment concerns certain properties which is said to have been relinquished by the father of the plaintiffs during his lifetime, and a suit for partition is instituted including those properties which the father had relinquished. It is on this premise the petitioner is before this court in challenging the said order. Since the issues are yet to be framed, all the remedy is available to the petitioner to knock at the appropriate fora at the appropriate time. The learned counsel for the petitioner submits that liberty of that kind be reserved to the hands of the petitioner and hands of the petitioner. The counsel for the respondent has no objection to reserving such liberty as it is a liberty available in law. In the light of the said circumstance, without interfering with the order passed by the concerned court, I deem it appropriate to dispose the petition, reserving the aforesaid liberty. Yes. Next.
47.
For the petition, my lord.
Notes, I request a week's time.
Why, sir? Vacating stay.
Vacating stay has been filed.
Huh.
Next week.
ಸ್ಟೇ ತಗೊಂಡ್ಮೇಲೆ ವೆಕೆಟಿಂಗ್ ರೆಡಿ ಇರ್ಬೇಕು. ಅದಕ್ಕೆ ಇದೆಲ್ಲ ಸ್ಟೇ ಆಗಿ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಮೇಲ್ ಹಾಕಿದ್ದೀನಿ.
Lord,
Now 10 petitions are over.
next week.
ಎಲ್ಲ vacating stay.
Next Friday or next Thursday.
What's the
Issue, Lord, is amendment has been allowed. Against that, I have preferred writ petition.
suit for
Partition, Lord.
anything else, sir?
Lord, that's not the only issue, Lord.
Yes, sir.
Suit for partition in separate position, filed by the plaintiff against the father and the brothers, saying that it's a joint family property. The defendant files a written statement contends that it's not a joint family, it is a self-acquired property. When the matter was set down for issue, my lord, the defendant files an application, order 6 rule 17, directing the plaintiff to include for property in the plaint, not in the written statement. He is seeking the amendment in respect of the plaint, my lord, on the basis of a judgment of the Madras High Court, where it says, my lord.
Oh, the plaintiff and respondent are equal.
No, my lord, that is
So
not,
adu iವ್ರು ಮಾಡ್ಬೋದು, ಇದು ಅದ್
that is
ಮಾಡ್ಬೋದು.
not the issue, my lord. This judgment, wherein the court said, my lord.
In that, sir.
Where the court said, my lord, if the plaintiff objects, it cannot be allowed. Here, my lord.
No, he is the master of his plaint.
Yes, my lord.
You file a counter claim if you want.
My lord, as per the
You
judgment.
file a counter claim, no problem. But you can't direct him, you do include that, you include this, you do that, you do this. Counter claim is always
No, my
available.
contention is only this. If according to the plaintiff, there is an existence of a joint family and one of the member owns a property and that is susceptible to
File a
partition.
counter claim, sir.
My lord, if that is susceptible to partition, why are you not including your own properties? Because invariably in the event, my lord, in the event, my lord,
Counter claim is registrable.
my lord, yes, but I would have
But
to see.
amendmental, amendmental, you can't direct him to do
My
something.
lord, kindly see the judgment of the Madras High Court. On this one limited point, a question was raised before.
No, if it is on a consensus, no problem at all.
No, kindly see the judgment. My lord.
No,
Kindly
sir.
see the issue that was raised. Paragraph 1.
Hmm.
It says, my lord, the question raised in the civil revision petition is whether under Order 6, Rule 17 of the CPC, amendment to the plaint in a partition suit can be allowed at the instance of the defendant.
Defendant.
Yes. Now kindly see, my lord.
No, there
paragraph-
this, I've seen this, the court holds
Yes.
that in a partition suit, the defendant and the respondent, their ranking is illusory because
Yes,
you're all,
because it is exchangeable.
you're all definitely getting partition. That would not mean that you direct the plaintiff to do something, file a
That's the
counter
issue, my
claim.
lord. I am only relying on this judgment
No,
which
sir.
specifically says
No,
that
no,
you
I
can
have-
do it.
I have distinguished this and held otherwise. Saying that counter claim is always.
Otherwise, he can file a separate suit for declaration.
It would only,
Damn
the
it.
resultant effect would
Iದ್ರಲ್ಲಿ
be the
counter claim
same.
ಹಾಕಕ್ಕೆ ಏನ್ ತೊಂದ್ರೆ?
ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
The resultant effect would be the same. Now,
Whatever, sir. In law, in terms of law, you do it. We will not permit you to direct what the plaintiff should do.
a liberty may be granted to that effect, my lord, if that is.
The petitioner is before this court seeking the following prayer. The petitioner is before this court. Petitioner plaintiff is before the court calling in question an order dated 1/3/2024 by which the application filed by the defendant seeking amendment of the plaint schedule property comes to be allowed. The suit is for partition. The parties to the list, the suit is for partition and separate possession. The plaintiff institutes the suit seeking partition of the joint family property according to him as the suit schedule property. After the appearance of the defendant, a written statement is filed. Written statement ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದಾರೆ sir.
Written statement is filed and later comes up an amendment under Order 6, Rule 17, directing the plaintiff to amend his plaint to include all the properties. It is no doubt true that in a suit for partition, all joint family properties should be the suit schedule property, so that the partition would not result in fragmented decree. That would not mean that the defendant would dictate the plaintiff to act in a particular manner or amend the suit schedule property, particularly in an application filed by the defendant. It was always open to the defendant to register his counter claim by including the properties that he now wants to seek amendment of. Reserving such liberty, I deem it appropriate to pass the following order. The order so and so stands quashed. The defendant is reserved liberty to register his counter claim in accordance with law.
To include property.
To include the properties that are the subject that are the subject matter of the application of Order 6, Rule 17.
Great.
Yes.
48.
Next.
Lord, I appeal for the petitioner in the first.
Partition.
It is not, it is arising out of.
48.
execution. 48.
ಇದಾಗಿದೆ ಯಾವ್ದು ಮೇಡಮ್? 47.
Proceedings.
48 ಎರಡು ಮ್ಯಾಟರ್ ಏನಿದೆ?
ಅದು ಇದ್ರಲ್ಲಿ ಅವ್ರು they have.
There were two
I have
applications.
filed- And I have filed the writ petition as against the rejection of an application filed by the my lord, decree holder under order 21 rule 11. Not as a counter blast subsequently, my lord, in fact, in the.
Counter blast.
In fact, my lord, you will have to calendar. He filed an application under section 47 word and inquiry in the execution proceeding. Not after service of notice, not he challenged, subsequently he challenged the, my lord, the rejection of the application filed by the judgment letter under section 47.
That is under challenge here.
That is under challenge in the
That is
second
an-
petition.
One
Not
application.
what entry, my lord, I have, in fact, I have said, my lord, I would file wakalat for the second petition.
ಹಾಕಿಲ್ವಾ ಇನ್ನು?
ಅದಕ್ಕೆ ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ, they have not served the copy in so far as the writ petition is concerned. That is one aspect.
ಸುನಿಲ್ ಯಾವ್ದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಯಾವ್ದು?
Connected matter, one writ petition, my lord, which I had filed against the order passed.
ಅಲ್ಲ
on-
ಇದ್ರಲ್ಲಿ ಯಾವ್ದು?
Second one.
Second one.
32937.
ಹೌದು, that is filed by the, as against the rejection.
Correct. ಅದ್ರಲ್ಲಿ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿಲ್ಲ. ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ.
Counsel for the
Anyway, I will share the copy. of it.
petitioner in 32937 shall serve set of papers upon the counsel for the respondent forthwith. Rest the matter on 3rd September.
My lord,
In the same stage, interim order subsisting will continue to the next.
ಅಲ್ಲ, interim order ಯಾವ್ದಿಲ್ಲ, in fact.
ಕೊಟ್ಟಿಲ್ವಾ ಇದ್ರಲ್ಲಿ?
ಇದ್ರಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ.
Interim order.
The
There is
rejection
an-
of the
ಅದ್ರಲ್ಲಿದೆ.
application. Second, in
There
fact,
is an
you will have to
application.
calendar.
There is another application filed by them in the execution code. for
List on 3rd September.
That is, in fact, you will want 2023 itself. not-
3rd September, yes.
Till such time, my lord, let
No
that-
such time, yes.
ಅಲ್ಲಲ್ಲ, ಯಾಕಂದ್ರೆ another application, ಈ application ರಿಜೆಕ್ಟ್ ಆಗಿ they have filed the writ petition. ಇದ್ರ ಮೇಲೆ, one order ಮೇಲೆ, another application is filed to issue an arrest warrant.
Not in this matter.
ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ?
ಅದೇ attachment, ಈ ಮೊದ್ಲು ಏನ್ ಮಾಡಿದ್ರು ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು. ಅದ್ರ ಮೇಲೆ ಎನ್ಕ್ವೈರಿ ಹೋಲ್ಡ್ ಮಾಡ್ಬಿಟ್ಟು ಇಶ್ಯೂ ಮಾಡಿ ಅಂತ ಅದ್ರ ಮೇಲೆ.
List on 29th, yes, next.
Till such time, my lord, let them not precipitate
ಯಾವ್ದನ್ನ
that the attachment
section
of
47 is rejected.
ಯಾರಾದ್ರೆ
ಒಂದು application ಹಾಕೊಂಡು.
you move it.
ನಾನು ಈ ಕೇಸಲ್ಲಿ ಹಾಕಿಲ್ಲ.
Next,
Maybe
next.
in other, some other case.
49.
9 minutes may seek for a passover in this matter minutes.
Interim order ಇದೆಯಾ?
ಇಲ್ಲ, interim order
Interim
ಇಲ್ಲ,
order
that's why
ಬೇಕು ಅಂತ application ಹಾಕಿದ್ದಾರೆ.
application
ಬೇಕೇ
ಹಾಕೊಂಡಿದ್ದೀವಿ
ಬೇಕು.
ಬೇಕು ಅಂತ they have filed
Emergency minutes may
2015 suit ಮೇಲೆ they have filed seeking for stay.
ಏನ್ ಹಾಕಿರಿ? What is the challenge, order and challenge?
minutes. Application under 151 minutes to treat the second set of the plaint minutes as a minutes first set and to carry on with the
What's
matter.
first set, second set?
There will be two sets of plaint minutes. Minutes
Sir,
at
there
the
is
time
a
of
judge-
cross examination, it came to know minutes. There is two paragraphs in the first set are not forthcoming. However, minutes second set there is. Minutes I filed an application. There are two applications filed minutes. That's the reason. Minutes there is some urgency. Lordship, you kindly pass it over minutes.
Oh, passovers, sorry.
Any other day.
Today minutes matter is posted today minutes. they
List on
filed-
22nd.
Minutes may make one request minutes. They have filed application for rejection of plaint under minutes 11DE minutes because there are no two sets of plaint. Minutes matter is posted today for a.
You will see order pass ಮಾಡಿದ್ರೆ ಬನ್ನಿ. Yes, next.
Please.
50.
Respond number 1 and 3 minute.
Driver of the vehicle.
Driver of the other offending vehicle.
Or driver of the, what, driver of the vehicle anyway.
Yes, sir.
Ah,
Owner, not driver.
owner
of
driver.
the- He is the owner come driver.
Hmm.
That's involvement of two vehicles. One is the, I am the owner of the lorry.
That is
Ah.
that is rejected.
Rejected, my lord. But as per the full
It
bench
has to
judgment.
be
of-
allowed.
Pardon?
It has to be allowed.
My humble submission, my lord. I have filed the documents along with my objection. Kindly,
Objection ಹಾಕಿದ್ದೀರಾ?
yes, my lord.
ಎಲ್ಲಿದೆ?
Filed the
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ನಿಮ್ಗೆ?
copy, sir. Copy, sir. to the- Kindly, where is the charge? sheet?
Contributory negligence ಗೆ ಬೇಕೇ ಬೇಕು.
My lord.
You
the-
can't escape. Yes.
My lord, my humble submission, my lord. Kindly take the complaint, my lord. When I was driving the car, he, behind back, he came and dashed to my car. my
That's a matter of evidence. Yes.
They want to implead me as a respond number in the proceedings.
There's a matter of evidence.
In
ನಾಳೆ
my-
ದಿನ ಕಾಂಟ್ರಿಬ್ಯೂಟರಿ ನೆಗ್ಲಿಜೆನ್ಸ್ ಬೇಕು ಅಂದ್ರೆ ಬೇಕೇ ಬೇಕು. Why the court has rejected it? Well, put up your defense, whatever you want there. You can't be bought in ಅಂತ ಇಲ್ಲ. No reason is given. ಅಷ್ಟೇನಾ? Yes, ಕೊಡಿ. The petitioner ನೀವೇನು?
Owner of the lorry, other vehicle.
The petitioner, owner of a lorry bearing registration number, idrಲ್ಲಿದೆ first synopsis.
41A.
Is before this court calling in question an order of the concerned court dated 26/3/2024 by which the application filed by the present petitioner in Order 1 Rule 10 of the CPC seeking to implead the owner cum driver of the offending vehicle comes to be rejected. Heard so and so. The first respondent is said to have sustained injuries out of a road traffic accident that happens on 2/2/2023 of in a collision between the lorry and the owner of the offending vehicle, which is the impleading applicant. It is therefore the contention of the petitioner was with regard to contributory negligence, qua determination of compensation. Therefore, the petitioner prefers an application before the concerned court in MVC 5102 of 2023 under Order 1 Rule 10 seeking impleadment of the owner cum driver of the offending vehicle. The concerned court by the order impugned rejects the application on the score that the offending vehicle, the owner and cum driver of the offending vehicle need not bear trial in the case for compensation of the victim, the first respondent. It is this that drives the present petitioner before this court in the subject petition. The learned counsel would reiterate the averment in the petition to contend that if contributory negligence has to be determined at a later point in time, the owner cum driver of the offending vehicle does become a necessary party. The counsel for the respondent, the proposed respondent, the owner of the offending vehicle would defend the order passed by the concerned court. The afore narrated facts are not in dispute. The factum of the accident between the lorry and the owner of the offending vehicle resulting in the injury sustained to the first respondent is a matter of record. The concerned court, the present petitioner prefers an application before the concerned court seeking under Order 1 Rule 10, seeking the owner of the offending vehicle to be brought in as a party respondent to the proceeding in MVC 5102 of 2023. The concerned court rejects the application. The rejection on the face of it is erroneous, as it is a matter of trial or evidence, evidence whether the offending vehicle was involved in the accident or otherwise at a later point in time, if contributory negligence or otherwise has to be determined while granting compensation to the first respondent. Therefore, in the light of the admitted fact that there was involvement of vehicles belonging to the present petitioner and the impleading applicant, the concerned court ought to have permitted the impleading applicant to come on record and allow the application so filed by the present petitioner. In that light, the petition deserves to succeed and the order of the concerned court stands quashed. The application filed by the petitioner to implead the owner of the offending vehicle stands allowed. The claimant to amend, the petitioner, first respondent to amend the cause title accordingly. Yes, ordered record. Next.
51 minutes, may I seek for a passover minutes at least.
This is a matter, Lords, where
May I seek for a passover in this matter.
ಎಲ್ಲ ಪಾಸ್ ಓವರ್ ಆಗಲ್ಲ. ವೇಕೇಟಿಂಗ್ ಸ್ಟೇ ಇದ್ಮೇಲೆ ನೋ ಪಾಸ್ ಓವರ್, ನೋ ಅಡ್ಜರ್ನ್ಮೆಂಟ್.
He is on his legs matters. That's one of the only reason.
You start, sir.
Yes. Respondent.
Vacating stay ಅಲ್ಲಿ all counsels kindly bear that I will not adjourn any matter.
I'm not asking for adjournment. I'm
ಎಲ್ಲ ಪಾಸ್ ಓವರ್ is indirect adjournment. ಅದೆಲ್ಲ ಆಗಲ್ಲ. Yes.
It's 2:30 minutes.
In a suit for partnership, in a suit for partition, but I am a bona fide purchaser of one of the suit schedule properties. Defendant, the plaintiff 1A and 1B enter into a compromise with me.
Very
right.
timely in asking because 1:30.
2:30 Lords.
Yes, 2:30. Please. Adjournments ಯಾರು ಬೇಕಾದ್ರೆ ಹೇಳಿ. This ಕರೆದ್ಬಿಡಿ ಮೇಡಮ್.
Serial number 94 ಮೇಡಮ್.
Page wise.
Page wise adjournment. Wait.
My lords,
Serial number 58, my lords.
Page wise, I'm calling.
Page 11, 55 to 58.
My lords, page serial number 58, my lords. I'm appearing for the petitioner. I'm unwell, my lords. That's why I'm appearing through VC, my lords, today.
Sorry?
I'm unwell, my lords. That's why I'm appearing through VC today. Kindly the matter maybe adjourn to any time next week, my lords. I'll be ready to argue the matter in the next week.
At the
my
request
lords.
of the council appearing for the petitioner list after 2 weeks. Next.
My lord, this is a commercial OS, my lord.
Interim order, yeah?
Yes, my lord.
Oh, yes. List the matter on 20th in preliminary hearing.
Grateful, my lords.
Page 12, 59 to 61.
20th, but 22nd in preliminary hearing.
Number 59, your lordship.
1 minute. Serial number?
Petitioner in this matter. Service to the respondent, they not have wakalat. However, I may be permitted.
Why do you want adjournment? Tell me, madam. 1948 suit. Again, what is happening now? Wait. Yes. Interim order, yeah? List the matter after 2 weeks at the request of the council appearing for petitioner. Yes. Next.
Page 13, 62 to 68.
62.
And next week.
62 settlement ಹೇಳಿದ್ನಲ್ಲ ಏನಾಯ್ತು? Yes, at the request petitioner, at the request of the council appearing for the petitioner, the learned counsel of the petitioner submits that the respondents have taken the inventory draw ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ನಲ್ಲ ಏನಾಯ್ತು ಅದು? They have taken possession, is it? Then what remains? The learned counsel for the petitioner submits that the respondents have taken possession of the property yesterday. Date hakbidi. They have broken open the lock and drawn the inventory as was directed by this court earlier. In that light, they list this matter after 4 weeks. Yes, next. Yan entry ಮಾಡ್ತಾ sir, yes. Interim order subsisting, que deposit shall continue to the next date of hearing. 60?
68. I'm for the petitioner. 68. I have to file my objection. There is no interim order in 68. There is no.
What's the 2 weeks? List the matter on 10th September. Objections, if any, by the respondent by then. Next. 70?
Page 14, 69 to 74.
ಏನು? Respondent, interim order ಇದೆಯಾ? At the request of the council appearing for the petitioner, list the matter after 2 weeks. Next. 2 weeks, but 2 weeks on the 10th September. Yes. Next.
Page 15, 75 to 80. Page 16, 81 to 88.
80, my lords, 80, my lords. 80, my lords. Kindly, adjournment, my lords. Interim order may be extended, my lords. 80, my lords.
What is the steps you have not taken?
I've taken the steps, my lords.
Learned counsel so and so. Yes, sir. Learned counsel so and so submits that he has entered appearance for the second respondent.
I oppose any adjournment in this.
1 minute. Second respondent.
Second respondent.
Registry to print the name of so and so. List this matter on 20th in preliminary hearing. It is made clear if no submissions are made on the 20th, interim order would stand automatically vacated.
There are three judgments from the.
Don't worry, sir. 20ಕ್ಕೆ ಹಾಕಿದ್ದೀನಿ ಅಷ್ಟೇ.
Here only the first judgment is before this honorable court and sought for a stay.
No problem.
As far as the other judgment.
1 minute. It is clarified that the interim order granted by this court is would stand subsisting only qua the present petitioner and not against others.
Page 16, 81 to 88. Page 17, 89 to 95.
In 94, my lords, I appeal for the petitioner. It matter was heard at length and thereafter both the parties have in terms of settlement adu ಮಾತುಕತೆ ನಡೆದಿದೆ. It will be kindly have it on 29th.
Council for the parties would submit talks of settlement between them is a foot, a foot. In that light, list this matter on 12th September to report settlement if any. Yes, next.
Serial number 95, my lords. My lords, arguing counsel is unwell, my lords. Any date may be.
Ramesh Chandra illa idralla iga.
Respondent number 1 and 2, my lords.
Avrige inform ಮಾಡಿ. He was here. I will not grant without his, yes. We will grant it. You inform him and come.
Yes.
Yes, next.
Page
ಯಾವ್ದ್ರಲ್ಲಿ 95 ಅಲ್ಲ. Learned counsel appearing for the respondent seeks 2 weeks time. List the matter after 2 weeks. Interim order subsisting will continue to the next date of hearing. Yes, next.
page 80, 96 to 100.
Amal.
Page 19, 101 to 110.
My lord, 102, I request for next Wednesday, my lord. Senior counsel Vikram Mulligol is not well this week.
List on 3rd September. Yes.
Page 20, 111 to 117. Page 21, 118 to 128. Page 22, 129 to 137.
Serial number 130, my lord. And for the petitioner, my lord, lower court matter is on 19, my lord. Maybe put up on Monday the 18th. Lower court matter is coming up on 19th.
Objection idre amele. Yes. Objection idre mention.
130. Nobody is on record for respondent, my lord.
130.
130.
ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ದೀಗ?
130.
Wait, sir.
My lord, I am for the petitioner.
Learned counsel appearing for the petitioner seeks an adjournment. List the matter on 10th September.
My lord, 18th, my lord. 19th is a lower court matter, my lord. Kindly.
19th of which date?
19th of August is a lower court matter, my lord.
Why are you seeking time then?
It might not reach today, my lord.
No, may not reach. You don't worry about that. Please, you reach. That's enough.
Number 145.
1 minute.
Page 23, 138 to 145.
Serial number 145. I am for the petitioner. But may kindly have it next week. They had sought respondents at
Respondents ಹೇಳ್ಬಿಡಿ. 2 weeks time at the request of the counsel appearing for the petition. Next.
Please.
Page
Interim
20.
order may kindly be.
Page.
Page 24, 146 to 153. Page 25, 154 to 161.
155, my lords.
My lords.
I'm asking for the petitioner.
Yes, madam.
Madam, my lords, next week one time.
Interim order ಇದೆಯಾ? Interim order ಇದೆಯಾ?
ಇಲ್ಲ, my lords. Preliminary hearing ಅಲ್ಲಿ list ಮಾಡಿಸ್ಬೇಕು.
List the matter on 3rd September. Yes.
My lordship, case called out, acknowledgement served, my lordship.
Where is your right hand?
Serial number left hand, brachial plexus agide,
Oh,
my
sorry,
lord.
last time ಹೇಳಿದ್ರು.
Yes, my lord. Serial number 80, my lordship. Acknowledgement serve ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ರು. Serve ಮಾಡಿದೀವಿ, my lordship.
ಮಾಡಿ, registry file ಮಾಡಿ. Registry file.
Order extension ಮಾಡ್ರಿ.
Registry file ಮಾಡಿ. We will extend it. Yes.
May I submit your lordships, my lord? Sorry, my lord, troubling your lordships, my lord. End of the matter on matter, my lord, land acquisition. They want to take, my lord, the KDP possession of the lands tomorrow, my lord. That is the leads the end of the day.
ಯಾವ್ದು ಕೊಡಿ ಅದು?
My colleague is
ಏನ್ ನಿಮ್ದೇನು? ಹಾ? ಅದು ಮೆಮೊ ನಾಗರಾಜಪ್ಪ ಅವ್ರ ಮೆಮೊ ವಾಪಸ್ ಕೊಡಿ. I will not take it. Don't throw papers here without even mentioning the writ petition number. Yes. Fourth. ಏನ್ ಆಗ್ಬೇಕೀಗ? Tomorrow ತಗೊಳ್ಳಿ. So ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈ ಮಾಡಿದ್ದೀರಾ? ಅದು ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಬರೋದೇ ಇಲ್ಲ.
List number list 3
Pending matter will come only on seniority, nothing.
number 3 serial number
No,
5.
sir. No.
My lord, list number 3 my lord. List number 3
Number 3 ಏನು?
List number 3.
Follow out ಮಾಡ್ಬಿಡಿ.
Serial number 2, my lord.
Wait.
List number 3.
serial number 3 lords.
Serial number 2.
Page
ಏನಾಗ್ಬೇಕು?
1 to 5.
After next week your lords.
My lord, list number serial number 2, my lord.
Last opportunity was given to them, my lord.
No,
order ಇದೆಯಾ?
last time I was ready, only petitioner only said.
Interim order ಇದೆಯಾ? List the matter on 9th September. Yes.
Much of
Serial number
Order will
5, my lord.
continue. Serial number?
Serial number 2, my lords. Interim order is to be inserted, the order was there. That's ready, my lords. Otherwise, the file is ready due to paucity of.
Wait, we'll call it.
My lord, serial number 5, my lord. Serial number 5, my lord. My lord, matter is settled in mediation, my lord. Parties will be present before this court to report the settlement. My lords may kindly have it on 20th, my lord.
All right. 20th, 22nd, thoda?
22nd.
List the matter on 22nd. Learn counsel with the petitioner submits that the matter has been settled between the parties. Yes.
Serial number 62.
60?
2, my lord.
Page,
Third list ಅಲ್ಲಿ ಏನಿದೆ?
page 2, 6 and 7, page 3, 8, page 4, 9 to 13, page 5, 14 and 15.
List 1, my lord.
List 1 ಇಲ್ಲ. You're not hungry? You had your lunch? You had your lunch? Go ahead.
List.
My lords, memo for posting, my lords. Yesterday I had moved a memo for withdrawing the petition, my lords. It has not been listed, my lords.
And withdrawal list agilva. Very shocking. Give it. Yes.
And one more date given matter, my lords. It was supposed to be listed today, my lords. The trial court matter has been posted for judgment, my lords. Kindly have it on Monday, my lords.
Not shocking. Give it on Wednesday. Yes.
Serial number 62 is adjourned at the request of a learned
Inventory.
friend. I took possession yesterday, my lord.
ಹೇಳಿದ್ರು.
Request for a short accommodation because it is adjourned to 4 weeks.
So what?
Lord, arrears is 80 lakhs, please. My lord.
80.
Yes, my lord.
Then 10th September.
Lord, August some.
Serial number 53, my lord. Serial number 53, my lord.
What do you want?
Kindly have it on next week, my lord. Interim.
Respondent here.
I am the respondent.
Petitioner here. At the request of the council for respondent, list after 4 weeks. Yes. Interim order continues. Next.
My lord, memo
Next
for
week.
posting, my lord.
ಇವತ್ತಿದ್ರೆ ಮಾಡಿ ಇಲ್ಲ.
My lord, a memo for posting, my lords. This WP was filed by us for quashing of IA, orders on IA. So they've ordered for us to deposit 30 lakhs. And if we fail to do so, our defense will be struck off, my lords. And the matters listed on Monday, that is 18th. Kindly have this posted on.
My lord, serial number 69, my lord, a short accommodation.
Petitioner respondent.
I am for petitioner, my lord.
Interim
Kindly
order
have-
ಇದೆಯಾ?
My lord?
Interim order ಇದೆಯಾ?
No, my lord. So
List
kindly
after-
have it on 21st.
List
my
after
lord.
2 weeks. Yes.
My lord, kindly have it
If
on
you want it
21st,
today,
my lord.
otherwise 2 weeks. Next.
Your Lordship, list number 2, matter number 7. Your Lordship may kindly adjourn the matter.
List number 2.
Matter number 7.
That is in the morning itself adjourned, madam. Yes, give it. Pronouncement Tolim.
List number 4, pronouncement of order. Serial number 1.
Who appears for the petitioner? Nirmal. The applications in IA 1 and 2 of 2024 filed by the petitioner seeking permission to reopen the case and reappoint the arbitrator stands allowed. The petitioner is at liberty to file his claim afresh within 30 days from the date of receipt of the copy of this order. Appointment of the arbitrator will be, the order appointing the arbitrator will be passed in due course.
Serial number 2.
Imda. The writ petition is allowed for FIR in crime number 210 of 2021, registered in so and so against the petitioner, where the petitioner, accused number 3, stands quashed. It is made clear that the observations made in the course of the order are only for the purpose of consideration of the case of the petitioner, accused number 3, under 488 of the CRPC, and would not bind or influence the investigation or any proceedings before any other fora against the accused, against the other accused.
Number 3.
Appearing for the respondent, my lord.
Dismissed.
Number 4.
For the petition. A perusal at the contents of the petition, particularly writ petition 12987 of 2025, would depict that it is verbatim similar with changes in paragraph numbers to the writ petition pending before the division bench, albeit filed in public interest. All the contentions that are now urged before this court are the grounds that are urged in the pending writ petition before the division bench, barring a few which also would touch upon the pending proceedings. In the light of the identical issue and all proceedings pending before the division bench, judicial discipline demands and hierarchy demands, hierarchy and propriety requires that this court to show judicial hands-off to the present petitions. Therefore, the subject petitions are not entertainable in the light of the aforesaid reasons. The learned Advocate General has undertaken during these proceedings that the respondents would not insist upon installation of the smart meter of the residential premises, if any, of these petitioners in both these cases, as they are not new installations. In that light, the petitions are rejected.
Five.
Writ petition is allowed, order dated so and so stands quashed, the matter is remitted back to the concerned court to regulate the proceedings in accordance with the observations made in the course of the order.
List 151,
Alla, pass over ittala.
pastor. Pastor matter. 7.
Your Lordship, senior is in court hall number 8, Your Lordship. He'll take
Is an
another.
interim order operating?
Yes, Your Lordship.
I'll vacate it.
Your Lordship, another 20 minutes, Your Lordship.
20 minutes. This is not, I passed it over in the morning
Yes, Your
for
Lordship.
want of senior.
Yes, Your
Now again, if you say, I'm going to vacate the interim order.
Your Lordship, just 10 minutes, Your Lordship. I'll call him up, Your Lordship.
Call him up.
I'll ask him.
But we have not, in fact, not the decrease for almost for about 42 crores. 24, not totally there are about 79 flats which were to be sold. They object.
14, they have sold for
14, Allah, no amount is now deposited in the court. They have filed objections for us not to withdraw that also. Ultimately, 1 rupee also we don't have today. That also they have objected. Now, subsequently, they have objected many things. Number the only ground.
What are the other things?
No, yes, no. Now they say subsequently the sales are irregular, etc. Now, Lord, the only ground which is urged in the writ petition is that the valuation of theirs is not taken into account by the sale officer. That is clear. He has considered that and passed it.
You are here in the court?
Yeah, well.
Where, shall I take it at 4 o'clock?
Very.
4 o'clock.
Yes,
If
Your Lordship.
the senior is not there and no submission, or you make the submission, or the senior should come. I'll vacate the interim order otherwise. 4 o'clock.
Grateful.
Yes.
Pastor 33.
It's connected with
84. 84 jote karibe. Wait.
51.
The vacating stay would be as far as disposal itself. Not, can I request not the date to be fixed? I'll argue on merits.
Today is the date. Vacate interim order ತಗೊಂಡ ಮೇಲೆ ready ಇರ್ಬೇಕು.
The issue, my lord, is suit for partition, partial compromise is done. Therefore, my lord, I oppose the partial compromise, saying in a suit for partition there cannot be partial compromise.
Why? Who said?
That's what, my lord, the apex court has said.
Kodi.
There are some more judgments, my lord, I would want to place it on record.
Nobody can stop parties from getting into a compromise.
Lord, in a suit for partition, Lord, what has happened is there are multiple items of property.
I may just to intervene without me. This is a matter where, lords, the plaintiff files a suit for partition. Melanet friend, that is the petitioner, opposes that, saying that these properties are no longer available for partition. All of them have been sold in my favor. That is the written statement filed. Then, Lord, but the plaintiff was objecting to that. We paid money to the plaintiff, 3.5 crores, and therefore they said we do not want to press these matters. Where the defendant, even according to his written statement, not one paragraph in the
You're defendant.
defendant. In his written statement, he says these properties have no longer available and it has been sold in my favor.
All right, 1 minute.
Only requesting, Lord's, my habit it next week.
Wait, no, sir.
But I'll
No
place some more
vacating
judgment.
stay I have granted without
Very
hearing.
well, very
Yes.
well. Lord's, please turn to Lord page, the plaint, which is at page 16, the plaint starts.
Oh, it's not my interim order. Yes.
Please note.
Coordinate bench is interim order.
Please. Not the, I am not defendant number 12, not in the suit.
Where is your written statement?
My written statement notes will get it at page 54. Now the suit is filed seeking for, the prayer is at page 37. But the prayer is not for partition consequential division to identify, quantify and allot to the plaintiffs her undivided 1/7 share in the A schedule properties and to put her in actual possession. Not A schedule property, but consists of about not 21 properties. Lord, so please turn to page 38 onwards. They're all not suit A schedule properties. Now, Lord, I am also a family member.
That's not in dispute.
That is not in dispute. Lord, I have filed a written statement at page 54 is my written statement. It is my case that not there was a partition earlier, etc. Lord, that is my contention. And there's another suit that is filed. There's a delay of not 48 years in filing of the suit, etc. Now, Lord, please then turn to Lord, the compromise petition that is filed.
Page
79.
Between whom?
But compromise petition is filed between the plaintiff and defendant number 16. Only two of them.
Concerning which what property?
Concerning Lord, item number 10 of the plaint schedule. 10, 11, 12.
10 ondena?
10, page 90 ಅಲ್ಲಿ 10,
11, 12.
11, 12, 19, 20.
19?
And 20.
19 and 20. With regard to all these properties,
please,
what is your pleading in the written statement?
There are 6 of the.
Lord, I have said that these properties are sold. That is my
page.
Lord,
admittedly, suit schedule properties are self-acquired properties of so and so.
Page 54 it starts. Lord,
I am at 56.
Please.
Disposed suit property son so and so consequently fell in the hands of different 15. Therefore, does not intestate. Sold and
7.
was one of the sons of so and so executed registered sale deed in 67 in favor of so and so right.
There is a release deed. I don't think. that is
Release
what-
deed. Where is the sale? Partitioned all the properties. So defendants are taking steps on virtue of the partition. They must have disposed all the property. in
Lord, I
favor
am
of-
not the one who had sold it. So, Lord, I don't think.
No. The question is not who sold it. Are those properties available today to seek partition?
But there are two issues that come into picture. In a suit for partition, Lord, if it is held by the trial court that the plaintiff has a share of 1/7 in the property, then
The
automatically.
property that is already sold.
Yes, assuming the court holds so. In that event, Lord, automatically even I'll be entitled for a share. And even the other defendants, Lord, in the suit would be entitled for a share. Now, Lord,
Now, who are you?
Lord, I am defendant number 12, who is also a family member.
Wife of?
Lord, I am Lord Prakash Paul, that is at page 20.
Prakash?
Prakash Paul. At page 20.
Who are you in relation to the plaintiff?
Lord, I am this Philomena. I think she is my aunt. Lord, page 23, if my Lord turns to. She is my aunt. Page 20, there is a family tree.
Right. Which paragraph in this judgment saying that compromise, partial compromise cannot be done in a partition suit?
Yes, Lord. Lord, please turn to para 95.
95?
95. 2023 judgment.
Yes.
It is now well settled that under Order 23 Rule 3, as it now stands, when a claim in a suit has been adjusted wholly or in part by way of lawful agreement or compromise, the compromise must be in writing and signed by the parties, and there must be complete agreement between the parties.
All the parties?
All the parties. To constitute an adjustment, agreement and compromise must itself be capable of being embodied in a decree. Now, Lord, here, what can the decree be?
Partial decree.
But there cannot be, because, Lord, ultimately, if it is held, Lord, that they have a share in the property, then even I'll be entitled to it. Then please see Lord, paragraph 96. Indisputably, in the case on hand, plaintiff has not put a signature on the deed of settlement, which was produced before the High Court in the first appeal. The plaintiff has made herself very clear that she never joined in the settlement between her brother, defendant number 1, and the sister, defendant number 2. On this ground alone, settlement could be said to be unlawful, being without any written consent of all the parties. In a suit for partition of joint property, a decree by consent amongst some only of the parties cannot be maintained. But the object is very simple, Lord. What happens is there'll be no proper division ultimately if they succeed. And Lord, it is not a case where Lord you can pick and choose the properties and file for partition. That is why Lord the courts have held in a suit for partition, all properties should be made subject matter.
All properties should be made.
Therefore, Lord, if this property is excluded, the consequence would be there is no one property. Then, Lord, para 97. In Nitya Moni versus so and so, Calcutta High Court observed the decree of subordinate court must be set aside and the whole case retried, because as this suit is for partition of joint property, a decree by consent among some only of the parties cannot possibly maintain. In Veer Singh versus so and so, all the proprietors had not assented to the compromise. The alleged compromise, not having been assented to by all the proprietors, was clearly contrary to law, and the court was therefore fully justified in refusing to enforce it. In para 99, in Tara Prasanna versus so and so, held there can be no compromise binding on all the parties to a suit for partition until and unless all the parties have joined in the compromise. But the object is very, very simple, my lords. In a suit for partition, if you are claiming a right to the property, it should be all the properties, because ultimately there has to be an FDP, there has to be equitable division of the properties. You can't say I will file it in respect of XYZ and delete one of the properties. Enter into compromise selectively insofar as some of the defendants are concerned. Because my lord, multiple properties are sold. It is not only that this property is sold, but multiple properties are sold in favor of various defendants. My lords, please permit me to show even the plaint government itself shows so. But please turn to page 32 for a moment.
Sold when?
Not sold, my lord, during 2005, 2003, 2002, page 32. But this is basically, my lord, blackmailing what is being done. But suit is filed in 2020, in respect of sale deeds that executed in 2002, 2003, 2005, etc. After lapse of 15 years, suit is filed. From the date of sale, various sale deeds are executed, which is reflected at page 32.
Now the respondent is a plaintiff?
Please note.
Respondent is a plaintiff or what?
Not the respondents are plaintiff and also not the person who has entered into
number 16.
Different number 16.
Yes, sir.
Well, I'll show before what is his case before the trial court. Lordships may permit me to place on record his application filed under Order 7, Rule 11 for rejection of the plaint. But in that memo which we have filed now, we have enclosed the application for under Order 7, Rule 11. Permit me to read paragraph 3, not running page 4. This is his case.
Yes.
I state that from a perusal of the averments made in the plaint, it is clear that even according to the plaintiff, the suit schedule properties are the self-acquired properties of late Thomas Appa, who during his lifetime distributed the said properties among his sons, namely, kindly note these names: Anthony Reddy, Arogya Reddy, Chinnaswamy Reddy, Joseph Tyagaraj, and Chauri Reddy. These are the 5 persons. Now, let's permit me to take lordships back to the plaint at page 41.
Yes.
There are about 5 items which have been sold in our favor. Page 41, Lord, item number 10. Item number 10, Lord, lordships may kindly note.
Yes.
Is sold by Thomas Appa himself, in which the petitioner is also a signatory to the sale deed.
This defendant number 12.
Even according to him. All the sons together along with petitioner. Item number 11 now is sold by Chinnaswamy Reddy. Lordships may kindly note that. Chinnaswamy Reddy. Now, para 3 of the Order 7, Rule 11 application, even according.
Yes. All right.
Item number 12, Arogya Reddy, one of the sons. Item number 19, again Arogya Reddy.
Yes.
Item number 20, Anthony Reddy. But according to this petitioner defendant, in his written statement and in his application Order 7, Rule 11, he says, these were all properties much prior to the filing of the suit for partition. My grandfather died intestate. His sons inherited that, and they have all executed registered sale deed. Therefore, the suit for partition should be dismissed. Is his written statement filed in Order 7, Rule 11 application. Now, before the trial court, the only other contesting party before us was, but we had purchased it about 25 years ago, was the plaintiff, these ladies, to whom, lords, we represented that at any rate, it would not be available. Therefore, a detailed compromise petition has been drafted and filed, in which they say, since these properties are no longer available for partition, we restrict our claim to the other properties and give up these claims. and they have collected some money also, about 3.5 crores. Kindly see the compromise petition.
ಈಗ ಇವ್ರಿಗೆ ಬೇಕಾಗಿರೋದು ಅಷ್ಟೇನೆ,
ಯಾರಿಗೆ?
ಮನಿ ಅಷ್ಟೇ. What else?
Kindly see, my lord, page number 79.
15-20 ವರ್ಷ ಅಲ್ಲಿ ಸೂಟ್ ಹಾಕೋದು ಅದಕ್ಕೇನೆ.
Then what? No, even according to them, plaint should be dismissed. And they say this is this compromise petition has been.
What happened to the 711 application?
It's pending. That is pending. But now kindly see, my lord, their compromise petition only, how it has been worded.
Page 95.
Yes. Now, that is the order, my lord. Their claim, they restrict their claim.
Plaintiffs and defendants 16.
Yes. It starts from.
Restrict the claim to what?
To the other scheduled properties. Because of this development, because of the admitted case of the contesting defendant that it has been given, they accept that. Those judgment which my learned friend refers to is when there is a contest between all of them. Even according to the plaintiff, she says that yes, these properties have been given away and they are no longer available for partition. Which
even according to this defendant also.
Even according to the defendant, and we are third party purchasers.
Yes, sir.
Lord, please turn to Lord.
In settlement talks ಆಗ್ಬೇಕಾ ಈಗ?
ಇಲ್ಲ, Lord, I want the suit to be dismissed because according to me there is a partition.
Suit to be
but
dismissed.
what Lord is being done is, Lord, the plaintiff Lord is picking and choosing, Lord, and whenever payment is made, he is withdrawing the suit, which Lord is permissible in law. Lord, I may have filed a rejection of plaint. There is no difficulty. I am not disputing that fact. But the question would be in law. But can the plaintiff pick and choose property and say, I am only going to proceed against this property? But please turn to page 32 for a moment. The sale deed that is executed in favor of the defendant number 16, Lord, is not executed by me or by my father.
No, signatory there. I produce that.
He never said
in that.
You are the witness or signatory.
No, signatory.
That may be true. I'm not.
No, page number 9 of that memo, Lord, which we have filed now. Page number 7 is the sale deed. Page number is the 7 is the sale deed, Lordships get it.
What's the petitioner's name?
Prakash Raj, page number 9, Lordships will get.
I'm there.
11, item, serial number 11.
Prakash Paul ಇದೆಯಲ್ಲ.
Very well. I stand ಅಲ್ಲ plaint ಅಲ್ಲಿ
ಈಗ ಸೆಟಲ್ಮೆಂಟ್ ಟಾಕ್ಸ್ ಆಗ್ಬೇಕು ಅಷ್ಟೇ, ಬೇರೆ ಏನಿಲ್ಲ. ಅವರು 3.5 ಕೋಟಿ ತಗೊಂಡಿದ್ದಾರೆ, ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡು ನಿಮಗೆ ಎಷ್ಟು ಬೇಕು ಅಂತ ಅಷ್ಟೇ.
ನನಗೆ ಹಂಗಲ್ಲ.
ಇನ್ನೇನಿದೆ?
My point is only this.
After 20 ವರ್ಷ ಎಲ್ಲ ಹಾಕೋದು ಇದಕ್ಕೇನೆ.
That is why Lord, I'm saying, Lord, suit itself is not maintainable. But Lord, it cannot be a case where the plaintiff will say, Lord, I will pursue my case against this particular property. Leave rest of the properties. Please look at the situation.
Even according to you, those properties are not available at all.
But I may say that the property is not available, but please see what the plaintiff says. The plaintiff says these properties are available.
You forget about the plaintiff.
No,
you say that it should be dismissed because none of these are available.
Lord, no doubt about it. But kindly see, Lord, the issue would be
arm twisting tactics.
Not arm twisting tactics by the plaintiff, not by me. The plaintiff is trying to say, Lord, I will take one property, let go of that property. Please see what is there in the compromise. No, plaintiff says, kindly see what happens is, if this property is let out from the case, the consequence.
Not even available.
No, that is precisely the case, Lord.
25 years ago, sale deed has happened.
In that event, Lord, the entire plaint
this
has
is
to
permitted, then gone.
But in that event, the entire plaint has to go.
That they have to pursue order
711
Lord. Then, Lord,
court will answer.
What will happen is, Lord, till then, Lord, what happens? Kindly see the situation. So once this property is not left out of the partition, tomorrow, Lord, the property is not available for division, Lord, insofar rest of the parties are concerned.
No problem.
And Lord, the judgment of the apex court, Lord, is
that
directly.
I will consider, no problem. We'll pass orders on Tuesday.
Please.
List on 19th. Yes, at 4 p.m.
The interim order may be extended.
Interim order will continue. Interim order shall continue to the next date.
I'll place on record some more judgments, Lord.
So there is one judgment of Justice Nataraj. In a partition suit, nobody on earth can stop compromise between the parties qua certain properties.
Place on record.
A detailed consideration of all the judgments of the apex court, including this.
Yeah. Very well. I'll have a look. Please. Ultimately, Lord, if the plaint is not
ultimately settle ಆದ್ರೆ ಸರಿ.
ಅಲ್ಲಿ ಎಲ್ಲರನ್ನು ಬಿಟ್ಕೊಟ್ರೆ ನಮ್ಗೆ ತೊಂದರೆ ಇಲ್ಲ. ಈಗ ಒಬ್ಬೊಬ್ಬರನ್ನ ಬಿಟ್ಕೊಂಡು ಹಿಂಗ್ ಮಾಡಿದ್ರೆ that is the difficulty.
711 application.
Yes. If the court observes something on that nature, Lord, I will be grateful.
You will withdraw the petition?
No problem. Hangala.
Let the court answer 711 application, you withdraw the petition, all contentions remain open. That's all.
No, if they withdraw the suit, Lord, I have no difficulty.
No, it's not the plaintiff.
No, the plaintiff is the one who is not entered into.
711 application, rejection of plaint ಮೇಲೆ ಆಗ್ಲಿ ಬಿಡಿ.
Right.
What do I do? Close it?
No. Have it on Tuesday.
Ah, then no problem.
I'm saying, Lord, if the plaintiff withdraws his case, then Lord, I have no Lord grievance at all.
Plaint ಹೋದ್ರೆ ನೀನ್ grievance ಇರುತ್ತೆ.
Please.
Yes. Heartburn because of compromise with others ಅಷ್ಟೇ.
No, not a heartburn in the sense.
What else?
I don't want anything from
They
them.
have also received
I
money.
don't want
Manoj. It is
anything
not-
from different number 16.
No, they have also received substantial amount. It's not that they have not.
I don't want anything from different number 16. I want the plaintiff to let me go. Because
Let me go with what?
I don't want anything from the plaintiff.
ಏನು ಬೇಡವಾ?
Nothing.
ಬಿಡಿ ಮತ್ತೆ.
But he is asking my properties. My difficulty is that he is not holding on to my properties, but he wants to let go of the property of different number 16.
We'll see. Yes.
That is where not the difficulty is. Please.
52.
Petitioner, my lord.
Why do you want the bank to be a defendant?
No, I have not made him as a
52
defendant.
ತಾನೆ?
They filed a impleading.
We have filed order 1/10 lordship.
You want to come into the proceeding?
Yeah, the thing is.
What? Yeah.
Apologies, lordship.
Yes.
The thing is, they have filed the initial P&C proceedings, lordship.
P&C.
Yes, initially the P&C.
Who filed the application order on Rule 10?
It's filed by the respondent number 3.
Respondent number 3, yeah.
Current cooperative bank, lordship.
Bank itself?
Yes, lordship.
Why?
The reason is, in the declaration suit, the entire original documents are with the bank. In the declaration suit, they called for all the original documents along with the bank to produce an evidence. And that in that particular thing, in between the defendant number 1 challenged the P&C probate order before the Honorable High Court. The Honorable High Court set aside the probate order, ex parte probate order, remanded back the matter. Because of that, the declaration suit very much instituted based on the probate was been dismissed because of the remand of the matter. Once that P&C had been converted to the OS before the trial court, we are never the parties. But now the entire loan amount of more than 1 crore had been given to the borrower, who is also not the party. That is the reason in the OS, which is
No, that is allowed.
Yes, that is being allowed.
Yes, sir.
Against that, we have preferred.
Correct. ಅದಕ್ಕೆ ಯಾಕೆ ಅಂತ?
ಅದಕ್ಕೆ ಅಂತ. Now he is a third party.
Who?
The bank.
Suit for what?
The bank suit for P&C for
P&C.
probate.
ಅಲ್ಲ, P&C is converted to OS.
No, that is a declaration current. That is the
Converted to OS
declaration.
because of the dispute. Nobody accepts the contention.
No, that P&C earlier it was decreed as ex parte. Against
ಹೌದು,
that, they preferred.
this court sent it back to hear it as a suit.
Yes, ma'am.
ಮತ್ತೆ?
Now he cannot interfere. He is not a family member.
Family member. P&C family member ಅಲ್ಲ.
P&C,
Whoever is having the
we
interest.
have filed application for issuance of probate certificate. Now that is pending.
No, who has
In
taken
that
loan
suit-
from you?
The loan, our vendor's vendor is the person who got his gift deed of this property from his father. Vendor's vendor. Then after that, that particular son was sold it to the one Abhinandan. Abhinandan was sold to my borrower, who's taken more than 1 CR of the loan. And that time there is no interim order. And when these people have in the declaration suit call all the original documents from the bank, then only we come to know this is the suit is pending. Then that declaration suit had been dismissed because of the demand of the P&C order.
Now they have mortgaged the property on 8/10/2021. The property registered in their name on
This is suit for
11/10/21.
declaration.
Now they are.
ಈಗ OS ಕನ್ವರ್ಟ್ ಆಗಿರೋದು ಯಾವ್ದು? P&C is converted.
P&C contested matter is converted to the OS.
ಅದ್ರಲ್ಲಿ ನೀವೇನ್ ಮಾಡ್ತೀರಾ?
The thing is, lordship, now we have the knowledge.
No, let
File
them
a separate suit. P&C ಅಲ್ಲಿ how can you come in?
My lord, the thing is, even there are other connected matters also, lordship. Even in the will, the witness, the lordship also considered.
Well, ಏನು?
There was a witness who signed that will, comes before this honorable court saying that I never been given any evidence. The lordship considered that matter and stayed that proceedings and asked to connect it to, along with the multiple matter that is also produced along with the statement of objection of respondent number 1.
Page?
Statement of objection, respondent number 1, lordship.
Objection of vacating stay application.
Objection of filed by the respondent number 1, page number 39. This is the matter, lordship, where even the witness signature, everything had been forged before the trial court when getting the P&C ex parte order. And that witness comes before the High Court saying that I have never been appeared before the trial court for getting the.
Where is the order?
The statement of objection filed by respondent number 1, the page number.
Synopsis, objection to vacating Objection to vacating stay. Where is the objection filed? There is no objection filed.
13/9/2024, Your Worship, page 32. The petition filed by the.
13/9.
Page 32, Your Worship. The petition filed by the witness.
Objection filed by you.
R1.
R1 ಯಾರು?
R1 is.
ನೀವೇ ಅಲ್ವಾ? ಎಲ್ಲಿದೆ objection? ಕೊಡಿ. ಕೊಡಿ ಮಾಡಿ.
Synopsis along with the document. Page 32.
Objection na synopsis correct ಆಗಿ ಹೇಳಿ.
Synopsis, along with the synopsis, I have produced certain documents, Your Worship.
Is that the objection?
Objection I have filed, Your Worship.
Yes, it is along with.
You either refer to objection or refer to synopsis or refer to something. Correct ಆಗಿ refer ಮಾಡಿ.
Kindly, Your Worship. Page.
ಮಾತ್ರ
Page 36, Your Worship, along with my objection.
ಮತ್ತೆ objection ಅಂತ ಇದ್ದೀರಾ?
ಎರಡು ಹಾಕಿದೆ. ಒಂದು ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಸಿನಾಪ್ಸಿಸ್ ಆದ್ದು, ಅದರಲ್ಲಿ ಸರ್ಟನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿ.
This will was executed.
The PCR filed by the witness. And he stated that he is not entered the witness box, and
Page
32 is the complaint.
Where is my order?
It is not quashed, Lordship, it is stayed.
Not quashed, it's
It is connected with, along with the other connected with the petition.
Which
The
is
page
that?
number,
Which
page
is
number
that?
40. 49 and 50, 49 and 50, that is the thing. That is been served to me, that is the thing. And it runs to the 53 also.
Thirdly, tag this petition along with
That was multiple.
WP 28767 of 2023. Yes, list on 3rd September. Yes, next.
The interim order.
Interim order subsisting will continue to the next date.
53, adjourn 54.
Serial number 53, the respondent has taken a time for 4 weeks.
Respondents taken?
Taken a time.
ಯಾವ್ದ್ರಲ್ಲಿ?
53 ಅಲ್ಲಿ interim order may be extended.
Interim order is extended.
ಅದು ನನಗೆ 4 weeks ಅಂತ ಮೆಸೇಜ್ ಹಾಕಿದ್ರು.
ಆಯ್ತು ಸರಿ. ಬರೀ 4 weeks ಅಂತ ಹಾಕ್ಬಿಟ್ರಾ?
ಅವ್ರು 4 weeks ಅಂತ ಹೇಳಿ.
ಅವ್ರ್ಯಾಕೆ ಹೇಳ್ತಾರೆ interim order extend ಆಗಿದೆ ಅಂತ? Yes. Next.
The suit is
54.
54, Malad. The suit is of the year 1991.
Yes, Sachin.
I place synopsis on.
What synopsis? Partition Act ಪ್ರಕಾರ ನಿಮಗೆ ಕೊಡ್ಬೇಕಾಗಿತ್ತು ಅಂತ ಅದಾ?
ಇಲ್ಲ, my lords, my submission before my lords is that the subject property is 22 acres and odd. My lords, the partition, the preliminary decrease, my lords may have a look at the synopsis.
Yes, we'll hear it on Wednesday, 20th. Just on 20th in preliminary hearing. Yes, next.
Interim order be extended.
Interim order will continue.
55.
Appearing for the petition. Your Lordship, the petitioner is the plaintiff in the lower court, Your Lordship.
2610A.
Swami?
2610A application.
2610 Allah, Swami.
ಮತ್ತೆ?
This is an application where an interesting application was filed with the defendant number 3, challenging my signatures in plaint and verifying affidavit, sorry, Your Lordship. I am not challenging my signature on the plaintiff and verifying affidavit.
Commercial OS.
Commercial OS. In commercial.
22 in the pending idea.
How this
So
one?
they have
22.
on more than one occasion got interim orders from this court.
Yes, sir. Come on.
Your Lordship.
Really?
I'll argue the matter.
Argue.
Swami, this is a case where we have filed for arrears of rent. Arrears of rent commercial property number 1 file ಮಾಡಿದ್ರು sir. It came for the stage of arguments. They filed an application before the honorable trial court, stating that the signatures which are available in the plaint and statement of truth are not of the plaintiff. We have not denied that. We are telling that is our signature. Then this application does not survive for consideration. But the honorable trial court has passed an order for sending our signatures to FSL, Your Lordship.
Admitted signatures.
Admitted signatures.
Yes, sir. Why?
But what happens is there is a discrepancy in the signatures.
Name the plaintiff. You are the plaintiff.
I'm the
Defendant number 3, sir.
The reason is that statement of truth, if it is not properly attested, it's a ground for rejection.
I mean, of course, your lordships would see that there is a discrepancy. Physically to the eye, it is visible that there is a discrepancy between what is shown in the plaint and the.
He's admitting it is his.
Yes, he says it is so. But the point is that person has not stepped into the witness box. Somebody else comes in and gives evidence as power of attorney holder. How is that to be tested? Because ultimately the statement of truth carries a certain weight.
That's all right. Now it is the petitioner here.
That's correct.
He's
She.
She is submitting that before the court. I will record it. No problem.
I'm sorry, my lord. Even here, the verifying affidavit before your lordship is sworn to by the power of attorney holder.
That is the husband's son.
Now,
Alright,
she's
can I just
admitting
make-
that it is both same.
It is not. It is visible to the eye that it's not. Therefore, then, my lord, there have to be one of two things.
He will either fall or rise on that ground. That's all. It is his peril that he is admitting it.
I bow down to that,
Then
but I just have to
over,
make one further submission, which
Yes.
is this. There was already a foreign, the commissioner came to be appointed. What happened was, in fact, upon the fact that the commissioner was appointed, this court disposed of the writ petition. The forensic science laboratory commissioner would say that the originals need to be made available for comparison, and therefore that got delayed. That is why the writ has been revived by them. That's
So that's all right. The lady herself is saying both the signature are
I bow
hers.
down to that. I bow
And
down because it is not. But the question is simply this: the lady is not saying it.
Here, who is the petitioner here?
Power of attorney holder is the one who sworn to this affidavit. I mean, I'm just placing that because the person whose signature is in question has not entered the witness box.
I will record that tomorrow that projection of that thing will not be there before the court saying that signatures are not mine.
No, my lord, quite so. But there is one other aspect, my lord. Your lordship, may please keep my defense also open for only this reason.
For what?
For the reason that it could be also a ground for rejection and consequently dismissal. Suppose if it's a ground for rejection, I also get a ground for dismissal, my lord. That is my.
So if the signature is varying.
Yes.
It is not varying now.
It is not. No.
I will say signature is the same.
I quite
Admit
see.
it.
It is like this.
Forensic ಹೋಗ್ಬೇಕು.
ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ it is not the same. It is, my lord, I can admit and say this is red, but it doesn't make it red. That is my submission.
That's all right.
That is what I wanted to point out. This is where it is at. Because only thing is then if I have the right to say, for example, claim adverse inference, all of those, my contentions may be please kept open. That's all I'm saying.
Adverse inference at the end of the trial.
Yeah, of course, my lord, because possibly if this does not go through, evidence is over. Evidence is otherwise over.
Final argument,
Evidence is otherwise over. That's why.
Final
Adverse
argument,
inference,
then-
now is the right time, my lord, to keep that open is all.
The plaintiff was admitting it is her signature.
A plaintiff is not admitting, somebody else is
Yeah, I
admitting
am
on behalf of
saying
the
he
plaintiff.
will, this is recording before the court.
Before the court, your lord.
The petitioner is before this court calling in question an order dated 1/7/2024 by which the signatures of the petitioner, the plaintiff, is sought to be sent for forensic examination on an application filed by the defendant. The learned counsel appearing for the petitioner would admit, learned counsel for the petitioner would admit that both the signatures that even if it is construed to be varying are that of the plaintiff, that of the plaintiff, and there can be no dispute about it, and the plaintiff will not dispute about it during the pendency of the proceedings. The learned senior counsel C.K. Nandakumar submits that the plaintiff is not saying so, but the power of attorney, and therefore all rights should be reserved to the defendants to seek to claim adverse inference on that score at the end of the trial, which which the parties would submit has come to an end.
Also, my lord, because he has not, the plaintiff has not entered the witness box. but
More so in the light of the fact that the plaintiff has not entered the witness box, but it is the power of attorney holder who is now representing the plaintiff even to tender evidence.
Husband is
The
the power of attorney is husband. Husband is the power of attorney.
ನಿಮಗೆ ಬರ್ತೀನಿ ತಾಳಿ. The learned counsel appearing for the petitioner plaintiff submits that the power of attorney holder is the husband, and the husband has tendered evidence on behalf of the wife. Be that as it may, in the light of the admission of the plaintiff that the signatures which are now sought to be sent to forensic examination are hers and would not dispute the same during the proceedings. During the proceedings, the issue gets resolved on the said submission. Therefore, the order that is impugned in the subject petition to refer the signatures to forensic examination would become unnecessary in the light of the said submission. For the aforesaid reasons, the following order: allowed, quashed, all All contentions that are urged in the petition or the respondent in the objections hakidira?
ಇಲ್ಲೂ objections ಹಾಕಿಲ್ಲ ಅಲ್ಲಿ.
All contentions,
sorry,
all
objections ಇಲ್ಲೂ
contentions,
ಹಾಕಿದೀವಿ and application.
all contentions except the one that is answered by this court shall remain open to be urged before the concerned court,
Great.
ordered accordingly. Yes.
56.
Permission to prosecute.
That because that he was not a party before the court, my lord.
Ah,
So therefore I filed an application.
ಆಯ್ತು ಏನಾಗಿದೆ ಈಗ?
That the compromise was entered into.
Ah,
That before the local.
suit for?
Suit for partition. Before the local it was entered within 2-3 days that the compromise was entered.
All the properties are
The properties
closed?
are there.
Who are you?
Closed. That I am son of the defendant number 1.
Son of?
Defendant number 1.
Son of Sadashinivas Reddy.
Fourth respondent.
Fourth respondent.
Fourth respondent.
Because that the partition is
No,
not.
ಅದೇ
equal, that is
Sadashiva
my-
Reddy.
Yes, that the properties are not equally partitioned, my lord, that it is my allegation.
Yes, sir.
Lord, it is whatever property that his father, that is IAP for fourth respondent, he's got more property. He's only challenging the quantum, my lord.
Amount.
Yeah, quantum of the property.
Properties.
He abandoned me 16 years back. He is not even taking care
ಅದೆಲ್ಲ
of me.
they will spring only when the litigation comes.
Yes, my lord.
That it is
Litigation, compensation, ಅವಾಗ relate, ಎಲ್ಲ sons, daughters from nowhere they will come.
No, that it is only under that circumstance only that it is filed.
2000
want to settle
itself,
it,
oral
settle it.
partition has taken place. Accordingly, the compromise petition was entered.
Yes, you want to settle it, settle it.
There is nothing to settle, my lord.
ಏನು
He will
ಇಲ್ವಾ?
get after me. That's it.
That the properties, my lord, that the allotted, it is not equal.
That will permit him to prosecute. Will allow the application, hear it on a different date. For the reasons indicated in the affidavit accompanying the application IA 1 of 2025 stands allowed. The list the matter on 17th September.
Interim order, my lord, that
No,
they shall not alienate, that's only there.
yes, next.
57.
In connected.
Malaj, appear for the petitioner, Malaj.
Wicketting stay ಇಲ್ಲ ಅಲ್ಲ?
ಇಲ್ಲ, Malaj.
Ah, yes.
Malaj.
Objections also, my lord. I have to file objections.
Ah,
my lord, for
file.
the petition.
Learned counsel appearing for the respondent seeks 2 weeks time to file statement of objections. List the matter on,
Malaj, kindly pass over the matter, Malaj.
interim order ಇದೆಯಾ?
Yeah, Malaj.
List the matter on 17th September. Objections, if any, by then interim order subsisting will continue to the next date of hearing. Next.
Malaj, interim orders in 18793 to be extended, Malaj.
ಮಾಡಾಯ್ತು. Yes. Madam, ಇದು dispensation is for the reasons indicated in the affidavit accompanying the application. ಎಲ್ಲ dispensation allow ಮಾಡ್ಬಿಡು madam. Yes. Next.
8 urgent. 59. Appear for the petitioner in this matter. I've just served a copy on the contesting respondent.
What copy?
Copy of the petition.
ಇವಾಗ ಕೊಟ್ರಿ. ಮಧ್ಯಾಹ್ನ adjournment ಯಾರೋ
Yeah,
object
I
ಮಾಡಿದ್ರಲ್ಲ?
mentioned.
You objected.
I know, I didn't object.
Who
I
objected?
mentioned.
Short accommodation. We'll take it another day, 17th. Yes,
The order may be extended.
17th September. Interim order subsisting will continue to the next date. Next,
Date maybe.
17th.
10.
Yes.
Urgent 61.
This is I've served copies on the counsel appearing for the respondent. I've taken steps also. This is a matter where the mandatory requirement under section 12A has not been complied with. Suit is for ejectment. There is absolutely no urgency pleaded.
List the matter on 17th September, awaiting the representation of the respondent. Interim order subsisting will continue to the next date of hearing.
Much of.
Next.
62 urgent 63.
No representation. Interim order ನೋಡಿ. List after 4 weeks. Registry is directed not to list the matter prior to the expiry of 4 weeks. Next.
64.
Same order.
65.
ಹಾಕಿ ಸರ್, ಅದಕ್ಕೆ ಯಾರು ಬೇಡ ಅಂತ.
Petitioner
Vincent.
in both cases, my lord.
What are these? Huh?
I had filed an IA under Order 7 Rule 11D, which was rejected. I filed a review. The review
Oh,
was also.
CRP connect ಆಗಿದೆಯಾ?
ಹೌದು.
First we'll take the CRP.
Yes, please.
286 days delay.
That delay is mainly because I filed a review.
Oh.
And after that, that's
Yes,
not the only thing,
Raghunath,
but that's.
will condone the delay. Yes. For the reasons indicated in the affidavit accompanying the application and being satisfied with the same, more so in the light of the fact that the respondent has no objection to condone the delay. Delay of 286 days in filing the petition stands condoned. Yes. I sorry bide, tagadu bide. More so in the tagadu bide, condone madad madi. Yes.
My lord. The plaint was amended, my lord.
Suit for?
The suit for, in this case, to declare that.
I am holding CRP. What is this suit for?
My lord, this suit.
Suit for under page 22 on
The prayer is to set aside a gift deed which was made in my favor by my father. And secondly, declare that my adoption deed is to be cancelled. Now.
Who is the plaintiff?
Plaintiff is the mother who adopted.
This is the respondent is the plaintiff.
Respondent plaintiff.
ಈಗ 711 ರಿಜೆಕ್ಟ್ ಆಗಿದೆಯಾ?
Reject type.
Correct ಆಗಿದೆ. It's a matter of evidence.
No, my lord, may I point out the very pleadings themselves? I'll point out from the pleadings.
According to you, 711 A and D?
D, my lord.
D, limitation.
One is limitation.
3 is cause of action.
Both, my lord. One is limitation with regard to the gift deed. The other is regarding the adoption deed. A validly executed adoption.
Plaint. Where is the plaint? Page.
I'll take my lord to that. Page 22. May I take my lord directly to page number 34.
20?
Starts at page 22. Page 34 is the relevant portion, if I may point out. Starting from 27F, my lord.
Who is the donor?
My father.
And who is the plaintiff?
My mother. Kindly go to page 34, my lord. If I may further submit, this has to do with the cousins. They are the power of attorney holders who are pursuing the case on her behalf. Now, my lord may kindly turn to page 34, starting with 27F. The plaintiff further submits that since the defendant has been careless and not taking care of the plaintiff, the adoption deed dated 13/5/92, which is registered as document number 72, book 4, so on and so forth, has no legal sanctity and is liable to be cancelled. Now, the next one. The plaintiff submits that she had entered into an agreement of purchase of property so and so in 1991. However, the sale deed has not been executed in favor of the plaintiff. The sale deed was executed in favor of late K.M. Chetty by overlooking the agreement of sale executed in her favor. As such, K.M. Chetty had no right, title and interest in respect of the aforesaid property, could not convey any right, title, interest in favor of the plaintiff, as the property is owned by her. The sale consideration was paid by this plaintiff, and therefore on the demise of K.M. Chetty, she is entitled to absolute share. The cause of action.
There is an interim order here?
There is in WP, there is an interim order.
CRP lilva?
CRP, the delay is only now condoned.
only ground which they have sought for rejection of the plaint is not in the, as far as para 27F is concerned. My lord may kindly see the application filed by them, which is at
Page 50.
page 50.
All right.
59.
52 affidavit is 54.
Page 52, annexure E, my lord. But they say that they reject the plaint in the above case as barred by law. Not the affidavit specifies as regards to adoption only. Not para 2 of the affidavit, which is at page 54. I
Yes,
submit.
we'll hear. We'll stay the proceedings there.
Lord, I am not been taken care of. I am.
That
from
we'll
adoptive
see.
mother.
Taken care of under, what do you mean taken care of?
He is residing with his natural parents.
Natural
sorry.
parent?
Yes.
I'm
Both
sorry.
myself and my husband
Ah.
adopted the petitioner herein, please.
Oh.
We don't have children. After adoption, after taking the benefits from the property and adoption,
Your property?
please, my lord,
Hmm.
and my husband's property, both.
Hmm.
My lord, I am at mercy of my relatives. I have not been taken care of by anyone.
Yes, sir.
My lord, that is entirely untrue.
Oh, very.
They have taken her away when the father died. The father-in-law and brother-in-law of the defendant, the petitioner herein, were even
We'll give you
assaulted.
15 days time. Sit across and settle the dispute.
My lord, if she
Otherwise-
is called to this court, my lord, she can be asked directly what she has to say about it.
We will
Because the
direct
power of-
whatever care you want to be taken off. Otherwise, petition, CRP, Order 7, Rule 11 has to be allowed. Has to be allowed. ನಿಮಗ್ ಬೇಕಾದ cause of action ಅಲ್ಲ.
My lord, may kindly see the reason for. My lord, there are other prayers in the suit. Not, the suit can't be dismissed partly, please, my lord, under Order 7, Rule 11. Kindly see the other
Of
reliefs.
course,
which I have
Order
sought
7,
for.
Rule 11 suit can't be dismissed partially.
Please, my lord.
Either it is to stay or go.
My lord, I have sought for cancellation, declaring that the gift deed is not.
ಒಂದೇ revolves around the gift deed ಅಷ್ಟೇ, ಬೇರೆ ಏನಿಲ್ಲ ಅಲ್ಲಿ.
And for being profits and challenging the adoption. My lord,
Challenging adoption ಯಾವಾಗ ಆಗಿದ್ದು?
adoption of the year 1992.
Anything else, sir?
Lord, who is taking care of me? My lord?
That we will see. ಅದಕ್ಕೆ ಸೆಟಲ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿ.
Lord, he files a suit
ಇದು
for
otherwise
partition
these
also.
things, no.
Lord, apart from this, he files a suit for partition.
Somebody else is shooting from your shoulder. Yes.
Certainly not. I am dependent on, let him take care, my lord.
Correct.
My lord,
We'll-
Why is
let
it
them
direct
send
that.
her.
We'll direct taking care. You want monthly maintenance?
Certainly, let
How
him.
much?
My lord, monthly maintenance is being paid, but that's not the issue. Let them please send her. We will take her and look after her.
Let him give an
They are not-
undertaking that he will not ill-treat me. He'll
Ill-treat?
take my-
Yes, certainly, my lord.
He has,
Give that
ill-treated.
undertaking.
See my
Let her be called to the court. We'll take her home.
No, the moment he ill-treats you, we will revive all these proceedings.
Not my condition.
He will not ill-treat you, sir. Please go and
He has
stay.
done it, my lord. That is the reason.
Don't worry,
I
sir.
had to
Please go
file
and
this
stay
suit.
now.
Lord, this is my condition.
ಅದಕ್ಕೆ he will take care of you. You want someone to take care of you,
Certainly.
correct? Your son is there, he will take care of you.
He is staying with his natural parents.
That doesn't mean that you should not be
Why
taken
should
care
he
of.
stay with his
May
natural
I
parents?
put it this way?
Why should he stay?
After
My
I
lord.
adopt him, my lord, after he takes benefit from me, he has no
ಈಗ
moral.
ಎಷ್ಟು ಕೊಡ್ತಾ ಇದ್ದಾರೆ ಮೇಂಟೆನೆನ್ಸ್?
I don't.
My lord, they went to the senior citizen.
ಎಷ್ಟು
tribunal.
ಕೊಡ್ತಾ? Question
ಇಪ್ಪತ್ತು
answer
ಸ್ವಾಮಿ.
ಮಾಡ. You'll always
20,
beg the question.
20.
20.
20 was ordered, though it said 10. The act says 10. We have not challenged that order 20. We have said even now, please send her home. We are ready to take care of her. He is not staying with his natural parents. He is staying with his wife and his son.
Natural wife.
Natural wife, yes.
All right.
And he is staying with his wife and his child, one or two children now. And in fact, if I may go still further, when the mother was in hospital after the father died, and he was assaulted by the cousins and others, a criminal
It's all
PCR
right.
is pending.
No, this story will be very nice, but
It
not
will be
necessary.
rather long, my lord, but
Wait,
the
wait.
fact
Ah,
is,
of course long.
the
It will
mother-
always be long.
The mother was ready to come home. She made the mistake of telling her, my
Now
son
you will
is
take care
coming
of,
tomorrow to
you
take
take
me.
care of her, or I'll increase the maintenance to 50,000.
Very
Give
well,
reasons.
my lord, we'll take care of her. She may be,
So I'll keep her present on the next date, please.
my lord, that would be,
I'll take it on 29th. By
Please.
then you sit across
Please.
and close this.
my lord, may it be taken just before that, my lord.
Why?
I will not be in station on 20.
ಯಾವತ್ ಬೇಕು ಹೇಳಿ?
Before
ನೀವೇ
the-
ಡೇಟ್ ಹೇಳಿ.
My lord, 22nd, 23rd.
All right, 23rd. 22nd, yes.
22nd.
22nd at 4 PM you come.
Please.
Obliged.
Heard the learned counsel appearing for the parties. The court is of the opinion that if time is granted up to 22nd, parties could explore the possibilities of a settlement, as the tussle is between the mother and the son, albeit the adopted son. Let's just till such time, all proceedings before the concerned court concerning the issue shall remain stayed.
It is already been said. Little stay.
CRP lo ಆಗಿದೆಯಾ?
CRP ಆಗಿಲ್ಲ.
CRP li ಮಾಡಿ ಅದು.
ಅಲ್ಲ ರಿಟಲ್ ಸ್ಟೇ ಇರೋದ್ರಿಂದ ಎರಡು
ಆಯ್ತು, ಎರಡರಲ್ಲೂ ಇರಲಿ ಬಿಡಿ.
ಆಯ್ತು. ಈ should we
It
keep
will
the parties present?
ease settlement ಅಷ್ಟೇ.
Should we keep the parties present?
Not necessary, you settle it. ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಇನ್ನೊಂದ್ ದಿನ will take parties.
May I request that the parties be kept present to make it.
4 PM parties be present before the court.
Obliged. 22nd.
With the kindly of this court, my lords, matter priced to 66 minutes.
66 ಬೇಡವಾ?
My apologies, my lords.
66.
Please.
ಯಾಕೆ?
It was caught, my lord.
ನಿಮ್ದು ಕರೆಯಲ್ಲ ಅಂತ ಡೌಟ್ ಇತ್ತಾ?
ಇಲ್ಲ.
ಮತ್ತೆ ಯಾಕೆ?
My lords, 66 least one is adjourned, that's what I had, my lords.
I'm appearing for petition.
64 ನಿಮ್ದು.
Please,
ಮತ್ತೆ?
I'm sorry. A matter got overlapped, my lords. Any date if my lords could permit.
ಯಾವತ್ತು ಕೊಟ್ಟಿರ್ಬೇಕು ಡೇಟ್?
ಇಲ್ಲ, 2 weeks ಅಂತ ಆಯ್ತಂತೆ ಅದಕ್ಕೆ.
ನೀವು ಇರ್ಲಿಲ್ಲ ಅಲ್ಲ?
ಇಲ್ಲ, I just heard, my lords. I just went down.
10th.
Great.
I'm appearing for petition, my lord. It is a plaintiff writ petition. Suit for declaration for easementary right in respect of two schedule B property, my lord. Trial court is order for temporary injunction. IA is allowed. First appellate court set aside.
Divergent finding. ಆಯ್ತು, ಇಬ್ರು ಯೂಸ್ ಮಾಡ್ತಾ ಇರಿ ಈಗ. ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ?
No, in fact, your lordship, there were 3 deeds, 2 partition deeds and 1 sale deed, my lord. In none of the deeds, there is no specification with regard to some certain roads, my lord, especially the easement.
ಆಯ್ತು, easement right. What is the area? 3 feet, 2 feet, 5 feet?
According to schedule B, my lord, it's 10 feet into 120 square feet.
It is pertaining to, we are all joint family members, my lord. Joint family members. It has been divided.
No, that
only
was
one
not the
side.
case, my lord.
ಆಯ್ತು, ಈಗ ಇಬ್ರು ಯೂಸ್ ಮಾಡಕ್ಕೆ ಏನ್ ಪ್ರಾಬ್ಲಮ್?
Lord, we have a separate road and there is an alternate road. That
I
is
will
our
hear
case,
the
my lord.
matter. Status quo be maintained by the parties. Yes. Ida, this matter.
Really all-
My lord, para 19, my lord. Para 19 of first appellate court order.
First appellate court order dated ಏನು?
Page number 24, my lord.
Injunction ಕೊಟ್ಟಿದ್ದ ಡೇಟ್ ಏನು? 7/11/23.
Lord, till today they are
ಒಂದ್
using
ನಿಮಿಷ.
the alternate road, my lord.
ಒಂದ್ ನಿಮಿಷ. ಈಗ 24th October 24 ಇಂದ ಅಲ್ಲ ವರೆಗೂ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
ಅಲ್ಲ, ಅವ್ರು ಬೇರೆ ರೋಡ್ ಯೂಸ್ ಮಾಡ್ತಾರೆ. There is alternate road. That is our case, my lord.
1 minute. There was an injunction granted.
Please, my lord.
Injunction was subsisting for 1 year.
Please, my lord.
What were you doing then?
Lord, we had challenged in MA, my lord.
ಅದಲ್ಲ ಸರ್, ಯಾವ ರೋಡ್ ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
We were using our road, which is adjacent to our land, my lord.
ಇವ್ರದ್ದು?
He was using the alternate road. That is what our case is.
My lord, para 19, my lord. Kindly
Sir,
see.
this writ petition is of 2024, my lord. They are using, even till date, they are using the other road.
My lord, para 20,
ಆಯ್ತು, we'll see.
19, my lord.
List the matter on 17 September. Parties to maintain status quo quo the easementary rights till the next date of hearing. ಅಷ್ಟೇ. ಯಾವ್ದು ಯೂಸ್ ಮಾಡ್ತಿದ್ರೆ ಅದನ್ನ ಯೂಸ್ ಮಾಡಿ. Yes.
67.
It is Allah will let the suit go on. It is made clear. Then we'll dispose it and send it. Status quo early. Let the suit be decided. Sorry, 1 minute.
They are saying that the easement is by necessity.
And then we'll decide it. Yes, there lies the problem. 17th. Yes.
This is the
This is
amendment application. That matter which we had argued for some time before your lordships last time. The issue, my lord, was with respect to essentially Schedule A property. Schedule A property, my lord, was about 1 acre of land, which under an arbitration and through a court sale, I purchased.
Talks of settlement in Aglilwa.
At some point in time, there was some discussion.
23/7/25 recorded that stocks of settlement are on.
It was attempted, but it couldn't fail.
Attempted ಅಂದ್ರೆ?
ಪ್ರಯತ್ನ ಮಾಡಿದ್ವಿ, ಆಗಲಿಲ್ಲ.
Yes.
Lord, can I request my lord to kindly see the plaint? The plaint, my lord, and specifically the schedule. The case of the plaintiff was that he had formed sites in this area, which is from Schedule A to Schedule G.
Picketing stack ಇದೀರಾ?
ಇಲ್ಲ, stay ಇಲ್ಲ.
Stay ಇಲ್ವಾ? Yes.
Stay ಇಲ್ಲ. It is.
ಏನ್ ಬೇಡಲ್ಲ?
Lordship may hear and dispose it off. No? That's why we are arguing.
Correct, but not today.
Whenever it's convenient to the
22nd?
Yes.
List the matter on 22nd. Because the second list matters in.
I know.
Yes. 22nd.
68, 69 adjourned, 70.
I'm for the petitioners, my lord. My lords, I am a bit unwell, therefore I am on VC.
It's all right. Tell me, sir.
Yes, sir. My lords, the impugned order here is that, my lords, the petitioners had filed a suit in OS number 132/1997, wherein a compromise with decree was executed between the parties on 9/1/1998, my lords. Subsequently, a suit comes to be filed challenging the decree passed in OS number 132/1997 in the year 2018, my lords. That is OS number 30/2018. Then, my lords, a CRP was preferred before this honorable court subsequent to an application under Order 7, Rule 11 D, my lords, that a fresh suit challenging the decree which has been passed in another case is not maintainable. This honorable court, my lords, through its order dated 22/9/2023, my lords, allowed the revision petition, and my lords had said that any application that had to be moved in OS number 132/1997 in accordance with law, that may be done so, and the same has to be considered in accordance with law by the court, that is the senior division court at Tiptur, my lords. While that being the circumstance, a case which has been declared, my lords, in OS number 30/2018 as not maintainable. Now, my lords, an application comes to be filed in OS number 132/1997, asking the court to summon for records in OS number 30/2018, which has been considered as null and void in the eye of law and non-est in the eye of law, my lords, and also came to be dismissed before this honorable court.
No, again, what are you challenging now?
Now, my lords, the impugned order, my lords, I draw the attention of this
Page.
court. Yes, my lords.
Page.
Yes, please, my lords. At page number 34 is the impugned order, my lords.
30?
34, 3-4, my lords.
54 on.
This way, my lords.
What is the order?
Just a minute, my lords.
Steps.
Just a minute, my lords. I am sorry, my lords, I draw the attention of this honorable court 103, my lords, page number 103.
103.
103. Here comes to be an order which is passed, my lords, allowing IA number 3. Here, my lords, the order is that calling for records in OS number 30/2018, my lords, which came to be dismissed by virtue of the order of this honorable court. There was not even pleadings which had been completed. It had been summarily dismissed at the stage of the filing of the plaint itself, my lords. That is the stage of first hearing itself, it came to be dismissed. That record is called for. This, my lords, is done in order to prolong the proceedings in OS number 132/1997, my lords. Therefore, any document, it can be directly produced before this honorable court. It need not be summoned from OS number 30/2018, my lords. Is all the case before this honorable court. And specific reason as to why this application has to be allowed also has not been spelled out categorically in the order, my lords.
Yes, sir.
Fraud has been played on the court.
On which court?
The court which disposed of the suit OS number 132 of 1997.
All right.
By producing a concocted power of attorney stated to have been executed by these persons.
Independently ಅದು ಕೇಳಲಿ. Why do you need OS
Yes.
30 of 2018
Correct.
records?
Yes. In OS 30 of 2018, the petitioner before this honorable court was a party, produced that the power of attorney stated to have been executed by the petition.
But the coordinate bench says that suit is rejected and that those documents cannot be taken.
I am not on that point. We are not
The court is on that point only.
No, I am submitting before this honorable court. Now kindly just make a note of 2 dates that would be relevant.
No problem. Really.
Please. OS number 132 of 1997 was filed on 1/2/1997. 1/12/1997. 1/12/1997 is the date of filing of the suit. Now the court ordered for.
What was the suit for?
Suit for declaration and permanent injunction, contending that on the basis of the so-called will stated to have been executed by one Muhammad Zafar Mahyuddin, who was not at all in any way related to the petitioner before this honorable court. We are the sons and children of Muhammad Zafar Mahyuddin.
Who is this Puttaswamy?
He is not at all in any way related.
My lord, sir. Puttaswamy
Wait,
is,
sir. ನೀವು ಪೂರ್ತಿ ಸ್ಟೋರಿ ಕೇಳ್ಬಿಟ್ಟು ಆಮೇಲೆ ಹೇಳಿ.
He is not at all in any way related to either the family or in any way. He claims
who executes will in favor of whom?
that Muhammad Zafar Mahyuddin, the father of these respondents before
Executes a will in favor of Puttaswamy.
Yes. On the basis of that document, he files a suit stating that I am the owner of larger extent of property situated within Tiptur city, and for permanent injunction restraining the respondents in this petition from interfering with his possession and enjoyment. Then before the notice is served on any one of the defendants in that suit OS number 1,
Compromise, huh?
a power of attorney is produced stated to have been executed prior to the filing of the suit, mentioning the number of the suit. That's the
Where
reason.
is the power of attorney?
That has been produced in OS 30 of 2000. Yes.
You were not heard when the coordinate bench passed the order?
We were.
Then why coordinate bench has rejected that?
That's not, I'm not on that point. My submission before this honorable court is this. Why that record is required is that power of attorney which was produced in OS 132 of 1997, antedating as if it has been obtained prior to the filing of the suit, but mentioning the
suit number
OS 132 of 1997.
Date is earlier to the suit.
Yes, was produced in that suit. That document is available. And
copy idea? Idre kodi.
Annexure R2 which I have produced along with the statement of objection. Page 21.
Objection ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿ.
Page
21.
Power of attorney.
Yes.
For court case.
For court case.
Date ಏನಿದ್ರದ್ದು?
ಇದು ಡೇಟು 11th of November
11/11/1997.
But the suit was filed on 1/12/1997.
Suit number ಹಾಕಿದಾರಾ ಇಲ್ಲಿ?
ಹಾಕಿದ್ದಾರೆ.
OS 132 of 97.
Which was filed on 1/12/1997. This power of attorney dated 11/11/97 could not have contained the suit number.
ಇಲ್ಲ ಎಲ್ಲ ಮಾಡ್ಬೇಕಾದ್ರೆ ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡ್ಬೇಕು.
So this document was
ಅಪರೆಂಟ್ ಆಗಿ ಈ ತರ ಮಾಡಿದ್ರೆ
ಇಲ್ಲ the party, your lordships may see the order sheet.
First of all, Moinuddin giving will in favor of Putswami.
ಇಲ್ಲ, it is not so, my lord.
First,
what has happened is
ಆಮೇಲೆ
originally they had an agreement for purchase of the property. Moinuddin,
You are
my lords,
Putswami.
in Interim, he executes a will in favor of Putswami, and my lords, he dies in road accident. And my lords, the respondents, my lords, whoever are there in the instant case, my lords, they appear before through his their own brother, my lords, who dies, and after he dies, they are local residents. They file a case after a period of about 25 years from the date of passing of the decree. I have been enjoying the property.
ಇದು ಎಲ್ಲಿ ಪ್ರಾಪರ್ಟಿ ಇದು?
Tiptur city.
It is in Tiptur, my lords. Tiptur.
This Putswami, he is the plaintiff.
He is the plaintiff. In OS number 132 of 1997.
132/1997. Now the question
Compromise
here is that, my
decree.
lords,
Yes, filed on 1/12/1997. And this power of attorney is dated 11/11/97.
ಎಲ್ಲ ಅದು ಗೊತ್ತಾಯ್ತು ಬಿಡಿ.
Then
my lords, the question,
even before service of notice on any one of the defendants.
That is all of you.
Yes, all of us.
Where is the cost title in the plaint?
Cost title in the plaint.
your lordships may see at page number 88, my lords, is the cost title of the plaint. Sorry, the order sheet, the cost title of the order sheet, my lords.
Page 19 annexure A.
132/1997.
ನೀವು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೀರಾ? ಪ್ಲೇಂಟ್ ಕಾಪಿ ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ, ಅವರೇ ಕೊಟ್ಟಿದ್ದಾರೆ, ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ. annexure A.
ಇಲ್ಲ, plaint copy I have filed, my lords.
1997.
Yes.
ಹೌದು.
132 of 1997.
Oh, ಎಲ್ಲ all of you are defendants.
Yeah, all of us were made defendants because he is seeking for declaration on the basis
Correct,
of
no problem. But no notice is issued.
No notice was issued to any one of the parties.
ಮತ್ತೆ ಕಾಂಪ್ರಮೈಸ್ ಯಾರ ಜೊತೆ?
Now, the defendant number 1 in that suit, he voluntarily appears even prior to the date mentioned in the order sheet of the court for the appearance of the parties, files an application for advancement, files a petition for compromise, stating that I have received ₹5 lakh from plaintiff. Therefore, in terms of the compromise, suit could be disposed of.
Yes,
And they
sir.
challenged the suit, my lords, after a period of 25 years.
ಯಾರು?
The respondents in the instant case, who were defendants in the earlier case, they challenged the case, a decree, after a period of 25 years.
ಕರೆಕ್ಟ್, ಅವ್ರಿಗೇನು ಗೊತ್ತಿಲ್ವಲ್ಲ?
ಅಲ್ಲ, ಗೊತ್ತಿರಲಿಲ್ಲ ಅನ್ನೋ ಪ್ರಶ್ನೆನೇ ಇಲ್ಲ ಸ್ವಾಮಿ, ಯಾಕಂದ್ರೆ they are residents of the same place itself. They are not residents somewhere else.
ಓ ಪರವಾಗಿಲ್ಲ ಬಿಡಿ. Fraud unravels everything.
ಇಲ್ಲ, that is true, my lords.
100 years ಆದ್ರೂ ಪರವಾಗಿಲ್ಲ.
But here there was.
And this is fraud apparent.
Now that the value of the properties have gone up, my lords.
ಅಲ್ಲ, this is apparent. You want me to write everything? I will write.
Basically.
On the face of it, a fraud.
ಇಲ್ಲ, no, my lords, it is not a fraud because.
Evidence ಆಗ್ಲಿ ಬಿಡಿ.
ಇಲ್ಲ, evidence ಆಗ್ಲಿ, ಅದ್ರ ಬಗ್ಗೆ I don't have any objection of
Suit
that.
papers OS definitely are necessary.
ಇಲ್ಲ, my lords,
ಅಲ್ಲ, you want me to observe? I'll observe. Power of attorney, I will expect and observe.
Because
if that is not a fraud, what else can be a fraud? Tell me.
My lords, my only submission before this honorable court is that
you imagined he will file a suit. You imagine the suit number, everything you imagine and print.
It cannot be done at all, my lords, because their contention is that the suit number had been
ಯಾರಿದು?
printed on the
Putswami,
power of attorney.
ನೀವು Putswami ಅಲ್ಲ ಇದು?
ಅವರು petitioner before the honorable.
Astrologer ನೀವು?
ಇಲ್ಲ, my lords, in the event that, my lords, I had to get a power of attorney after the suit is filed. Obviously, I would have got it after the suit is filed, because number does not happen before that.
What is this, sir? Yes.
My
You will direct reopening of everything now.
ಇಲ್ಲ, my lords, I will.
Yes,
my lords, my only.
I will direct reopening of the entire thing, notwithstanding the coordinate bench's order.
My lords, I will
take it to the
make
Supreme
one
Court.
submission before this honorable court, my lords. If that document is
doubt
produced
to
before the honorable court.
Moinuddin to Putswami.
My lords, I have a submission before this honorable court, my lords. Only one submission.
I am hearing only, sir.
Yes, sir. My lords, 132/1997, there is a power of attorney produced on the basis of which the case comes to be compromised. So the power of attorney obviously should be in the record of OS number 132/1997 only. Then
Intelligently, he
what
has
is the
taken
necessity for
taken power of
calling the
attorney
document
produced
in
before the court.
30/2008? That is all
ಬರಲ್ಲ
the
ಬಿಡಿ
question.
ಈಗ ಇನ್ನೊಂದ್ರಲ್ಲಿ ಕೊಲಾಟ್ರಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರಲ್ಲ ಬರ್ಲಿ ಬಿಡಿ ಅದು.
Yes, my lord, sir, let it come.
Let
I
it
will
come.
even. If
So
that
what
would
is
be
wrong
the-
with the order?
Yes, my lord, sir, let
Sorry,
I will
ಬಿಡಿ,
not even
close
press
ಮಾಡೋಣ.
upon this
Nothing is wrong
application,
with
my
the
lord,
order.
sir. Let it come, my lord.
You want to invite an order from me, I will write.
Illa, not required, my lords. I will
Not
not even
required,
press upon this application, my
Yes.
lords. Not required at all. Let the records come, my lords. Let the truth be elicited before the court.
Exactly. Let the truth come out, sir.
Yes, my lords.
Yes.
So I will withdraw this petition, my lords.
Correct, sir. The learned counsel for the petitioner, after arguing the matter at length, would seek leave of this court to withdraw the petition. The submission is placed on record. Petition is disposed as withdrawn.
I insist for cost.
Cost? Amal. ಪುಟ್ಸ್ವಾಮಿಗೆ ಹೇಗೆ ಹೋಯ್ತು ಮೈನುದ್ದೀನಿಂದ ಅದು ಗೊತ್ತಾಗ್ಲಿ, ಆಮೇಲೆ ಕಾಸ್ಟ್ ನೋಡ.
71.
This is the application was filed under Order 1, Rule 10, in a partition suit to implead himself as a defendant number 7.
Who is he?
My brother as defendant number 6 has come on record. And my application is rejected. On the ground.
Who are you?
I'm joint family member, one of the joint family member.
He belongs to a different branch. In fact, he had filed a written statement in another matter, admitting that there was a partition and he has already taken his
ಆಯ್ತು,
share.
ಅದೆಲ್ಲ ಮ್ಯಾಟರ್ ಆಫ್ ಎವಿಡೆನ್ಸ್ ಬಿಡಿ, ಮಾಡ್ಲಿ ಅಲ್ಲಿ.
Kindly see my statement of objections, wherein I have filed my his written statement, where he admits that he has already taken his share.
ಈಗ
This is a suit.
ಇನ್ನೊಂದು ಸೂಟ್ ಫಾರ್ ಡಿಕ್ಲರೇಷನ್ ಹಾಕಿ ಸ್ಟೇ ತಗೋಬೇಕಾ?
This is a case amongst the members of a separate branch. He is trying to enter into a litigation.
Court will not.
Lord,
Court
the
will
suit is
not
of the year
consider.
2012.
ಆಯ್ತು. Will direct the suit to be concluded expeditiously.
Is not necessary party. Kindly see for a moment, page number 47.
Yes, sir.
47.
Lord,
his name figures at left-hand side middle portion middle, Puttalingaya. It's the genealogical tree.
ಆಯ್ತು.
Now the suit is amongst the right side branch, Kodi Lingaya's children, right side. Therefore, he having taken his share is trying to enter into a litigation amongst members, in a litigation amongst the members of a different branch.
Yes.
Kindly
Anything else? You're telling as if it's a Berlin Wall.
My lord.
Yes.
My lord, may kindly see.
Separated East and West Germany.
My lord, may kindly see my statement of objections, where I have filed his written statement filed in another matter, where he says, it is a fact that during the lifetime of father of defendant number 1 to 3 by name Chikkamalaya and plaintiff number 1 and defendant number 4 and LRs of second wife Tolasamma, all are partitioned their ancestral and joint family properties through Panchayat Palupatti Vibhaga Patra on 10/4/1998.
Yes, sir. Why do you want to enter into their partition?
No, partition has been disputed by them. Based on that, a mutation entry was filed, made, which has been challenged
matter
by
of
them.
evidence. ಅಲ್ಲೇ ಆಗ್ಲಿ.
This partition deed has been acted
Order
upon.
1 Rule 10 ಯಾವಾಗ ಹಾಕಿದ್ರಿ application? When?
No, this is it was filed in page number
Filed in page number?
I'm sorry, page annexure E.
It was filed on 30/8/2024, my lord.
Suit of 2012.
Well,
what were you doing till then?
Lord, this is only to protract the proceedings in collusion with the plaintiff, my lord. The plaintiff is.
What were you doing for 12 years, sir?
It was they were prosecuting in a revenue court. They have filed application. I have filed objections. Kindly see additional documents have been filed wherein they dispute that Palupatti.
At earlier
so ಅದಕ್ಕೆ ಇದರಲ್ಲಿ you want to intervene.
No, that's what they say that there was a partition as per the Palupatti, which has been disputed by them. That's why I want to come on record. Even till today, that property is standing in the name of the ancestor. No changes have been affected.
At earlier instance, my lord, when this
That's
matter
why
was heard,
we want to come on record. Whereas my brother has already come on record as a defendant number 6.
He was asked whether he would include all the properties he had taken under
Yes, sir.
partition into the
Even
present
now,
suit.
yes, I am ready.
There was no answer
I am
to that.
ready.
ಎಲ್ಲ ಕೊಡ್ತಾರ.
I am ready. You can implead.
ನಿಮ್ ಹಳೆ ಪಾರ್ಟಿಷನ್ ಎಲ್ಲ ಇನ್ಕ್ಲೂಡ್
ಎಲ್ಲ
ಮಾಡ್ಬಿಡಿ.
ಬರ್ಲಿ, ಎಲ್ಲ ಬರ್ಲಿ, my lord.
His RTC has been produced wherein that partition deed has been referred, my lord. Kindly see page number 49.
No, they will include that also.
Yes, you
Statement
can
with record.
implead. You can make a, yes, it can be, my lord, let them not forget
You
about. the
produce
part-
what are the properties to be added.
Yes.
I'll take it on Monday, Tuesday.
Yes.
You give all the properties to be added.
Yes, yes.
We will, anyway, he has made a
16th, my
statement.
lord, is the, my lord, is the suit, my lord, is posted on
16th,
yes,
take
my
an
lord.
adjournment there, yes. List on, don't precipitate there, take an adjournment. You give a list of properties. Anyway, he's accepting.
Yes.
Let him come on record along with the properties. Yes. 4 o'clock ತಗೊಳ್ಳಿ madam. Wednesday.
Further hearing? 4 p.m. List number 2. Bill number 15.
List number 2, 3.
List number 3. Bill number 15.
Yes, Sangat.
For the petitioner.
What's the, nobody is here to answer?
Now there's a new SPP that's appointed. There's an official notification that the government has released.
For this?
No, not in connection with this petition explicitly. Rahul Karyappa was earlier appearing.
It's all right. Where is Jagdish? We'll appoint Jagdish as my cousin.
If your lordship were to see para 13 and 14 of your lordship's judgment, on the larger issue, my lord, your lordships had directed the state to report compliance.
Correct. Well, nobody is here.
Insofar as that is concerned.
What is the order date?
No, this is the original order, my lord. It's dated 24th March.
That's 1 minute. Which is confirmed by Supreme Court.
Yes, ma'am.
He's here.
Yes.
Jagdish sir, will ask you to come in as amicus. Your assistance may be required. The
Para 13 and 14, your lordships have said.
And what is the status? Rahul Karyappa was there and he had produced some documents with regard to status. So you come in as amicus.
Yes.
This court disposed writ petition, the subject petition, in terms of its order dated 25th April 2025 by issuing certain directions. Certain directions have been issued from time to time by subsequent orders, and the petition is kept for the purpose of issuance of continuing mandamus. The investigation papers from the progress in investigation from time to time was directed to be placed before the court. Placed before the court. For the purpose of the assistance, I deem it appropriate to appoint the additional SPP B.N. Jagdish as amicus in the subject proceedings. Papers idya?
I'll collect it.
The learned counsel for the petitioner to furnish all the complete set of papers upon B.N. Jagdish. The learned additional SPP to secure the records with regard to investigation conducted up to date and place it before the court for its perusal by the next date of hearing. List the matter on 14th at 4 p.m. Copy. Yes. In further hearing, oh, sorry, next 21st. Angad, 21st, not 14th is this week only. 21st, yes. Allah, further hearing karadbudi. It mugspan. 2:30 every day. Karadbudi.
2:30 mood matters being spoken to Seal number 1, Sadanandi Shastri.
The appeal for respondent may not survive. Orders have already been passed by the trial court. And for the petitioner, my lords.
Not survive?
No, my lords. The order has been passed and the application order 7 to 11 has been allowed.
Move ಮಾಡಿದ್ಯಾರು?
Respondent moved it, my lords, in the morning.
Correction iga
ಹೌದು.
being spoken.
Please, my lords.
Oh, this 39-192. Order is passed. This is that communication gap. All right. The learned counsel for the petitioner submits the memo so filed for being spoken to may not survive, as the concerned court is already passed an order.
Memo was filed by the respondent, my lords.
Filed by?
Respondent.
Filed by the respondent. Memo ashte. Yaradro hakiri. So. Submission is placed on record. Memo thus stands disposed. Next.
Order still number 2. Gautami S. Bandari.
Good.
For the petitioner, my lords. The petitioner herein is a life member of the respondent body.
NIPM. Yes. Tell me, madam. Why are you suspended?
I am suspended on false and frivolous grounds, my lords. I would like to state the brief facts before I get into it, my lords.
No, you tell me why are you before the court now? It's special orders. GMCPC. What is the order under challenge?
My lords, I had filed a suit before the second additional civil judge Mangaluru for declaration that the suspension order issued against me by the respondent herein is illegal and seeking injunction against the respondent body so that they don't act on the said suspension.
Final and interim both.
Please, my lords. However, I had filed an IA under Order 39 Rule 1 and 2 seeking an ad interim temporary injunction so that the suspension order is stayed and I am allowed to take part in the elections. The nomination, the last date was on 7/8, my lords. However,
Take part in the election to contest or to vote?
To contest and to vote. So, my lords, what happened is the final date for submitting my nomination was on 7/8.
It's over.
It's over. However, I went ahead and submitted my nominations. And as expected, I would like to produce.
Rejected.
It has been rejected owing to the suspension order.
All right.
However, I still have a chance to resubmit my nomination as the final list of candidates will be only given on 18/8, my lords.
Why are you suspended now? Tell me.
Coming to that, my lords, I am the chairman of the Mangalore chapter of the respondent body. From 2023 to 2025 I was elected, and taking note of my exceptional leadership skills, I was re-elected from 2025 to 2027. I have taken up a lot of events, organized a lot of events. I have introduced new things.
What is the reason for suspension? Who asked for encomiums? Yes.
Thereafter, when matters stood thus, my lords, a show cause was issued to me on 29/5/2025.
Where do I get that? Page.
Section E, my lords. Page number 71.
Calling for explanation.
Please, my lords. The reasons in this are very frivolous. So there's a NatCon event that was conducted under my supervision in Mangalore in 2024, my lords. In this said show cause notice, the allegations are that I have not provided enough kits, that is pen, paper, etc. That the accommodation I have provided was not up to par, that the food and liquor services were not priorly discussed with the national body. Such frivolous allegations they have put on me. It is very important to note here, my lord, that all the decisions that I have taken approval for the same from the national body, and committees were formed as per the respondents' recommendations. However, you can see, my lords, I have issued a detailed reply to the same in Annexure F, that is page 75. I replied to the said show cause, page 75, Annexure F.
Yes.
In the reply, I have put forth my case. In detail, I mentioned why the said show cause is unreasonable and those allegations are unreasonable. In detail, I have replied. However, without taking my reply into consideration at all, in Annexure G, we can see that they have suspended me on 24/6/2025.
1 minute.
Please, my lord.
What was the date of the election? When were the calendar of events issued for the election?
Annexure J, my lords, on 23/7/2025.
23. Oh, you are placed on suspension before that.
Please, my lords. In Annexure J,
Elections were to be held from 7th.
no, nomination, the final
Nomination.
date.
What
to
is the date of
submit my
election?
Date of election is 27/8, my lords.
Last date for nomination is 7/8, is it?
7/8.
Ah.
But the final list of contestants will be given only on 18/8, my lords. So, my lords, as we can see in Annexure G, that is page number 80, on 24/6/2025, I was placed under suspension. My reply was not considered. They have not given any reason as to why my reply is unsatisfactory. They have suspended me. My lords, it is very important herein. The respondent is a legal entity in itself, my lords. It has its own constitution. We can see constitution in Annexure B. If I can take my lords' attention to page number 33, that is Annexure B. In that clause 9, my
Do
lords,
you have a right to contest again for what post were you holding?
I was the chairman of the Mangalore chapter.
You have a right to contest again for that?
Please, my lord. No, I will be contesting for the post of national president. Once I'm elected, I'll have to give up the post of chairman.
It's all right. Yes.
In page 33, my lords.
1 moment. Heard the learned counsel. What's your name? You said.
Gautami Bandari.
So and so appearing for the petitioner. The petitioner institutes a suit in OS
1080
of 2025, calling in question, seeking relief of declaration to declare the suspension of the petitioner from the life membership of NIPM Mangalore chapter as illegal. The petitioner gets elected as a chairman of the respondent chapter, respondent Mangalore chapter, and was a president for a period of 3 years, is it?
Chairman, my lord.
Chairman for a period of?
2 years. I've been re-elected
chairman for a
another
period of 2 years. The ensuing elections were notified in the month of June 2025, not for the Mangalore chapter, but for the national president, is it?
Please,
National president of the National Institute of Personal Management. It is at that point in time comes the show cause notice to the petitioner seeking explanation as to why action should not be taken against him on certain omissions and commissions. A perusal at the contents of the communication seeking explanation would prima facie indicate that all the allegations are frivolous, as none would touch upon the integrity of the petitioner or working of the petitioner as the chairman of Mangalore chapter. The explanation is offered by the petitioner. It is in detail. The explanation does not bear consideration in the impugned order, which places the petitioner under suspension of his life membership in the NIPM. This appears to be only to stall the petitioner from contesting elections to the National Institute of Personal Management and not restricting his presence in the Mangalore chapter. In that light, Mangalore chapter. The learned counsel for the petitioner further submits that the last date for filing of the nomination is 7/8/2025, and the corrected nominations can be filed before the 18th. And the petitioner has, by way of abundant caution, had filed his nomination, which has been rejected. In that light, in the light of the aforesaid reasons, I deem it appropriate to direct the a returning officer appointed for the conduct of elections to accept the nomination of the petitioner, process the same, which shall however remain subject to the result of the petition. Petitioner to serve the respondent by way of hand summons, list the matter on 22nd in preliminary hearing. Yes.
Hand delivering, I request for hand
Third
delivering.
order. Yes, we'll see. Tomorrow morning you take it.
Please.
Yeah.
Much obliged.
Next. ಅದು further hearing ಇರೋದು ಕರೆದ್ಬಿಡಿ ಒಂದ್ಸರಿ. List 3 ನಾ ಕರೆದ್ಬಿಡಿ. ಎಷ್ಟು ಮ್ಯಾಟ್ರ್ ತುಂಬಾ ಇದೆ ಮೇಡಮ್. List 3 ಕರೆದ್ಬಿಡಿ.
List number 3 orders, still number 1.
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ BS ಪ್ರಸಾದ್? ಕೊಡಿ. By special order. Successive rate.
Next date and quote 22.
Complainant. Yes, madam. Where is Jagdish? He was here. Petitioner to serve set of papers upon the additional SPP BN Jagdish. List the matter on 29th. Yes.
Number
Next.
2.
In disposition, na? JCB.
This is third list, second.
Third list, second matter. Chandrasekhar Babu ನೀವೇ ಅಲ್ವಾ? ಹೇಳಿ.
That filing memo, my lords.
Want to withdraw the petition?
ಅದೇ ಅಲ್ಲ. Interim prayer ಅದು due to paucity of non-availability.
The matter was listed on 12/8/2025. Grounds for interim prayer was in the petition but not the interim prayer. Counsel for the petitioner submitted it was due to inadvertence. Therefore the application is now memo ಆಗಲ್ಲ. ಅಲ್ಲೂ ಪ್ರಾಬ್ಲಮ್.
ಅಲ್ಲ yesterday.
ಇಲ್ಲೇ ಬರ್ದ್ಬಿಡಿ ಇದ್ರಲ್ಲೇ.
ಅಲ್ಲ up to ಬರೀತೀನಿ.
ತಗೊಳ್ಳಿ. The learned counsel for the petitioner has filed a memo to incorporate the interim prayer. ತಗೊಳ್ಳಿ. The petitioner is permitted to incorporate the interim prayer. The petitioner, if in possession as on today, shall not be disturbed till the next date of hearing. Emergent respondent BDA ಅಲ್ಲ?
ಹೌದು BDA.
Learned counsel M. Ajay Kumar.
2 and 3 BDA.
Learned HCGP 1, 2 and 3 M. Ajay Kumar. Petitioner to serve set of papers upon the aforesaid counsel list the matter on 16th September in preliminary hearing.
Order copy may be available. Order copy may be available.
ಆಯ್ತು ಅಪ್ಲೋಡ್ ಮಾಡಿಸ್. Yes.
Today, my lords.
No, tomorrow.
Much obliged.
Still number 3 adjourn, still number 4 admission.
Rajat.
My discharge application order, my lords, is challenged before this honorable court. The co-accused, my lords, had approached this court.
Tag the
before.
petition ಅಂತ ಏನೋ ಇದೆ ಅಲ್ಲಿ. All right, tell me.
Lords, this is the order, my lords, where my lords have quashed the proceedings so far as the other accused are concerned. The other accused are, my lords, public servants. My lords held that if sanction is obtained, prosecution could continue against them. The essence of, my lords, the allegations against me, I am the developer, my lords. I am accused number 1 before my lords. The essence of the allegation is I have caused a loss of rupees 11,000 to the state exchequer by producing a fake supplemental agreement. And the complainant in this case is a former corporator of the area where the property was being developed. He not only, my lords, makes me an accused, he makes, my lords, the commissioner of the BDA and the others also as accused. They have been subsequently dropped.
Who is the complainant?
Complainant, my lords.
Page, where is it?
Complaint, my lords, will find at page number.
Right, you serve on the complaint.
Please.
The ಇದು ಲೋಕಾಯುಕ್ತನ ಸ್ಟೇಟ್?
Lokayukta.
Learned Counsel B.B. Patil is directed to accept notice for the first respondent, the second emergent notice to the second respondent, returnable by the 19th of September. List the matter on 19th of September. The Learned Counsel appearing for the petitioner would take this court through the documents appended to the petition to demonstrate that the allegation against the petitioner is production of certain supplemental agreement, which according to the complainant was fake, and due to which a loss of rupees 11,000 is, it has caused loss of rupees 11,000 on the state exchequer. But the offenses alleged are of forgery, cheating and criminal conspiracy as obtaining under section 471, 420 and 120B of the IPC. The Learned Counsel for the petitioner further submits that insofar as the allegation allegation against the public servants are concerned, the proceedings come to be quashed, reserving liberty to the concerned court to revive the proceedings in the event sanction would be accorded under section 197 of the CRPC. Since the allegations are intertwined between the public servants and the present petitioner, if further proceedings are permitted to continue, would prima facie become an abuse of the process of the law. In that light, there shall be an interim order of stay of further proceedings qua the petitioner till the next date of hearing. Yes. Next.
But I must mention, my lords, that I had approached this court earlier, but they had reserved liberty to urge all my contention before the discharge application. And after
ಅದು ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಈಗ?
ಹೌದು, ರಿಜೆಕ್ಟ್ ಆಗಿದೆ. That's why I'm quoting.
ಅಲ್ಲೊಂದು ಪ್ಯಾರಾ ಹಾಕಿ ಮೇಲೆ. The Learned Counsel for the petitioner submits, first ಇದನ್ನ ಹಾಕ್ಬಿಟ್ಟು ಆಮೇಲೆ further submits ಅಂತ next ಆಗಿ submits that the petitioner was before this court and was directed to file discharge application before the concerned court. The discharge application having been discharge application before the concerned court, reserving liberty to approach this court in the event the discharge application would go against. Athara ilva?
My lords may take page 2.
My order?
Illa.
Then?
Coordinate bench's order.
What is
there
that?
They've said the above petitions were filed seeking of quashing of the charge sheet filed in so and so. This court by order dated so and so dismissed both the petitions. Now the petitioners have moved the above memo for being spoken to on the ground that they have filed application before the trial court for their discharge, and the observations made in the order of this court may come in independent decision on their application or discharge. Therefore, they want this court to observe that the trial court shall dispose of their application for discharge uninfluenced by the observations made in the order.
Which page is that?
It's 253.
First quote that order. The Learned Counsel of the petitioner takes this court through the order passed by the coordinate bench so and so. The coordinate bench observed that the petitioner should approach the concerned court by filing a discharge application and left the remedies open later. In the light of the rejection of the discharge application, the Learned Counsel submits that petitioner is before this court in the subject petition. Ameli order ಮಾಡಿ. Next. ಯಾವ page Rajat you told that?
253.
253 ಬರ್ಕೊಂಬಿಡಿ. Order. Yes. Next.
5 adjourn. 6.
I pay for the respondent counsel.
CRP.
CRP. Rejection of plaint has been.
Correct. Rejection of plaint.
Yes, my lord. I sought for the rejection of the plaint on the ground that the cause of action is barred by limitation. After 12 years, they want
suit for.
Yes, my lord. Suit for injunction, mandatory injunction.
Mandatory injunction ಗೆ limitation ಎಲ್ಲಿ ಬರುತ್ತೆ?
ಅಲ್ಲ, what they are seeking in the alternate way.
Declaration ಆಯ್ತು, ಬೇರೆ ಎಲ್ಲ ಆಯ್ತು.
They wanted to seek the cancellation of the rectification of the document of 12 years old.
Where is?
Sorry, my lord.
Yes, my lord.
That is what seeking only for rectification of the deed, a partition deed, where the measurement has been wrongly mentioned. I am seeking for correction of that judgment, partition deed.
My lord, they are seeking the amendment to my schedule as well.
Where my vendor has what is the extent of 30/50, so that has been divided between the brothers. That is to be extended, where it has been returned as 50/40.
My lord, he is party to the document. After 12 years, he is coming and seeking for
only
rectification.
If the benefit that has flown to him is contrary to what had flown to you pursuant to the partition, obviously.
My lord, now he is seeking for the amendment of the partition itself, my lord.
No.
After 12
only
years,
amendment, only rectification of the measurement.
ಅಲ್ಲ, ಬರೀ ಅದಾದ measurement ಆದ್ರೆ ನಿಮ್ಗೆ ಏನು ತೊಂದರೆ ಇಲ್ವಾ?
ಅಲ್ಲ, only to his schedule.
Correct, his schedule only.
No, he is seeking for the.
Whichever property you have purchased, restrict your claim to that.
This property has been purchased by my father.
Correct. My father, between father, we had divided the properties.
Who are you?
I am the one of the son.
One of the son. Yes.
Millard, there are 3 schedules, Millard. One is A schedule, B schedule
ಇಲ್ಲ
and C
ಮಿಸ್ಟೇಕ್
schedule.
ಆಗಿದ್ರೆ ಕರೆಕ್ಷನ್ ಮಾಡ್ಲಿ.
Millard,
ಪಾರ್ಟಿಷನ್ ಚೇಂಜ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ
now Millard, they are virtually Millard, section 59, article 59 of
correct.
the Limitation Act says any rectification of a document, it should be within 3 years. Article 59 comes into play, Millard.
Yes, sir.
Madam, I had given a memo now. May kindly look into.
You are a party to the partition.
Yes, Millard, party to the
you are a
document.
party alva.
Yes, Millard.
100
I'm
ವರ್ಷ ಏನ್
admitting the
ಮಾಡಿದ್ರೆ?
partition deed is admitted.
12
Only
years,
the-
what did you do?
Only the measurement which has been, when I given a document to the bank for obtaining a loan, where the bank officials has told that earlier sale deed of your vendors is only 40-50. To that extent, you have to modify your partition deed. Thereafter, I am approaching the court to modify the partition deed only to that extent. May kindly look into now, I had produced the memo.
Would that eat away into his?
No, he is in extent of more extent he is there.
No, that's all right. Would it take away his
Yes,
right?
No, it
under-
won't take.
It will.
It won't.
ಇಲ್ದರೆ ಅವರೇ ಕೊಡ್ದಾಡ್ತಾರೆ.
Otherwise, why should I, Millard?
No, where the extent he is in, more extent is there for the.
More extent, but you leave it. There was a partition.
Yes.
In terms of the partition, you have settled your rights
Yes, please.
for 12 years. Now you want some loan and change the partition now?
Well, not changing the partition where extent is more is there, my lord. That where my father doesn't have, we doesn't have. To that extent itself, I am seeking.
Millard,
I
article.
kindly look into my plaint itself.
Unless you allege something else, rectification, the correction which would lead to changing the partition itself, no?
No, no changing of the party. Only the measurement is by mistake. It is there.
By mistake.
That will
I
take
kindly
away,
look into.
that will take away my property also.
No, it won't take where the property has acquired by my father. That is divided between us.
ಇದು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆಗೋ ಕೆಲಸ ಅಲ್ಲ. ನೀವು ಹಂಗೆ ಅವ್ರ ಹತ್ರ ಮಾಡ್ಕೋಬೇಕು.
I am requesting for them itself only.
ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಕೋರ್ಟ್ ಇಂದ ಆಗಲ್ಲ ಇದು. ಆರ್ಟಿಕಲ್ 59.
59, Millard.
May kindly look into my part, in my prayer itself. The only respect of the measurement, only the maiden.
It changes the entire nature, sir.
But if nature change
ಅಲ್ಲ ನೇಚರ್ ಪಾರ್ಟಿಷನ್ ಬಂದಿರೋದು ಚೇಂಜ್ ಆಗುತ್ತೆ.
ಆಗುತ್ತೆ.
ಈಗ 50-40 ಅವ್ರಿಗೆ ಬಂದಿದೆ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ. ನೀವೀಗ ಅವ್ರಿಗೆ ಜಾಸ್ತಿ ಕಮ್ಮಿ ಬರ್ಬೇಕಾಗಿದೆ 30-40 ಮಾಡಕ್ಕಾಗುತ್ತೆ.
ಇಲ್ಲ, I'm not that like. Where 40-50 is divided between 20-50.
Yes.
That itself only the
We'll see.
measurement different.
We'll hear list after 4 weeks.
Yes. Well, in the meanwhile, Millard, they are going ahead with the evidence of the case.
There, that we will stay. Yes.
Yes.
Only the, where it can be sorted out. In the time may become next week, we can sort it out.
Yes. Sort out. We'll stay till then.
Yes, Millard.
The petitioner is before this court calling in question an application filed by the petitioner, filed by the respondent, seeking correction of the boundaries that were in the partition long after the
Not the boundaries, only measurement.
measurement of the partition long after the suit for partition comes to be decreed. The suit for partition comes to be decreed in the
No decree.
compromise.
Millard,
No,
deed of-
no,
partition deed.
Sir, partition deed.
Yes.
Where the suit irlilva.
Illa, sir. Suit
Illa.
alla.
Very partition deed.
Partition deed, we have seeking for rectification, that's all.
After 12 years, Millard, after 12 years. After 12
I
years.
thought it
Millard.
was a decree of
No,
partition.
there is no decree.
Not decrease, Millard. It's a partition deed. It affects my property, Millard. Now, all along 12 years,
Sit and discuss.
I've also
Yes.
put up the
Ken Beda.
construction also.
Let's the matter on 29th. Parties to explore the possibilities of a settlement and report if any, failing which the matter would be considered on its merit.
But in the meanwhile, they are going on with the
Meanwhile, ಕೂತ್ಕೊಂಡು ಮಾತಾಡ್ಬಿಡಿ.
evidence. They are going on with the evidence, Millard. Yesterday also they led the
Yes.
evidence.
Yes, next.
In the meanwhile, at least interim order till then, Millard.
No. Sir. Yes.
7.
We'll see. We'll answer it.
Number 7.
ಯಾವ್ದು ಮೇಡಮ್? BD and LBBMP?
The special order, my lords, on 24/1/2024. It came up before your lordship. But I appear for the respondent number 2.
Let it go before the regular court only.
Please, my lords.
ಎಲ್ಲೇ BDA ಇಲ್ಲಿದೆಯಲ್ಲ ಅದಕ್ಕೆ. LB is again it will come here only. Yes. Yes, sir.
I appear for the respondent petitioner number 2 at.
What are all these?
But I will comply with this, my lords. Office
Report of
objections in IA
outcome
number-
of meeting by AGA and council. ಏನidella? Manish Kumar.
That is with respect to the khata to be issued by the BP. We have gone beyond that, my lord. The further developments will take.
List the matter on 12th September.
That's, there is some interim order, my lords.
Interim order, if any, shall continue to the next date. Next.
8.
Then service matter.
Service matter.
Why?
In a special order on the post.
Departmental inquiry.
Departmental inquiry, 14 order is telling that. And there is an interim order of stay. And after that, they have issued the articles of discharge by the Lokayukta. And that also I have amended the petition. No, my lord, when there is a stay, operation of stay is there. Lokayukta has completed the inquiry ex parte, sent a report to the government. Therefore, I filed an application.
Government ಏನ್ ಮಾಡಿದ್ದಾರೆ?
Government ಇನ್ನೇನು ಮಾಡಿಲ್ಲ.
ಏನು ಮಾಡಿಲ್ಲ.
That is not to participate ಅಂತ interim order.
Heard the learned counsel Raghavendra Gayatri appearing for the petitioner. Interim order ಇಲ್ಲಲ್ಲ?
Interim order ಇದೆ.
ಎಲ್ಲಿದೆ?
Interim order 16/12/2022 ಗೆ ಇದೆ. 14 order itself is, my lord,
The coordinate bench of this court on 16/12/2022 had passed the following order. The learned counsel appearing for the petitioner submits, notwithstanding the interim order, rather in its teeth, the Lokayukta has completed, the office of the Lokayukta, office alla yaru Upalokayukta na?
assistant registrar of inquiry.
The additional registrar of inquiries appointed for conduct of departmental inquiry against the petitioner has completed the inquiry, submitted a report to the government, all ex parte.
31/12/2024.
All ex parte in terms of its communication dated 31/12/2024. Therefore, the petitioner has filed an application seeking stay of all further proceedings or the order dated 31/12/2024. In the teeth of the subsistence of the interim order, prima facie, the Lokayukta could not have concluded the inquiry and submitted its report all ex parte. In that light, the communication dated 31/12/2024 and all further proceedings taken thereto or to be taken thereto shall remain stayed till the next date of hearing. List the matter on 12th September.
Please.
Yes, next.
Final hearing, seal number 9.
ರಾಘವೇಂದ್ರ ಅವರೇ, ಯಾವ ಐ ಹಾಕಿದ್ದೀರಾ ನೀವು?
ಐ ಫಾರ್ ಡೈರೆಕ್ಷನ್ಸ್ ಆಗಿದೆ.
ಎಲ್ಲಿದೆ? ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಅಂತ ಇದೆ?
ತಪ್ಪಾಗಿ ಬರ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಬಟ್ ಐ ಇದೆ.
On IA 1 of 2025, order on IA 1 of 2025 ಅಂತ ಮಾಡಿ.
ಬರೆಯೋದ್ರಲ್ಲಿ ತಪ್ಪು ಬರ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಆಯ್ತು ಸರ್. ಎಸ್.
Office objection.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆಯಾ?
Office objection. Rectification.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಸ್ಕ್ವೇ IA 1 of 2025 overruled. ಆಮೇಲೆ ಇದನ್ನ ಮಾಡಿ ಆರ್ಡರ್. ಎಸ್.
Number 9.
I appear for the petition.
ಯಾಕೆ ಇವತ್ತು ಬಂತು? ಡೇಟ್ ಕೊಟ್ಟಿತ್ತಾ? ಗೊತ್ತು. ಮಂಗಳವಾರ ಈಗ ಹಿಯರ್ ಆಗ್ಬೇಕು, ಇವಾಗ ಆಗಲ್ಲ. ಎಸ್, ಲಿಸ್ಟ್ ಆನ್ ಟ್ಯೂಸ್ಡೇ.
Further hearing, seal number 10.
For the petitioner.
Huh?
Seniors held up in another court, all my lords.
Hits music Tuesday. Interim order continues.
11.
Same order.
12.
Interim order.
Continues. 12. ಇದು ಕೇಳಿದ್ದೀನಲ್ಲ ಇನ್ನೇನು?
Already once result ಕೂಡ ಆಗಿತ್ತು.
Reserved, yes.
Because
Visit advocate.
we wanted to file the
Committee ಅದು
memo.
ಕೊಡಿ. ಅದೊಂದು ಆಮೇಲೆ ಫೈಲ್ ಯುವರ್
Let's say a memo is filed, the connected matter.
Connected matter?
In the, my lords, arising out of the same issue, that's the commissioner had made some remarks against the petitioner.
No, ಇಲ್ಲಿ complainant ಯಾರು?
Complainant is the person against whom an inquiry was instituted.
No, correct, but not.
R1, my lords.
Somebody is represented.
There was a counsel.
For R1, my lord.
Yes, sir.
Praise and adjournment.
Trace and adjournment. ಎಷ್ಟು ಸರಿ ಕೇಳೋದು ಇದನ್ನ? ಕೇಳಿ.
Today only we have filed invoice.
ಇವತ್ತು ಹಾಕಿದ್ದೀರಾ?
Today afternoon.
ಆಯ್ತು, ವಿಲ್ ಹಿಯರ್ ಹಿಮ್. ನಾಳೆ ವಾಪಸ್ ಬರುತ್ತಾ? Yes.
Because in the, what happened, my lords, there was a.
No, I'll give one date. Get ready. ಇದು 4-5 ಸರಿ ಹಿಯರಿಂಗ್ ಆಗೋಗಿದೆ.
Please.
ಸಿ ಮೋಹನ ಯಾರು?
Manish Kumar.
What's your name, sir?
Today we have filed
ಅದೇ ಯಾವ ನಿಮ್ ಹೆಸರೇನು ಸರ್?
Aditya, Karthik Aditya.
Learned counsel so and so submits that he has entered appearance in place of
R1. Aditya.
so and so, in place of so and so. Registry to print the name of so and so is appearing for the first respondent complainant. The matter was heard and reheard on several occasions. The complainant is now represented. Therefore, to grant an opportunity to the complainant to make his submissions. His submissions. List the matter as a last chance on 22nd. Yes. Avat mugsbidi.
Interim order may kindly be.
Interim order subsisting. Other heard learned senior counsel can Panidran Madi. Interim order subsisting will continue to the next date of hearing. Yes, next.
Committee report, my lord.
ಅವರು ಆಲ್ಟರ್ನೇಟ್ ಡೇ ಮೂವ್ ಮಾಡಕ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ರು, ಅದಕ್ಕೆ ನಾನು ರಿಲೀಸ್ ಮಾಡ್ತೀನಿ.
ಇಲ್ಲ ಇಲ್ಲ.
ಎಷ್ಟು ಸರ್ತಿ ಮೂವ್ ಮಾಡೋದು?
My lord, on the last occasion, your lordship has
The committee's recommendations are with me.
yes, my lord.
We'll reserve it and pass orders.
My lord, if that report is given, my lord, then I could make a.
Don't worry, sir. We'll give it to you in appropriate way. ಅದೆಲ್ಲ ಬೇರೆದೆಲ್ಲ ಇದೆ, ನಿಮಗೆ ಬೇಕಾಗಿಲ್ಲದೆ ಇರೋದಿದೆ.
ಅದಿದ್ರೆ then I can file a application, my lord, modifying the, because if it is an admitted fact, then this court, my lord, has power, my lord, to direct. Yes, therefore, my lord.
That will be in the order, don't worry. Yes.
Yes.
Heard reserved.
Please. We
Yes.
have already paid, my lord, that also may be considered.
Yeah, we have already filed everything.
My lord,
Yes.
they have, my lord, not complied with the interim order. Now, my lord, there are judgments of this
ಏನು
court.
500 crores ಬಂದಿಲ್ವಾ ಈಗ?
ಇಲ್ಲ ಬಂದಿಲ್ಲ. This
ಎಷ್ಟು crores ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್?
your lordships have directed 160 crores ಕೊಡಿ ಅಂತ.
ಹಾ.
Not even one pay, my lord, has been released.
ಅದು recalling ಹಾಕಿದ್ದಾರೆ.
Recalling ಹಾಕೊಟ್ಟಿದ್ದಾರೆ.
We'll
No, my
answer
lord,
that
unless
also.
and until they comply with the order, there, my lord, objection only cannot be looked into. My lord, that is what the Supreme Court says in the judgment. If your lordships are hearing, my lord, I will produce those
No,
judgments.
all right. Yes, we'll answer that application. Don't worry. Yes.
Please.
90% work is over. Now in statement of objection, they say that 68.
ಆ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆ ಅಲ್ಲ, don't worry. Yes.
Please. Report we have not seen, therefore, my lord.
ಅದು ನಿಮ್ದು ಓಕೆ, ಬೇರೆಯವ್ರದೆಲ್ಲ ಯಾಕೆ?
ಅಲ್ಲ ಬೇರೆಯವ್ರು ಬೇಡ.
ಮತ್ತೆ ನಿಮ್ಗೊಂದು ಪೇಜ್ ತೆಗೆದು ಕೊಡ್ಲಾ ಹಂಗೆ? Yes.
Please.
14.
Appearing for the petitioner, my lord.
Respondent number 1 in this matter, your lordship.
I have it on 23rd, my lordship. Senior counsel Sajan Poe.
23rd.
Your lordship, I seek for a date in the subsequent week, your lordship.
We'll take it on 23rd ಆಗಲ್ಲ?
30th.
30th, yes.
Obliged, your lordship.
30th is also a working Saturday, we'll do that.
Yes, much obliged.
ಈಗ go back. 4 o'clock matter ತಗೊಳ್ಳಿ. ನಗರನ್ ಸರ್.
Password matter. 7. List 1 7.
Sorry, my lord, I had to seek a password. No, today has been a unusually
Not once, but twice.
Sorry, my apologies, my lord. Matters, my lord, today is too many clashes. My lord,
Yes, sir.
What is before your lordships, my lord, is one writ petition is there. That is the one which your lordships are now seeing. 6830 of 25.
ಒಂದೇ ಇರೋದಲ್ಲ?
ಒಂದೇ writ petition.
ಅಲ್ಲ, connected ಏನೋ ಇದೆ?
Connected, my lord, are there certain, my learned friend appears in.
Well, let the senior finish. I'll come to you later.
Not the controversy is like this, my lord. There was an award passed which became final by the Honorable Supreme Court. In enforcement of that award, my lord, execution proceedings were filed. In the execution proceedings, my lord, the court passed an order on 28/2/25. That is, my lord, Annexure A at page 28. But that order, my lord, produces only the operative portion. We have filed a separate memo, my lord, with the detailed order. Could your lordships, my lord, permit me to show that, my lord, is filed with a memo on 20th March 25.
27th March 25?
The order is dated 28th February 25.
Memo date,
Memo
20.
is, my lord, 20th of March 25.
There is one 27th March. Memo along with documents.
Illa. This is a memo along with the order, my lord. Lord, I'll tell you, Lordships, what that was, my lord. The prayer in that application was in the executing court and IA number 69.
27th March.
Correct. That encloses the order.
Huh.
Where
Volume
he-
1 and volume 2.
No, my lord. It's a very short memo only with the order copy, my lord. Filed in court, my lord.
Ah, yes.
Yeah, thank you.
That's again 27th March.
Yes. So sorry, my lord.
Hmm.
Your lordships may see, my lord, this. Kindly go, my lord, to, I'll skip the narration of the stand and all that.
All right. Yes.
Kindly go to page 4.
Hmm.
Point number 1. It is the specific case of the applicant decree holder
Yes.
that the present execution petition is filed to execute the arbitral award passed by the arbitrator in arbitration case number so and so. Said award has attained finality. That all efforts made by the JDR to challenge the award went in vain, and the order has been confirmed by all judicial processes. The court has passed an order for attachment of several apartments based on application filed by the applicant. The JDR, instead of paying award amount, is now trying to create hurdles in execution of the award. He filed an application stating that 24 flats out of the attached 144 flats are unencumbered and they can be auctioned and sold to satisfy the award amount. This applicant is making an attempt to recover the award amount since more than 6 years, but due to the conduct of the JDR, it's become difficult for him to execute the award. That out of 144 apartments attached in this case, some of the objectors have appeared and filed claim petitions, and remaining flats are available for disposal to meet the award amount. Now, what happened was number of apartments, agreements had been entered into, and the purchasers of those flats, my lord, were put in possession. They were occupying it. So they, my lord, came and made this submission. Hence, the present application is filed praying for allowing the same. The JDR in the objection statement tried to contend that the property sought for proclamation and sale by the DHR are subject matters of attachment issued by several authorities like National Consumer Disputes Redressal Commission, Real Estate Regulatory Authority, District Commission, and Honorable High Court, and they have already been seized by those authorities. If this court orders for proclamation and sale of attached properties, it will amount to conflict to be orders to be passed by the said authorities, therefore prayed for rejecting the application. Though the JDR has referred various authorities in the objection statement and tried to contend that those authorities have passed the order of attachment of the subject matter of this application, even he has gone through the extent that above referred authorities have already been attached the flats which are subject matter of this application. But in this regard, the JDR, except raising such contention, has not produced a single piece of document. If really the properties which are subject matter of this application have already been seized and attached by the above referred authorities by their orders, the JDR being party to said proceeding ought to have produced the relevant documents except his oral contention. He has not produced a single piece of document. Moreover, the court has already passed the attachment order as per order dated 12/11/24, attaching 144 units of the flat. Till the date, the JDR has not challenged the said order. Well, factually, my lord, that's not correct. There's a writ petition filed and the writ petition entertained. It's pending also on the attachment.
Writ petition is pending?
Yes, my lord.
Which is that?
WP 6807 of 25.
Any order passed in that?
No, my lord. No order is passed yet.
No, it's yet to come up before the court?
I don't know. It has come up. It has come up, my lord, but the notices have been issued. No order has been passed.
These are the parties there?
Yes.
We'll continue tomorrow then. We'll tag this petition along with that?
That will not survive itself. It is after attachment,
Ah.
this order of sale has been done. That will not survive.
So
This
that
is the
won't-
main watch.
Let's not tag it.
No, I suggest, my lord, if it is as simple as my learned friend says, it can be disposed of. Let it come up ಅಷ್ಟೇನೆ. ಬಂದ್ರೆ ಏನಾಗುತ್ತೆ?
Dispose ಮಾಡಿ.
ಅಷ್ಟೇ.
Tag this
One more
petition.
disposal ಆಗುತ್ತೆ among the huge numbers that your lordship.
Tag this petition along with number ಕೊಡಿ. What's the number?
6807.
68 WP 6807 of
Of
2025. Tomorrow also, we'll take it at 4 PM. Yes.
My apologies, my lord, today.
buyers.
No, no, I-
Putting Lord's argument hold, before your lordships. Those are two connected matters. They have to file their application before the trial court. This
No,
is
no,
an
let,
attempt
you
to
are,
obstruct the
you
entire
are there in
proceedings.
one petition?
There's one more buyer who's not
No
there.
problem.
They are-
There
they
is
have to
one
go and-
buyer, no problem. We'll consider it. Tomorrow we'll take it. We'll continue. If the need arises that it should be tagged, we will.
Interim order to continue.
That tomorrow. This is the
ಅಲ್ಲ,
matter
commercial
tomorrow.
court ಅಲ್ಲಿ ನಾಳೆ ಇದೆ.
Huh?
ನಾಳೆ ಕಮರ್ಷಿಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆ. I
Interim
don't
order
want the
continue
court to
ಮಾಡಿ.
proceed with sale, my lord.
I'm continuing the interim order.
Sorry.
How will I not do that when I'm hearing it? What is this? Yes. Heard the learned senior counsel, this is Naganand appearing for the petition, and learned senior counsel Prabhuling Navadgi representing the respondent.
The
To-
interim order was regarding, my lord, the flats, 59 flats, which was subject matter of this case. Now, my lord, what has happened is there's an application to sell the remaining 24. Now, that is what is now before the executing court tomorrow for sale. We have filed.
Oh,
an
I have stayed the proceedings
No,
itself.
what is, please?
So, Lords,
Not state the
I'm sorry,
proceedings?
I'm sorry. Lord, this writ petition is filed challenging the order passed by the trial court ordering sale of those properties.
Correct.
Under order 21 rule 64. This honorable court, my lord, directed that the sale shall be restricted to 24 flats. That is the interim order which has been granted. That may be continued. There cannot be a further, I do not know what my learned
No,
friend
the
is.
challenge is only to that 24 flat sale
There's
or
an interim order granted by your lordships. my
Whatever
lord.
be the interim order, let it be continued. I have no objection. for that.
interim order subsisting would continue till the next date of
But
case.
in the interim order granted, your lordships, my lord, directed that 24 flats can be sold.
Correct.
Now, my lord, that those 20, the sale of those 24 flats, whether it was lawful or no, is pending before your lordships in an IAF file
No
and
problem.
before that court also.
That has to
Now,
be.
my lord, the court is proceeding to sell the remaining flats.
No, we are concerned with 24.
Yeah.
The remaining we'll see. Whatever interim order I've granted now, I will take it tomorrow.
Lord, since your
If the
lordships
matter
are
is
having-
tomorrow, you know what should be done there.
Wait.
Yes. Remaining matters, all dates will be given.
Serial number 113, my lords. It's a Waqf property, my lords. I have filed a IA for vacating, my lords. They are.
Vacating will come in vacating wait.
142 would
The
become
urgent-
infructuous,
My
my lord.
lords, the petitioner are
Infructuous, my lord.
constructing illegally, my
Vacating
lords.
stay only on Wednesdays. That according to seniority, it will come, it will be heard.
My lord.
It's
My lord.
113
Whatever
on
urgency
Wednesday,
it
my
is.
lords.
My lord, 142 would become infructuous, my lord. Serial number 142
Has become or would become?
would become infructuous. The original suit become disposed of.
Has become ಅಂತ ಹೇಳಿ.
Has become.
ಮತ್ತೆ
148.
142.
140. My lord, 142.
wait, ಒಂದು ನಿಮಿಷ ಡಿಸಿಪ್ಲಿನ್ ಇಲ್ಲ. Wait, ಕರೆದು ಬಿಡಿ ಅಲ್ಲ.
72.
1 minute. 72. Interim order ಇದೆಯಾ?
Yes, sir.
Interim order ಇದೆಯಾ? List after 2 weeks, interim order subsisting will continue till no date. Yes, next.
73 adjourned, 74.
25 matters ಅಲ್ಲ, first hold ಮುಗಿಲಿ. 74?
I appear for the petitioner in the first matter, my lords.
2 weeks, yes, next.
My lords, in the connected matter.
Interim order subsisting will continue to the next date of hearing. Yes, next. ತೊಂದ್ರೆ ಇಲ್ಲ. List the matter on 20th. Yes.
76.
Yes, next.
76.
List after 2 weeks, interim order continue ಮಾಡಿ. 77.
77.
Interim order ಇದೆಯಾ?
29th ಇದೆ trial court.
Huh?
29th trial court ಅಲ್ಲಿ matter.
List the matter on 22nd. Next.
78.
IA 25 expert interim stay date. List the matter on 22nd. Yes.
79.
Interim order ಇದೆಯಾ? Yes. 29th. Yes.
80 adjourned, 81.
My lord, respondent, my lord, we will take up on 19th, my lord. 16th ಇದೆ matter trial court ಅಲ್ಲಿ.
ಯಾವುದು?
It's 81, my lord.
Interim order ಇದೆಯಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ ಇಲ್ಲ. 90th, my lord.
List the matter on 22nd. Yes.
82.
Petition, my lord. Interim order.
List after 2 weeks. Interim order subsisting. Continue. Next.
83.
Trademark matter. 22nd. Yes. 21st Thursday tax day. 22nd will take. Yes.
Well, if it could be taken up on Monday, my lord, please.
ಯಾವುದು?
So the respondent has.
Which one?
83.
14%.
No. I'm opening for the respondent.
Respondent, all right. 14% ಯಾರು?
84.
Anyway, list on 22nd ಮಾಡಿ madam.
My lord, there is a connected matter, my lord.
In which? Oh, the 84 ಅದೇನಾ?
Yes, my
Vinay.
lord. 33.
33 and 84. Tag them both and list on 22nd.
Much obliged, my lord.
Yes, next.
My lord, I appear for the respondent in 84. I just want to know, has notice been issued in 33?
My lord, it doesn't come in the way of.
33 and 84 will be taken up together.
Together. I'm
Yes.
obliged. My lord, may direct the petitioner to serve me with the papers before the next date of hearing on.
I may dismiss
My
it
lord.
also. Why are you worried?
I'm
Yes.
most grateful. my lord.
85.
85? Interim order ಇಲ್ವಾ?
Interim order.
List after 2 weeks. IO. Next.
86.
List after 2 weeks. File an application for vacating if you want. Yes. Next. ಆಯ್ತು ಕೊಟ್ extend ಮಾಡಿದ್ದೀನಲ್ಲ. List after 2 weeks. IO. Next. First vacating stay dispose ಮಾಡೋಣ ಆಮೇಲೆ. No problems. Yes. 86. 2 weeks.
87.
Siddharth. Interim order ಇದೆಯಾ? List the matter on 22nd in preliminary hearing. Next.
88.
88 ಅಲ್ಲ.
I am for the
ನಾಳೆಗೆ ಇಲ್ವೇ ಇಲ್ಲ. Yes. List on 20th. Yes.
89.
20th ಅಲ್ಲ. ಒಂದು ನಿಮಿಷ. 22nd. List on 22nd.
Another 88, the copies are not served. I am for the respondents 1 to 5.
ಸರ್ವ್ ಮಾಡಿ ಫಸ್ಟ್. ರವೀಂದ್ರನಾಥ್ ಕಾಮತ್.
89.
No stay. 22nd. Preliminary hearing. Next. 90.
22nd, my lord. 22nd.
No interim order?
No interim.
22nd. Yes.
91.
Yes, appear for petitioner, please, lordship. 91 petitioner. There is no interim order.
91 interim order ಇಲ್ಲ ಅಂದ್ರೆ 22nd. Yes.
92.
22nd. Yes.
And for the petitioner, there is no interim order.
22nd.
94.
List after 2 weeks.
94 adjourn. 94.
Adjourn ಆಗಿದ್ಯಾ?
96. Interim order.
96?
Interim order.
ಇದು rent. List the matter on 22nd in preliminary hearing. ಇರ್ಲಿ. But rent pay ಮಾಡಿಲ್ಲ ಅಂತ. That's the allegation. On deposit of rent. Hearing on IR ಬರ್ಲಿ. Yes. Preliminary hearing ಬೇಡ and caption hearing on interlocutory. Yes.
97.
For the respondent, my lord.
Execution stay ex parte. Yes, list after 2 weeks. Interim order subsisting will continue to the next.
For vacating, my lord. Short court.
Vacating ಇದೆಯಾ?
Vacating.
List on when?
20th, my lord.
No. Don't decide the date, sir. List on 3rd. Yes. Under the caption interlocutory applications. Next.
98.
For the respondent, your lordship. It's a BBMP park, your lordship, that's taking a stay in it.
Interim order ಇದೆಯಾ?
ಇದೆ.
2 weeks. IO. Next.
Date will be given, your lordship.
File vacating stay, sir. Yes. Government. Oh, this is what I said. I'll impose costs. List the matter on 20th in preliminary hearing. Yes. 100.
100.
I am for the petitioner.
Respondent, Your Honor.
I am for the petitioner, my
matter is
lord.
disposed before the trial court.
Lordship,
The
kindly
plaint-
say in
plaint
my-
was
Disposed,
returned. Plaint was returned.
One nimsham.
Producing the memo. along
100,
with,
the learned counsel appearing for the respondent submits.
Petitioner, my lord, in view of the amendment, they have taken back the plaint and presented before the senior court.
Idantu hoಯ್ತಾ? The learned counsel appearing for the respondent submits that the plaint has been returned to be presented before the appropriate court. In that light, the present proceeding rendered infructuous disposed as having become infructuous, reserving liberty to the petitioner to avail of such remedy as is available in law. Next.
101.
Madam, time ಆಯ್ತು. ಇದು 101 ಇಂದ ಯಾವ್ಯಾವ್ದು interim order ಇಲ್ಲ ಅದೆಲ್ಲ 22nd ಹಾಕಿ, ಯಾವ್ದು interim order ಇದೆ 2 weeks.
My lord,
ಯಾವ್ದು interim order ಇದೆ 2 weeks ಹಾಕಿ.
148 ರೆಂಟ್ ಪೇ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. 148
ಯಾವ್ದು interim order ಇದೆ 2 weeks
148 ರೆಂಟ್ ಪೇ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ ಅದರಲ್ಲಿ.
123, 18th is the hearing.
My lord, 148 ರೆಂಟ್ ಪೇ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ.
There is an
1 minute.
My lord,
Wherever
148
interim orders are there, list after 2 weeks.
148 ರೆಂಟ್ ಪೇ ಮಾಡಿಲ್ಲ.
If somebody is wanting, file application seeking vacation of the interim order.
148 ರೆಂಟ್ ಪೇ ಮಾಡಿಲ್ಲ.
230 mood mat ಮತ್ತೆ.
230 mood matter.
Yes, Nagarajappa.
My lord, I am appearing for the petitioner, my lord. My lord, sorry, my lord, troubling your lordships, my lord. My physical presence may kindly be, my lord, dispensed. My lord, this is this honorable court, my lord. This honorable court, my lord, quashed the, my lord, 28-4 proceedings. Your lordship will find at page 88.
P.V. Chandrasekhar is directed to accept notice for the respondents petitioner to serve set of papers upon the aforesaid counsel. The petitioner, if in possession today, shall not be disturbed till the next date of hearing. List the matter on 9th September.
My lord, 148 ರೆಂಟ್ ಪೇ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ.
1 minute.
148 ರೆಂಟ್ ಪೇ ಮಾಡಿಲ್ಲ.
In terms of the memo.
My lord, list number 1.
Petitioner has moved the memo seeking withdrawal of the petition, disposed as withdrawn.
My lord,
ಈಗ
148.
ಯಾವುದು urgency project
148.
listen, wherever interim order is there 2 weeks ಬಿಟ್ಟು ಬರುತ್ತೆ. Wherever interim order is not there 22nd ಬರುತ್ತೆ. Beyond this clarification I cannot grant and no matter will be taken other.
ರೆಂಟ್ ಪೇ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. 148.
Madam.
ರೆಂಟ್ ಪೇ ಮಾಡಿಲ್ಲ.